in the USA, people find themselves in court.
All right, who did you say this is, Mr. Manning?
Judge, this is Mr. Barentine here on a motion to terminate court-appointed counsel.
All right, court calls cause numbers CR 25-130, 192, 193, 194, 226, and 277. This is the state versus Joseph Lee Barentine. I think we're also set for pretrial today, Mr. Manning. Let's take up pretrial.
Judge, actually, I'm sorry. It looks like we are set for pretrial on 4 of those cases. It appears on CR 25-277 that he may have been arraigned. The note is unclear, but he may have been arraigned on that at our 12-4 docket. I show it's our first setting on that.
Yeah, I showed he was arraigned 12-4 of 25.
Yeah, we arranged.
Okay, I just noted that was our first sitting. So, Judge, I guess Mr. Barentine has filed a motion on January 5th with this court in all cause numbers alleging a substantial breakdown in attorney-client relationship, as well as conflict of interest, that his interest will be best served by removal or voluntary removal of counsel, and that he freely and knowingly consents to the termination and asserts that any such denial will result in a filing of formal grievance with the state bar. It's my understanding that speaking with Mr. Barentine that he has already filed a grievance at this time, and I told him at this point I would probably agree with him in section 1. There's been a substantial breakdown in attorney-client relationship. That occurred in our last court setting when I conveyed to him the state's offer of 50 TDC for resolution of these cases. So due to the nature of the possibility of pending litigation, I'm not going to address any other aspects other than agree with Mr. Barentine that for section 2A, that there has been a substantial breakdown in the attorney-client relationship, specifically in regards to communication.
Well, I need more information than that. So you're going to expound upon what is the root cause of the breakdown of communication. Is it because you're refusing to communicate to him? Is it because he's refusing to communicate to you? Is it because there's a fundamental disagreement on trial strategy? What is the failure to communicate?
Judge, if you'd like, I'll allow my client to answer those questions.
Mr. Barentine, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Mr. Barentine, I'm going to allow you to testify for a very limited purpose of arguing your motion to terminate court-appointed counsel. I would caution you that anything that you say that could divulge any type of attorney-client privileged communications, if you say it out loud, then you've waived it. You talk about what you and Mr. Manning talk about as trial strategy, then that's waived. Okay, we're in open court here. I've admonished you, so you're free to tell me why you think the court should grant your motion to terminate Mr. Manning as your court-appointed attorney. But that's my warning to you is
yes, sir.
Not divulge what your defenses are or to divulge what you've communicated to Mr. Manning in confidence that he can't even disclose because the privilege belongs to you as the client. Do you fully understand my warning?
Yes, sir.
All right. So let me ask a few questions before I let you speak. Mr. Barentine, do you have the ability to hire your own attorney?
No, sir.
You've asked the court to find you indigent, is that correct?
Yes, sir.
The court has found you indigent and the court has provided you an attorney, Mr. Manning. Mr.
Yes, sir.
Mr. Manning's being paid by the taxpayers of Van Zandt County. You understand that?
Yes, sir.
You're not paying anything for your representation. You understand that?
Yes, sir.
Your family's not paying anything for his representation. You understand that?
Yes, sir.
You understand that Mr. Manning does not represent your family. You understand that?
Yes, sir.
Mr. Manning is not under any obligations to communicate with your family or anyone else. He represents you and you alone. Do you understand that?
Yes, sir.
All right. With that warning and me understanding what you understand, go ahead and argue your motion to terminate.
He's communicated me one time in 6 months, and that was in the very end of August. He's communicated with me only one time in 6 months. We haven't discussed any trial strategy or anything.
That's your whole reason for the motion?
When when we met in August, he's instructed to file for bond reduction and examining trial. He hasn't done any of these things, any of the things he was instructed. He hasn't come back to see me to discuss that since then. We spoke one time in August.
Okay. Is there anything else?
No, sir.
Mr. Manning, would you like to respond?
Judge, if I may, I'm just pulling up one quick thing, Judge. Yes, Judge. Just briefly, Mr. Barentine was arrested on August 15th, 2025. I was appointed shortly after that. I believe my records actually show that I visited him on September 5th of 2025. At that point in time, the charges that were pending against Mr. Barentine range from manufactured delivery, possession of controlled substance, penalty group 1, 200 grams to 400 grams, 4 grams less than 200 grams, 4 grams less than 200 grams, ag assault against public servant, unlawful possession of firearm by a felon, manufactured delivery PG3, or 4 less than 28 grams, evading arrest detention, as well as possession of marijuana less than 2 ounces. Discussed both the charges, the bonds, as well as remedies with Mr. Barentine at that point in time. And it was after that point that on September 19th, about 2 weeks later, the state first filed their indictments for aggravated assault with the public servant, both counts, and on the unlawful possession of firearm by a felon. It was later determined that they filed on October 17th, 2025, a manufactured delivery controlled substance greater than 200 grams, less than 400 grams, and subsequent indictment on November 21st of manufactured delivery over 200 grams, less than 400 grams. As I explained to Mr. Barentine in our court settings, we've had 3 court settings since on the oldest cases. As I explained to him both the arraignment process and the pretrial process, I explained to him the bond law as it applied to his unindicted cases and indicted cases, as well as the lack of credit that he would receive on any of those cases were he still being held on any single case that had not been given a bond on. It was shortly after that he made it aware that he was unhappy with my representation, and at our last court setting on September 4th, he let myself and the court know that he wished to terminate me. He filed his motion on January 5th, and at this point in time, based on the information that he provided in our conversations, as I said before, I would agree with him that I believe that at this point in time, our ability to effectively communicate and for me to represent him has been compromised beyond repair.
What is your reply or response to his allegation that the basis is that you've failed to follow instructions and only meet with him one time during the course of your representation?
Judge, I've met with him one time specifically prior to the indictments, but I have met with him each and every time he's come to court and discussed aspects of his case and provide responses to particular strategies of why it would not be in his best interest to file bond reductions on cases that have already been indicted.
What about his indication that he's instructed or requested an examining trial?
Yes, Judge. As I mentioned, the first case that was indicted was filed 2 weeks after the my first meeting and appointment to Mr. Barentine's case. As the court's aware, an examining trial is for a probable cause determination of a case prior to indictment. And so therefore, it was not applicable in those first 3 cases. Since that point in time, his attention had shifted to the bond issue, which I continue to explain to him that the law did not permit him to receive PR bonds on those particular cases. His bonds were set, by my recollection, at what I believe the court and case law would indicate are reasonable bonds, with the highest bond out of all his cases being $50,000 down to $5,000 on the misdemeanors.
All right, so Mr. Barentine, what are you wanting me to do? You're wanting me to you wanting me to terminate Mr. Manning's representation of you that you're not paying for, and you're wanting me to appoint another attorney?
If at all possible.
Who do you want me to appoint?
I'm not aware of the attorneys that we have. At this point, anyone other than Mr. Manning, our communication, anyone other than Mr. Manning.
Have you already filed a grievance on Mr. Manning?
Yes, sir, Your Honor, I have. Yes, Your Honor.
Why'd you do that?
Because his failure to take action on what he was instructed to do. I instructed him in that meeting in September to please file for the examining trial. This is prior to any indictments. I instructed him to please file for the examining trial. Please file for any bond reductions or PR bonds that are possible. This was in September. I asked him to do that before any of the indictments even came. And his lack of action has caused irreparable damage between us. We can't communicate anymore.
And why is it irreparable?
Clearly, his modus operandi is not in my best interest.
What is his modus? What is
His modus
operandi?
is clearly not in my best interest.
Well, I'm saying, what is
that is motive? That's Latin for motives. His motives are not in my best interest.
Right, and I'm saying, what are his motives?
I'm not aware of what his motives are or aren't, but he's clearly not following instruction or doing any of the things I asked him. He's not communicating with me about it. The communication in the courtroom is minimal, and it violates any client attorney privilege with everyone in the courtroom in here with us. That's not true communication.
And so you're saying he hasn't explained the law to you. He hasn't explained the bail issues to you. He hasn't done any of those things. That's what you're saying?
Not in a manner that I can fully understand. Not in the actual environment that provides a proper attorney-client privilege.
And have you been in court before, and are you in a position to know all about the attorney-client privilege and how it should function and not function?
I just know that the room full of people in here with us isn't any kind of privacy where he could really explain to me anything fully where I could understand it properly.
So your decision was then to file a grievance against his law license, rather than discussing it with him or the court. You filed.
He won't discuss. He won't communicate with me.
Did you try to?
If there was, yes, Your Honor. Yes, I have tried.
How did you do that?
I've tried to contact him, and I've had family try to contact him.
When did you try to contact him?
Multiple occasions.
How so?
On the phone, multiple times.
Okay.
I've had my family email him also, and he refuses to correspond.
And you understand he doesn't have to correspond with your family because he doesn't represent your family.
I understand that, but he does have to correspond with me, or we need to not be.
Did you email him?
How can I email him from the jail, Your Honor?
You can't email from the jail?
No, sir.
And Judge, I will agree with Mr. Barentine. For some reason, the jail system does not permit them, while they're in custody, to email their attorneys. I think that's would be a useful tool for us to have, but is not currently available. However, I would respond to Mr. Barentine, his assertion that his family has reached out and emailed me, as I have just once again reviewed my email inbox and have no emails regarding Mr. Barentine from anyone other than the court and the prosecutor's office.
All right, Mr. Barentine, want to grant your motion to terminate court-appointed attorney. And I don't know who I'm going to be able to appoint to you. I don't know if I have anyone. So you may be sitting there for quite some time without an attorney. I'll do my best, but I can't guarantee you that it'll happen soon. So
That's okay. Thank you, Your Honor. I appreciate it.
you're welcome. All right, court is going to set Mr. Barentine for pretrial on April 2nd in all cases, and also for status of court-appointed attorney. Mr. Barentine, I would implore you to reach out to your family and try to pull together your resources so that you can hire the attorney that you want, so that you can boss whoever you want to boss around at your dollar. Understand?
Yes, Your Honor.
Every day in the USA, people find themselves in court.
Judge, we have Mr. Pelosa at
Okay.
the seat.
All right, I'll call State of Kansas versus Gary Michael Pelosa. Case numbers 26 CR 25 and 26 MR 19. And actually, that's an extradition issue. So we'll take up 26 CR 25 initially, and depending on how that gets resolved, then we'll proceed on to the extradition. So if counsel would state their appearances, please.
Jerry Gear on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Gary Pelosa. Mr. Pelosa does appear from the Butler County Detention Facility. Judge, I do have an announcement to make. I have met with Mr. Pelosa. We've discussed his case. During that discussion, he did make it clear he wanted to represent himself rather than have counsel. We discussed that at length, as well as he has then thought about it longer overnight. So we've had a breakout room. We've discussed it again here today. And I can tell the court he does wish to represent himself and not have counsel. So based upon that, Judge, I'm asking the court to allow me to withdraw.
Okay, Mr. Pelosa, is that accurate?
Yes, sir. I didn't know we weren't going to be in court today. I have motions here that I don't know how to get into court because the jail don't have mailing envelopes. I thought I was going to be in court so I can give it to your clerk. And I'm going to need to ask to push this maybe forward so I can find a way to get it into the court.
Well, Mr. Pelosa, what you're discussing is one of the complications of representing yourself. What's your educational background, sir?
I've got high school and two years of broadcasting school, and I graduated broadcasting school. So I had 14 years of school, and I had 2 years of business law.
All right. Why a person has a right to represent themselves. However, it is generally not considered to be a wise decision for most. Why is it you want to represent yourself as opposed to Mr. Patterson, who's an experienced attorney in this district? And
Well, I'm going to tell you, I've advocated for prisoners in federal prison, and I have personally have gotten out 9 federal inmates myself. Also, in
well,
conjunction.
generally, that's when somebody that's advocating for them, it's because they are a federal inmate of themselves. Is that correct? For you?
No, it's not
Okay.
correct for me.
Proceed.
So I'm just asking if I can get some time forward to get these documents into the court record.
Well, what's your experience in regards to filing motions and so forth?
I have a lot of experience in it, sir.
What is the nature of your motions at this juncture?
A notice in demand. It's really a notice in demand.
For
I got evidence to bring forward. And no one's able to see. I mean, I wasn't even stopped. I was walking, but they said the registration.
Okay. Well, hold on.
I don't want to get into arguing anything.
Right.
So
Now, do you understand what sometimes what I've done and other judges do is allow a person to represent themselves, but also have standby counsel available. Would you be receptive to that procedure?
no, sir.
Is there a particular reason why?
Right, because we haven't established the court's jurisdiction just yet. Sir, I'm one of the people, and I am the beneficiary for the defendant. You are a corporate judge, and that's a corporate attorney, and I'm one of the private people of this country. So I want to represent myself.
All right. Mr. Pelosa, are you going to be requesting a trial to a jury?
Yes, I will.
Is that one of your written motions that you have?
No.
Okay, in Kansas, on a misdemeanor, law requires a person to file a written request for a jury trial. Again, on a misdemeanor offense, you're certainly entitled to that. But we set some earlier, and it looks like, well, we've got the next jury trial date is going to be February 25th. Are you going to be available and ready to go by that date? That's just a couple of weeks away, sir.
Well, I want discovery. I want the video of the officer's cam, and that's evidence in itself.
Well, and I understand that, and a certain amount of discovery is appropriate. Again, it's a lot easier with counsel, but
sir,
if you're okay, I'm going to set this matter for trial. The next date after February 28th is going to be in April, April the 8th at 9. So you could end up, remaining in jail for a good period of time. Is why I'm bringing these things up.
Okay, I'm still challenging the court's jurisdiction. I can challenge jurisdiction at any time. I mean, sir, let me ask you this question. Are you a member of the bar in good standing?
I've been a practicing judge for the last over 5 years, sir, and yes.
Okay, is the prosecutor a member of the bar in good standing?
Okay, I'm not going to go playing your games here, sir.
Well, we have a conflict of interest.
Sir, I'm going to set this matter down for hearings. Sarah, excuse me, Jen, does Judge Webster, what's her next motions date?
Are you asking about a Monday misdemeanor control or a bench trial?
No, I'm not sure how she breaks that up. You tell me, I don't know the nature of all of his motions or how long that'll take. But it wouldn't be able to go on the expedited docket.
And Judge Webster would usually hear those on a Wednesday afternoon. That's when she has evidentiary type hearings.
Okay. Jen, can you look on that and see when she has next available?
The next available is going to be March 25th at 1:30.
March 25th at 1:30. So, Mr. Pelosa, at this time, I'm going to take your motion to represent yourself under advisement. I'm going to permit you to file your motions and not have Mr. Patterson do anything on that, but you need to get your motions on file. And that is one of the issues that, frankly, there's a lot of questions that, and I don't have those in front of me in regards to a pro se defendant. But we'll set that on that March, is that March 25th at 1:30?
That is correct, Your Honor.
Okay. That's when your motions will be set. You'll need to file those. You have them ready to go now, sir?
Yes.
Okay. I want those on file by March 5.
How do I get them to you?
Well, I'm not going to explain
Okay.
how you have to do things.
Okay.
You say you know how to do all this stuff. I cannot advise you how to proceed on your case.
I'm not asking for advisement.
Yeah, you are. You're asking for procedural questions in regards to how to do it, and the court can't hold your hand and do that. That's one of the extreme disadvantages of representing yourself. So I'm judge will take those up at that time and make her decision in regards to Mr. Patterson, but I'm not going to require Mr. Patterson to do anything further on this matter. Mr. Patterson, would you be appearing on that docket as well?
Not normally, Judge, but I did put it down. If you are ordering that I continue as standby, at least for now, I put it down.
I would ask that you be there as standby right now.
I reject that. I reject that.
I know you do, and you'll get a full hearing on it. But today's not the day on that. That was not scheduled for today. So March the 25th at 1:30. That is in regards to 26 CR 25. All right. Moving on then to the 26 MR 19. Mr. Patterson, are you appointed on that case as well?
Because it is misdemeanor charges in Missouri, then yes, it does fall on my contract. But again, I've discussed that with him and he has the same position on that too.
Is that correct, Mr. Pelosa?
Yes, sir.
You'll need to file your motions and things on that. We'll set it for March 25th at 1:30 as well. So I'm going to, Mr. Patterson will be standby counsel on that as well.
I reject that. If he wants to take the consequences of it, let him so. If not, then he needs to go.
He's not asking for that, sir. I'm ordering it. So at this time, and it's going to be the same order that I just made.
What's your
You're
authority?
still going to, sir,
what's your
don't interrupt. You're still going to have the opportunity to do that. I'm not asking him to do anything on your behalf in the meantime, but you're going to need to file your motions, and that's going to be difficult from where you're sitting. So, file whatever motions that you feel is appropriate, and it'll get brought up at that time as well. Again, that's on Judge Webster's calendar. But if you're going to be requesting a jury trial on these matters, you need to get those on file as well, because that April 8th date is on the court docket coming up fairly soon. All right. Is there any other issues that we need to discuss concerning either of these cases for Mr. Pelosa? Mr. Regier?
Your Honor, if the court is continuing the bonds in both these matters, the state has nothing further.
Mr. Pelosa, anything further?
Not at this point.
All right, I'm going to continue the bond status as they currently are. Mr. Pelosa, if you do make bond, you are ordered to appear before the court on that March 25th date at 1:30. You're to be there at the courthouse. If it's a Zoom hearing, then they'll do it through court security, but you are to be present at that time. Do you understand?
What if I'm in another county extradited and I'm still in jail or something?
That's another matter. If you're, I said if you were released, if you've made bond on your various cases, then and are released, that's the order. If you're in custody, typically these matters you take care of the local matters here that you're charged with, and deal with that, and then before a person is extradited. But so that's going to make a complication for you perhaps, but that's your choice.
So if I may ask, the 26 CR 25 case, what is the 26 MR 19 case?
That's the extradition case.
Okay.
All right. It appears that on the 26th case, the bond is set at 10,000 cash assurity. So that'll continue to be the bond with the conditions that I just noted. Anything further concerning Mr. Pelosa?
Not from the state, Your Honor.
Very well. These matters are adjourned. Mr. Pelosa can be returned to lockup.
Thank you.
Every day in the USA, people find themselves in court.
Why don't you have a seat over here? And Mr. Rivera, why don't you come on up here and have a seat. So first off, I'm going to put you under oath here. And we've all worked, I don't need you to stand up. But so first, Mr. Rivera, raising your right hand, you swear to tell the truth, the whole truth, and nothing but the truth.
Yes, ma'am, I do.
All right. Mr. Welch, why don't you raise your right hand?
Yes,
Swear to tell the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Take your hat off the table. You can put it in the chair. We don't put hats on tables around here. You can keep your information. If you've got your documents or something, you can put it on the table. But I've got first a question of you, Mr. Rivera. I see you're set for trial next week. and it looks like it might be on these events that you've been charged with, and you've got an attorney in that case. Have you advised your attorney you've filed this small claims?
Yes, I have, ma'am.
Okay, so you know that you are under oath and this is a recording and it could be used against you in trial?
Absolutely, ma'am. Yes.
Okay, and you still want to go forward today?
Absolutely. Yes.
All right.
Please.
Okay, so you realize again that this could be used against you. Anything you say here can be plucked up and used by the prosecutor
Yes,
against you in that trial.
I am in complete compliance with everything.
Okay,
I'm
just
not
so you
worried.
know. So that, I just want to make sure that's your decision.
Yes.
All right, so you're ready to go to trial. Mr. Welch, you're ready to go to trial.
Yes, ma'am.
Okay, and what I've got here, and you'll notice I'm looking back and forth because everything's electronic. And so I'm looking over here to find the information that's been filed, the notice that was filed, and then I have lots of information from, get this open better. There it goes. From Mr. Welch, nothing from file, which is fine, filed by Mr. Rivera. So what I'm going to do is just turn to you, Mr. Rivera, and ask you to tell me why you think you're owed $5,000. You're asking assault, refusal of documentation, vandalism, being irate, defiant, rude. Very little of that is, yeah, that's a good reminder. Everyone turn off your phones. Your phone's off. Phone's off in the back. Okay,
Your Honor, my
that's
phone is
okay.
off right now.
It happens at least once every day. So,
The kids.
all right. So get that silent.
Sorry.
So, tell me why you think you're owed $5,000 from Mr. Welch.
Well, ma'am, on August 18th, I went to my community store. We live in Steamboat
Well,
Island.
let me slow you down. I'll get to that. But what I want to know is, what is the theory? What is it that you think you're owed money for? Just give me a capsule there. Why?
Because of the allegations that he has put against me. It's cost me to have to hire attorneys, to consult with other attorneys, because there's two matters here, a civil and a regular criminal issue.
There's another lawsuit filed other than this? There's a criminal case, there's this and another one?
I had to file against Mr.
So
Welch.
answer that question first. So there's a criminal case filed against you.
Yes, and
There's
this.
you filed this, and there isn't a third. Okay,
No,
so
there's
these
no
two,
third
that's
one.
what you mean. So you had to hire attorneys. What else?
I had to do a consultation just to get information, because when we had this,
Consultation with whom?
I have,
I'm just trying to map out what you think you're owed.
I had a consultation with, these are all my notes, Your Honor. I'm sorry. Bear with me one moment. Connolly, Tacone, and Meserve.
Okay,
And
so that's another attorney's firm. So how much are you allege that Mr. Welch owes you for attorney fees?
I'm going to leave that up to you, Your Honor.
No, you don't. You have to prove it.
Okay, I have
And you
no
have to give
problem.
me proof.
I have no problem proving.
Okay, how much?
$5,000.
Okay, so you
That's-
think that's what it is. So your claim is for attorney's fees.
My claim is for attorney's fees and for the damage that he caused to my vehicle that I caught him doing.
Okay, so your claim is for $5,000. You're asserting all of that as attorney's fees, but now you're telling me damage to a vehicle.
That's what started this whole thing. Yes, ma'am.
So you think you're owed money on that? Generally, how much is that?
My deductible was $1,000 and the damage was 700 something.
So you got paid off by an insurance company, but you spent $1,000.
To have my car fixed. That's my deductible. Yes, ma'am.
Okay, so you were out $1,000 on that.
Yeah, and
Okay.
the 700 something for the damage that he caused.
Well, but if your insurance paid for that, no, they didn't pay because your deductible was $1,000. Okay.
Yes, so I would like to have
You
my
didn't do
insurance
that at
company
all.
have their paperwork too. They're owed $291.
Oh, I see. All right.
And I would like my $1,000 back. And I would like him to pay for my attorneys and all that, because I've had to put out a lot of money just to defend myself. because he made a false police report against me. He assaulted me.
All right, well, we'll
That-
get into the facts. So now I understand what you're asking for. And we'll see if you have the proof for it. So the damage to the vehicle was about $700 some. And that's the sum total out of your pocket on the damage issue, or is
That
there
was
something
paid by
else?
the insurance.
It was.
I had to pay
Oh,
my $1,000 deductible,
okay.
and my car is fixed now.
So you paid $1,000 out of your pocket to get your car fixed.
Yes, and I can prove everything that I'm explaining to you. Yes, ma'am.
Okay, well, that's where we head next, just so we know what you're talking about. So, tell me the car damage first. Let's go there. That's a little clearer.
Ma'am, I went to our community, it's called Steamboat Island store. It's an Indian like cigarette, get cheap cigarettes there.
Yeah, you got to kind of hone in here. So one day on that day in
On August
August
18th, yes,
yep.
ma'am. I proceeded to go into the store. I parked on the side. I was illegally parked, ma'am. There's a handicap spot there, and I did not want to park in the handicap spot. There's also a restaurant and another gas station there. I was illegally parked.
And how did Mr. Welch, why is he owe you $1,000 for car damage?
Because when I came out of the door, nobody was at the cash register. I went in there. I pulled my car up. I locked it. I walked 10 feet into the door. I was in that store maybe 10 seconds, maybe 15. I walk out the exit door, and the first thing I saw was Mr. Welch.
Talk to me and stay seated.
Yes. Oh, I was just going to show you.
Don't point at Mr. Welch. I won't allow him to point or do that.
Yes,
you're going to talk to me and you're going to stay seated.
Yes, ma'am.
All right.
Yes. And when I opened the door with my hand, you know.
Which door?
The door from the store.
The store door.
Yes,
Okay.
I just got rang out for my cigarettes. And I opened up the door, and I'm sorry.
Again, look at me. You're talking
yes,
to me.
Yes, ma'am. I witnessed Mr. Welcher, who I don't know at all. He had my mirror. I thought he was going to break my mirror off my car.
Okay, which
And I
mirror?
asked him,
Which mirror?
My passenger side mirror.
Passenger side
Yes,
mirror.
ma'am.
So the way you parked, then were you near Mr. Welch's
No,
vehicle?
I was not.
So his vehicle wasn't next to yours.
No, he did park next to me, yes. And he had his door completely opened like this. And I witnessed him go like
Which
that.
door?
His driver's door.
Okay.
He had it completely opened, and he was doing that, and it was making my whole mirror turn. I thought it was going to fall off. I didn't know it could bend that way.
So on your passenger side mirror, he's describe again. He's seated in his vehicle, standing. What is he doing?
He was seated in his vehicle, and he had his arm extended and his door completely open, and he was doing this to my mirror.
It is.
And I saw him with my own eyes, and I said, "Whoa, sir, please stop.
Okay.
You're vandalizing my car." And he got so mad at me.
Right. So what was the damage to the mirror? Tell me about that.
All they did, that car is very expensive. It's a special order car.
What kind of car?
It's a super stock, Red Eye Hellcat.
Okay, I guess I don't know what that is, but it's got a
It's a
passenger side.
$135,000 car. It's a special order. I had to wait 9.5. All my cars I had.
So what was the damage?
He took my paint, my clear coat, everything right off my mirror, and he caused a big scrape, which I have pictures of.
Okay. All right. And okay. And so you attribute that to Mr. Welch, and you said you didn't know him from before. How do you know it's Mr.
I saw him do it
Welch?
with my own eyes. That's why I asked him. I needed his information for his insurance.
Okay.
And he almost knocked me off my feet, and he assaulted me.
And in what way? In what way? So now we're getting into
ma'am, I'll call it the sumo wrestler. He hit me with his tummy, and it almost sent me. I was up against the building. That's why I'm not in the camera, and the security footage
Let
of
me
the
understand.
camera.
Let me step you back. So he's seated in his car. His driver's door is wide open.
Mm-hmm.
His
Doing that on my
his
mirror.
left hand is on your rear view passenger side
So his hand is
mirror.
on his door, and his door is hitting my mirror.
Oh, okay.
Yes, he's
The
running
door is
his
hitting
door
your mirror.
into my mirror, making it trying to break off.
Okay, door in a mirror. And then how did you get close enough to him?
My car was parked right there.
Yeah.
in front of the door, in front of all the cameras at the store. And what bothers me is,
So did you come back and around behind your vehicle and then up to Mr. Welch?
no, I came right out that door. I asked him for his information. He assaulted
But
me.
his driver's door is open. How did you, and it's banging into yours, so there wouldn't be enough space for you to walk through there. Trying to understand how you got close enough to him to get.
I got in my car. He wouldn't give me any information.
So you got into your
I got
driver's.
into my car. I
Okay.
unlocked it. I grabbed my phone and I took a picture of his license plate and
So
the
how
damage.
did you get close to him though? Help me understand what you
Oh,
did.
very simple, because he closed his
Look
door.
at me.
Oh,
You're talking to
yes,
me.
yes, ma'am. He closed his door. And next thing I know, he's back at me again, standing right over me.
He
And
closes the driver's door and presumably he's outside of his vehicle.
yes.
Okay.
And he told me,
then-
and he yelled at me something about how I parked and I shouldn't park something. I don't know. I didn't catch all he said. And I didn't care because he's not the police. I was illegally parked. I'll take a ticket.
Then what did you do next? Once he
I
closes
asked
the
him for his
driver's door.
information. He didn't, he refused.
Well, where did you go? That's what I'm trying
Yes.
to figure
I
out.
went
Where
right
were
back
you?
to my car. I grabbed my phone and I took a picture of his
Where
license
did you go
plate.
though? Was this the driver's door that you entered?
No, I went all the way around into my car, all the way around to
How
the back
though?
of
What
his
door?
and-
What door did you get into your car?
driver's side.
Okay, so the driver's side door, you open up
Driver's
the
side's
door.
over here, passenger side's over here.
Right, so
His
it's the
driver's side's
other
right next to
side.
my passenger side.
Yeah.
He
so
pulled
it's
into the
other side.
handicap spot. He doesn't even have
I'm
a
trying
back.
to clarify. So you open your driver's door, you get in, you get your phone.
And I walked around out of my car to the back of both me and his vehicles.
Okay,
And I took a picture of his license plate.
okay.
And then he was already at the front by the door that I had come out of, by the front of the vehicle, his vehicle. And he assaulted me again.
Well, the first time, I'm still trying to figure out how that worked.
When
So
I asked him
where
for,
were you when you were?
the very first time I asked him for his information was when I saw him with my own two eyeballs damaging my vehicle.
You're not
I-
helping me. What
I
I'm
was in-
trying to do is you say that you come out of the store. Where was it that you say that you were assaulted?
Right there in front of that door, in front of my car.
In front of your car door?
That's correct.
Driver's car door?
No, the front of my car.
Passenger car door?
Not one of, not the
No.
car doors, the front of
The
my
front?
car.
Oh, so in
Yes.
front of the grill or whatever.
Yes,
the car- all right.
absolutely.
So you're asserting Mr. Welch walked up
Yes,
to
he
the
did.
front of your vehicle. All right.
Yes. And if
All
I had,
right.
if I had the whole tape, it would really collaborate everything that I've told my attorneys. That's why I hired attorneys.
So, all right. And so then that happens. And then what did you do? You went to your driver's door?
That's when I took my pictures after he assaulted me and I told him, please don't assault me, dude. Just give me your information, sir.
So then you went around, took a picture of
Took the
his
pictures,
vehicle
went-
license
After I
plate,
got
and
done,
then
I put
what?
my phone back in the car.
So you went
and-
back around to your driver's
Yep.
side door?
And then
Slow down, you went back around to your driver's side door, opened the door, put your phone back in there, closed your driver's door, and then where did you go?
back to the front of, well, the front of my car, the front of his. He was
Okay.
standing right there
All right,
and he did the belly thing on me again, like trying to run me over like a big sumo guy.
okay.
And the first time he did that, I weigh 130 pounds, man. That guy almost sent me
So
flying.
what damage did you have from that? What do you?
I didn't have
claiming?
no damage,
Okay, well then,
but
all right, so what proof then, let's step back to the car. What proof do you have that you are out $1,000?
oh, just my deductible.
What proof do you have other than what you're saying?
Oh, honey, I have all paperwork, Your Honor.
All right, well, what would you like me to see? It's your case. You have
I
to
would
prove
like you
it.
to see anything that you're
I'm
willing.
not going to rifle through your papers. You look through that and tell me what you think is proof that you're owed $1,000.
This is all I feel I'm owed.
Okay,
right here.
go through your papers, figure out what it is, and then we'll come get it.
Okay, it's
So,
right here. I've
all of
already done that.
Okay, so why don't you come on over here and hand that all to me, and then you'll walk me through it.
Okay,
come
now
on
I can
over.
approach it now.
Come on up, and then you'll have a seat. Come on up, hand that to me, have a seat. And then you're gonna tell me what of this is important.
Okay.
What shows that you're owed $1,000 from Mr. Welch? Got all sorts of things.
Yeah, I apologize. I'm not a good,
So I got Capital Collision Inc.
yeah,
They
that's,
say, and where did this come? All right, owner, you, Haggerty Insurance. This is from October of 25. This is alleged to have occurred August of 25. The 2022 Dodge The Hellcat. All right, claim number check. So you got a check for 291, total balance 11 or 1291. They received Capital Collision received the 291. So who paid the 1,000?
I did.
Okay.
There's a piece of paper and they're showing that I paid for the deductible and the summons of service people.
Okay, whoops. There's a piece of paper that, do you have a bank statement or a check or something?
To show.
That you paid or a credit card? How'd you
Yeah, it
pay
should
it?
be on my credit card statement right there.
Your credit card
Yeah,
statement.
it should be right there with all that stuff.
I got Cabela's. I've got.
It's on that
receipt.
Cabela's.
That's your credit card. Okay. All
I
right.
should have
Oh, I see. All
a
right.
service for $90 and $1,000 deductible or something like that on there.
Okay, Capital Collision, $1,000, November 26th. And so you're asserting that this reverts back to the August event.
Oh, yes, ma'am. Yes.
Right.
I didn't want to drive my car. I didn't even know that he had filed a police report on me until.
Slow down. I'm not asking you any questions. I don't want to get off course here. So I've got something from Capital Collision that says you paid him $1,000. They're owed $1,000. Excuse me. Your credit card statement says in November, about a month later. Yeah. You sent $1,000 to Capital Collision. No, this is your bank statement. Balance.
I have my credit card if you'd like to see my credit card.
So there's also an Enki Detweiler on this. Is it a shared account?
Yes, she has a Cabela's card and so do I.
Okay, and it's one card, one account that you're sharing. Is that why you're both
something
on it?
like that? Yeah, I don't know the exact.
Okay, Todd Rivera transactions. All right, so got that. So you sent $1,000 to Capital Collision. I know that much. And that was all right. And then I got here UPS store. Let's not.
I think that UPS is for copies that I had to make for the summons of service people.
All right, so I've got these receipts to Enki Detweiler for $2,000.
That's one of my attorney receipts there.
Okay.
For the criminal case. The criminal case I shouldn't have any of the criminal stuff in there, ma'am. It's a separate thing. I apologize if that's in there.
Okay, so, all right. And then what I got here is you think you're owed $5,000 or you from Mr. Welch. Where did you, so I take it, there's sound law here. I see $4,000 worth of receipts. Are these receipts about attorneys?
Yeah, there's another one somewhere, Your Honor. I can't locate that. Okay. I'm not worried about it.
So maybe 4,000 you have proof of.
Yeah,
maybe.
It was 5,000 for the attorney.
Okay.
But
so it says from Todd Rivera, Enki Detweiler, $2,000 by English and sound law. And so this is for what?
That is for my attorneys for my assault, fourth degree.
For the charge against you.
Yes.
Let me see. All right. And this receipt is attached to your legal services and fee amount. Let me review this. Flat fee of 4,000. So that's what these two receipts are, is the 4,000 that's indicated in the contract that you've signed with Sound Legal.
Yes, ma'am.
And so one says from Enki Detweiler, but not you. Did you pay the $2,000?
We were both there.
You're the plaintiff. So what did you pay? 2,000?
I paid the first $2,000. The second one, she gave him a check or something.
Okay.
That's why that receipt's in her name.
All right. So you have proof that you paid $2,000. Okay. To Sound Legal. And that was to hire this person for, let me see, scope. Trial, filing a pretrial motions appeal and okay. So this is all about the criminal case.
Yeah.
All right.
And
Gotcha.
it would be more.
And so you're owed that because you feel that you were falsely accused. And that the prosecutor shouldn't have filed charges against you.
No, ma'am, I'm not saying that. I did
Okay.
do to Mr. Welch what he did to me. And I asked him,
Why would he owe you legal fees for the criminal case? Help me understand that then.
well, I feel if it wasn't for him false reporting me and calling the cops on me after I left.
So you do assert that he falsely
You
reported
know, absolutely.
that
He
you assaulted
he
him.
says I assaulted him. He says all this stuff is on me, and he apparently didn't do any wrong, and that's wrong. That's why I had to go get attorneys and stuff.
Okay.
'Cause I
so
didn't
for
do
the
anything
criminal
wrong.
case. All right, because you got charged by the prosecuting attorney. All right.
Yes, and that will be
Okay.
dismissed here come March 10th.
And then you got, all right. And then the UPS, I take it the UPS store is, what's that about?
That was copies to give to the serving company.
Okay, so to get service on,
Mr. Welch,
tell
yes,
Mr.
ma'am.
Welch about today.
Yes, ma'am.
Okay. And then, all right, I understand that. And then there's kind of a list of things on a small notebook.
Yeah, I wrote that last night, right before I went to bed, just trying to get as much documentation for you as I can today, ma'am.
Okay, all right.
I
So
apologize about the penmanship there.
no, it's pretty good. All right, so Conley Tacone Reserve Consultation 250, what was that about?
That was, I don't know if that piece of paper is up there in that envelope. I think it is. That was to get, may I, come
You
up?
have something
ma'am?
else there you want me, there's nothing else in the envelope. I've
There's
already
a,
gone through
there's
everything.
a, thing from the,
Yeah.
Messina Tacoma, attorney that, oh, here it is, right here.
Okay. Why don't you hand that up too, if that's something you
I'm
think I should
sorry, Your
look
Honor.
at?
I should have given you this with that other
It's
stuff.
okay, just hand it up now and have a seat. We'll
Um,
talk all about it.
Yes, ma'am. I had to go and pay that guy for a consultation fee, if that's
So
what
this
they,
is the assessor's
um,
document.
yes,
I'm looking.
I
at
got
the
that
assessor's.
assessor's thing
Yeah,
printed by the attorney that Taconi, whatever the name is on there. That's how I was able to get the information to know about civil court and
so why do
and to
you,
file.
$250, did you pay $250 to Conley Tacon in Reserve?
Jan did. She wrote a check to him. Yes, ma'am.
So you didn't.
Well, she did then.
Okay, but that's not
Oh,
who's
that's fine.
filing this
That-
lawsuit. All right, and then, and so this is simply because, so you could figure out how to serve Mr. Welch.
Absolutely, to
Okay.
try to find out how I could go about
Got
doing the
that.
right thing, because I had everything filed against me behind my back. I didn't realize, like I said, I didn't find out till 2 days after. And then I'm already an ex-convict, ma'am, so I was really scared to drive my car.
Okay.
You know, I don't
Slow
want to
down. I haven't asked you a question, so I'm trying to map out here. So far, what I've got, you're talking about is $2,000 in attorney's fees. I'm not considering like service of notice or anything or filing fees. I'm just trying to get to the principle here. And $1,000 in damage to the vehicle. So it's looking like $3,000 potentially. All right. That you're out. Is there anything else that I'm missing? Not filing fee, not
I'm
service
just
fees.
grateful that you're here to hear the case. That means a lot to me. I'm not worried about the money. I just want my justice for my car and me.
All right. There we go. So, all right, I'm going to hand this all back to you so you can review that. Yeah, come on. Make sure, why don't you sit down and just silently kind of go through it, have a seat, make sure that everything you wanted me to know from that, I know. So just take a seat, review it all, and then look up and tell me if there's anything else, all right?
So Judge Wilcox,
Yep, Marnie?
if I may,
Sure.
my parties may want to request a continuance, so I brought them back into the courtroom.
Okay.
There are
And
some.
who?
So this is 39391.
So Danielle. Flavius. Okay.
And yeah.
Okay. So I'm just going to take that up real quick. You look at things, Mr. Rivera, but I'll come back to you. I'm just going to jump to 39391. So Ms. Flavius and Mr. Johnson, I have you both, Ms. Johnson, unmute. All right. So Ms. Flavius, Mr. Johnson, need some more time today. Set a new court date. Is that what I'm hearing, Ms. Flavius?
That's correct.
Okay, Mr. Johnson, any issue there?
Kind of. She has a 10 o'clock appointment that she has to get to, and I've set aside all day to deal with this. So
Well, okay, and I know a lot of people don't realize that they're going to spend the morning with us, maybe longer if we don't get to them, because we kind of overbook like the airline. So I'm going to grant you their continuous, Ms. Flavius, and realize that the next hearing, expect to spend at least the whole morning with us.
Absolutely, Your Honor.
It doesn't prevent you from continuing to talk to each other, to continue to use Dispute Resolution Center services, because Ms. Flavius, part of your filing fee already went to pay for Dispute Resolution Center, so you paid for them. But we're going to set that court date, and then let's see what.
It'll be April 17th.
All right, we'll be back April 17th. Ms. Flavius, any problem with that date? Mr. Johnson, any problem with that date? Look at your phones if you need to.
That's perfect for me.
Yeah, I think that'll work.
Okay, so April 17th, 8:30. Expect to spend the morning at least. And nobody needs to serve anybody notice anymore. If there's any other information that either Mr. Johnson or Ms. Flavius think you need to file with the court, get it into the court no later than April 10, the week before, so the court can review it and it can be useful. Otherwise, if it's after that, court may not look at it. So we'll see you on April 17th at 8:30.
Thank you.
Thank you.
Thanks so long.
Thank you, Your Honor.
Thanks, Marnie.
Thank you.
All right, back to Mr. Rivera. Had a little time to re-review all of your information that you file. Anything else?
No, ma'am. The only question I would have about that would be the money for my insurance company, the $291 that they had to pay out. I'd like for them to be compensated.
They would have to file their own lawsuit. Yeah, you spend out $1,000. Okay. All right. So I'm not going to turn to Mr. Welch. There's a basic thing called a prima facie case. In criminal cases, there's a basic level that has to be proved for a case to go forward. All I see from what you've shown, I'm also looking at all the exhibits that were filed by Mr. Welch, all the information filed by Mr. Welch. Now, the issue is car damage. The issue is hiring an attorney for consultation. I don't have sufficient evidence. So I'm dismissing your lawsuit against Mr. Welch. You've shown that you paid an insurance company $1,000. I have no other information. Consulting with attorneys, there is no basis that you've shown that this is for some unlawful or legal theory. And then you have to show a preponderance of the evidence, and you haven't even shown that. So that means that the claim is dismissed and the case is done. You have to meet that level before we even have to go to the other side to hear anything. Okay. So that's it today. So how about Mr. Rivera, you can be on your way. We'll get you a copy of this order and then you can be on your way. Mr. Welch, stay where you are.
Thank you so much, Donna. I appreciate your time.
You can just hand it to me. Mr. Rivera, why don't you come on over here and I'll give you a copy. That's for you. And then you can be on your way.
No more civil.
Not from this court, it's dismissed.
All right.
Right.
Thank you so much,
you can be on your way. Thanks. And then Mr. Welch, you can, so you don't have to bump into folks here in the parking lot. Feel free to stay in here or stay by security or make your decision how you want, when you want to leave. All right.
I have a copy.
Oh, yeah, of course. I'm sorry, Mr. Welch, can you do the walking? And it's a copy
May
for
I
you.
make a statement?
No, because no one's here. Best not to.
All right.
All right. Okay. So, but you can, maybe a good idea is to wait a little bit, either in here or out there with security, and make sure that you can safely make it to your car. You're welcome. All right.
Every day in the USA, people find themselves in court.
Good morning. Do we have counsel here on the Stonecipher versus Hunt case?
Yes, we do. Let me see.
There we go. Get the camera going. There we go.
Here I am.
All right.
In all my
All
glory.
right. We're gonna start. We're gonna start with the Stonecipher versus Jennifer Hunt, 25-18. Were you able to get service on the respondent?
The police attempted service on my behalf on January 29th, and that was less than 5 days. So then we requested a continuation to change the date.
Yes.
And we attempted service again. I had a private party attempt service again twice. They were unable to get anyone to answer the door. So my attorney emailed Mrs. Hunt the change of date at that point.
Well, sorry, let me correct. I didn't email her, but so Your Honor, the first service was the entire packet, but it had a notice of hearing that was a little too early. So I contacted the clerk, and the clerk contacted the court, and they issued a change of, the date. And so that's what he was, Mr. Stonecipher was talking about, that was attempted several times for personal service. So she didn't receive personal service of the change in notice, but she did receive personal service of the whole packet with the initial change of notice.
All right, and I'll just pull the courtroom as well. Is Jennifer Hunt present? Okay, it looks like she has made it to court.
Okay.
Okay. All right, I'll mark you down as here. Okay, and I want to make. I'm going to just hold this matter for a second, and I'm going to find out who else is here for the rest of the calendar, and we'll go from there. Okay, I think I'm ready to proceed with this. Ms. Hunt, I'm going to swear you in, and you can add anything in the form of testimony that you think is appropriate. Do you swear that the testimony that you give in this matter will be the truth, the whole truth, and nothing but the truth? Okay, go ahead and have a seat there. Now, keep in mind that everything you've handed me has been filed with the court, and it's part of the record, so it's not necessary for you to repeat it all. But you can, present your facts and any argument you have to support your response to the motion to extend the anti-harassment. And make sure you talk loud enough so that into the microphone there, so that Mr. Clark can hear you.
Okay. All right. It's with a mother's grieving heart that I respectfully submit my request to the courts today that the basis of this order be dismissed due to a substantial change in circumstances and the fact that the reasons and motives underlying in the original protection order are no longer applicable or relevant to the present case. By granting the request, relief for our family would be given for our healing and recovery. The substantial change in circumstances are outlined as below. My 7-year-old son's allegations of molestation with 3 people at the preschool between 2022 through 2023, and petitioner being one of the people involved. My son's conversation starting in October of 2025 is documented in the conversations with Nathaniel, and his continuing trying to talk to us is documented in my husband's January 10th document. His current diagnosis of trauma and continued therapy. My child undergoing sexually transmitted disease testing due to his allegations and continuing physical symptoms. My own suffering that I've been diagnosed with PTSD as a response to the emotional and mental anguish of this case, as in exhibit respondents' mental health appointments and clinical notes. An active and ongoing police investigation concerning the allegations stated by my son and petitioner. Our own safety concerns, because I'm part of the ACP, and me and petitioner's information is posted online as in exhibits URLs. The financial burden this has been on our family to keep up with all the aspects of the case, our counseling, medical appointments, and recovery. My own seeking out of advisors for child sexual abuse that have counseled us that our family was groomed. Due to these reasons, our family no longer feels safe with petitioner. Our son's acting out starting in 2023. Our son's recent and consistent statements concerning petitioner and attempts to talk with us, which we are in full compliance of the police to not talk with him about. Petitioner's probes of the past, when I filed a complaint with the district January 15th, and he filed the anti-harassment order January 22nd of 2025, terminating all probes. A petitioner stated fondness for my son in February of 3rd, 2025, which, but wanted me not in the picture, which caused my husband to file a no contact letter with the school district as in exhibit husband no contact letter. So from our perspective, these actions have prevented accountability for the concerns we raised and instead redirected the attention and scrutiny towards our family. Taken all together, these circumstances explain why, in contrast to a desire for being in contact with petitioner, I and my family do not feel safe any longer with petitioner and instead desire no contact. The original reasons and motives for contact were CCing on letters concerning my son's education planning, to have our family concerns addressed, which they were through the district, to show petitioner I was a kind, friendly person that he could have contact with, but I now no longer am seeking that and instead seeking therapy in order to heal and to move on. And I've accepted that petitioner did not want to reconcile and that petitioner is no longer a safe person for our family to do so. I have taken personal responsibility by both entering therapy along with accepting that it was inappropriate for me to reach out to petitioner through his home by writing a letter of forgiveness and sending gifts there to try and reconcile an issue that happened at the school. I regret any negative emotional or mental impact that my items ended up causing petitioner, and as such, wanting to relieve his distress, I reached out to the district to coordinate the picking up of those gifts. The circumstances surrounding this matter have been a learning experience for me, and I have grown from it, and I will not repeat my mistakes. Once, over the past 4 months, my actions have not been motivated by any intent to cause petitioner harm or maintain contact. Rather, this period has been focused on ensuring that I act rightly by following the guidance of both counselors and legal counsel, advocating for my autistic son and fully complying with the protection order. I want to ensure that I could report what my son had communicated while also providing him with every available avenue and resource for his healing and recovery. I requested a modification, not a termination, because my concern had to do with the third-party contact part of the clause. Concerning legal fees, petitioner already requested the court award respondent to cover them, but they were denied at the hearing to modify on 12/8. In closing, I do not want, need, or desire any contact with petitioner and simply wish for peace between our two families so we can move forward and heal without the financial burden of a protection order impeding my family's ability to become financially stable and ongoing, and no longer desire to have ongoing legal matters with petitioner. I am fully aware that if Mr. Stonecipher were to feel unsafe and contacted or harassed, that he would have the right to get another protection order, and I accept and heed that warning. For the reasons stated in this declaration and its attachments, I respectfully request that this court find a substantial change in circumstances as required by RCW 7.105.500 and not renew the protection order that was set forth to expire on 2/8/26. I have not engaged in and will not engage in any acts of contact or harassment of petitioner. Thank you, Your Honor.
Thank you. Okay. Now, I said at the beginning,
Mhm.
and I'll sort of reframe it, that procedurally, the motion to renew or extend is operating in a set of assumptions that are different from when the case is initially filed. The set of assumptions, so to speak, or presumptions are that the court would extend the order unless the respondent, and that in this case you, Ms. Hunt, carries a certain burden. And so pursuant to that procedure, which is outlined in RCW 7.105.405, the motion has been filed by Mr. Stonecipher to extend. The court has set the hearing. You have responded. The petitioner bears no burden of proving that he is under any current or reasonable fear of harm by the respondent. But the respondent, in this case you, Ms. Hunt, have to show to the court or prove to the court by a preponderance of the evidence that acts of harassment, unlawful harassment, will not occur. That's under subsection 4E of the statute. The respondent has to prove to the court that the respondent will not resume harassment of the petitioner when the order expires. I've listened to your statements regarding that. I've reviewed the court file for the prior procedural history of this case. I've reviewed the documents that you filed in support of your request that the order not be extended. Listen to your testimony and summary as to the reasons that you believe that it should not be. Now, based on those statements that you've made and the evidence that you've submitted, I do not find by a preponderance of the evidence that acts of unlawful harassment are unlikely to continue. I don't find that that burden has even come close to being met. There is, based on your statements and your characterization of the underlying reasons that this order was issued in the first place, the court does not believe that you have changed your approach with regard to Mr. Stonecipher, that your understanding of the I guess characterizing it as the wrongful conduct that led to the issuance of the order does not give the court confidence that you will modify your future behavior in the absence of an order by the court that you have no contact with Mr. Stonecipher. Therefore, the court will grant the extension requested by Mr. Stonecipher. The previously issued anti-harassment order will be extended. The court will extend that order on the same terms and conditions under which it currently exists for an additional 5 years.
And Your Honor, will you be ruling on the request for fees, costs and fees?
You did make a request for fees, and I'm going to ask you to stand by on that. All right, I've composed a written order extending the provisions of that anti-harassment order to February 9th of 2031, which is 5 years from today. All right, and Mr. Clark, on the issue of your request for fees and costs, I'm looking in the file and you can point me to it. I don't see it. Any breakdown of the fees and costs to this point?
Yeah, that's correct. I haven't submitted anything at this point. You know, I mean, it's not that much. It's like just for this action itself, it's like $755. I don't know if Mr. Stonecipher is ever going to really bother to try to collect on it, but you know, I suppose as maybe a moral victory.
Well, I mean, to be completely upfront with you on that, I know that the statute does provide for the ability of petitioners to get an award of attorney's fees, and but I'm really reluctant to do that in this type of case because of the sort of chilling effect that can have on people who are either genuinely bringing or people who are genuinely responding to requests for orders.
Yeah, that makes
there may be
sense.
exceptions to that in cases where people are clearly, you know, acting in an abusive way or in bad faith and attempting to inflict costs on the other side, which, you know, is certainly a different matter.
Understood.
Yeah, I think I'm going to just forego the attorney's fees issue and leave it lie. So at this point, given what I have in front of me here today, I'm going to deny the request for attorney's fees.
Okay. All right. Thank you for addressing it.
All right, Ms. Hunt, I have a copy here of the order that the court just issued extending that anti-harassment order. That's for you.
I make a
Right there. Yeah, on the clerk's bench there. And you are good to go. All right, Mr. Clark, Mr. Stonecipher, thank you.
Thank you, Your Honor. All right. Bye-bye.
Good, thanks. Granite Valley versus Ronald Allen Bodges, 260001.
John Capitano, P61901, during a behalf of plaintiff Granite Valley.
Your name, Mr. Bodges?
Vargas.
Now you didn't have any alcohol today, right?
Sure.
You sure? All right, what do we got here?
All right, Your Honor, this is just cause termination.
Yeah.
Mr. Bodges, back in November, I believe it was November 1st, he assaulted 2 residents at the community. This isn't the first time either. This has been an ongoing issue. I mean, I have police reports dating back from, gosh, you know, I have one from December 24. I have trespass.
Is that the serious case that's pending as a felony?
Yes, this is the one where one count is assault with intent to do great bodily harm less than murder or by strangulation. Count 2, assault with dangerous weapon, felonious assault. Count 3, assault with dangerous weapon, felonious assault. And last but not least, habitual offender. 4th offense, notice mandatory 25 seconds. Your Honor, the community is tired of having SWAT teams come over. Residents are complaining. It's unfair to the residents. We asked the court to terminate the residency of Mr. Bodges.
Mr. Bodges? Yeah. Do you have anything to say?
Well, he just said I saw 2 people I know. Remember, there's only one person there. He tried to assault me in my own home. He got his ass whooped.
Hang on, don't talk like that. It's a courtroom.
Anyways, he got beat up. Want to pick me out for that. I said, it's self-defense, Mom. I got a court date. For all these charges that he read. Most of them not even there. He don't know what he's talking about. And so I'm gonna beat that case, Your Honor. I need to go March 7th to beat that case.
This is you rent, correct?
What we're trying to rent a lot. Suzanne wants my home.
No, Suzanne does not want his home. Suzanne wants to have a community member who doesn't disrupt the quiet, peaceful.
No, I know, I get it, Mr. Capitan, but here's the problem Mike got right now. I don't want to be asking him a bunch of questions. He's got the right to remain silent. I don't know whether he intends, don't say anything, Mr. Bodges. I don't know whether he intends to say anything or not, or testify or not. Is that March 7th trial or is that March 7th pre-trial?
Might be pre-trial or trial. For sure. I think the guy's got to show up there. Right there.
This isn't even about Mr. Mr. Bogdan. I'm sorry, I'm speaking.
Hang on.
This isn't even about Mr. I'm speaking, sir.
Mr. Bodges, settle down. Before you go anywhere, Jennifer Wiseman, would you do me a
Yes, Your
favor,
Honor.
please, or Jennifer McLose? Would you call Amy and ask her to check and see what that case is scheduled for, please?
Judge, I'm pulling up Third Circuit's website right now and looking to see if I can.
Good. All right, go ahead, Counsel.
Well, I was going to say, Your Honor, whether or not Mr. Bias gets convicted of this or not, what we have here is a disruption in the community. This has been ongoing. This isn't even it's not even the first time. Obviously, I've told Your Honor I have about 7-8 reports here throughout the years since 2022. This is an ongoing issue. It's not even about him being convicted. It's about having the disruptions, having the police presence in the community. I mean, he just admitted that he was in a fist fight right at his house. So I think that that's enough to provide for cause for termination. I mean, I'll take judicial notice of.
What if he's acquitted of it?
Well, if he's acquitted, it doesn't matter.
Wait a minute.
This is a civil case. I mean, if you take a look at it,
You're alleging that he physically assaulted another resident of the community with a baseball bat. That's what your allegation says.
My allegation is that he was arrested in November.
Well, that's what I'm reading off of your notice to quit here.
Yes. Yeah, that he assaulted another resident. That's correct, with a baseball bat. Whether or not it was self-defense or not, what we have here is Mr. Bogus telling the court, hey, I was in a fist fight. He admitted it. He spoke. I did. So I think what we have before the court is we have November 3rd.
The law is not an ass, you know? If this was truly self-defense, I'm not saying it was. I'm not saying it wasn't. I'm in a pickle because I'm not going to be asking him questions today. That's not fair. That's not appropriate for a judge to be asking a defendant questions regarding a criminal case that he has pending because he has the right to remain silent. It's not appropriate. It's not something I'm going to do. In fact, I don't know how I'm going to, and listen, Mr. Bodges is not high on my totem pole here. I mean, he shows up to court drunk. He was on there yelling F this, whatever, on Zoom here a couple of weeks ago. So this is not about me thinking that Mr. Bodges should be in the church choir. That's not what I'm talking about. I still have a function, a responsibility, and I'm not going to breach that by throwing this guy out without a hearing. I'm not going to breach that by assuming that he is going to be convicted. I'm not doing it. I'm just not doing it. I'll be glad to. Have you figured out what that is, Jennifer?
Yes, Your Honor. So it looks like there's a final settlement February, or a final conference on 2/19 and a jury trial on March 4th.
Okay, good. Then we're going to adjourn it to right after. I doubt it's going to settle based on what he said. If it does, I'll be glad if you find that out, Mr. Capitan, to call the court and say, ask the judge to give us an earlier hearing. But I'm going to be gone on the 4th, I believe, right? Or the 5th. So we're going to have to do it when I get back.
Right, I know you have vacation because there's another case where we're going to go out to a property. Yeah, you have vacation.
Right. So I can do it like, what day am I coming back? I don't even know.
You'll be back on this for the 16th.
Yeah.
Well, then let's do the 16th, okay? 16th of March.
Judge, do you want it later in the morning if you're gonna have testimony possibly?
And also,
Like 10:30?
Yeah.
Isn't it the day that you're going out to another property?
I don't know.
Yeah, pretty sure.
Is it?
Because it's my property.
What time?
I thought it was, gosh,
Early.
it was like
Early?
8:30, yeah.
I'm gonna know what the jury verdict is that day. I don't know if I'm gonna need testimony. March 16th at 11. Let's do 11 o'clock in the morning.
Okay, Your Honor.
But I don't want you to have to sit around here too much either. Do you know what time that is? Are you going out to meet me is the point, counsel?
Yes. Yeah,
Do you know what time that is?
yeah, it's like 8:30.
Well, then let's make this 10:15. How's that? Time we get out there and look and come back.
So that's also another.
All right, that's what I'll do on that. Thank you. You understand everything that's going on? No, March 16th at 10:15. March 16th at 10:15, the day before St. Patrick's Day. March 16th at 10:15. Good luck. We'll see you here then. Owners Management versus Justice Spicer 2-5-0-2-4-3.
Good morning, Your Honor.
0-2-4-2-3.
Good morning, Your Honor. Attorney David Lechner on behalf of Owners Management.
What do we do on this?
Your Honor, this is I filed in December. Ms. Spicer and the parties agreed to a probationary period back in I want to say October of last year, and it was our contention that Ms. Spicer violated the terms of her lease in December. I filed a motion to reinstate the case. We then withdrew that motion. On December 22nd, we had a hearing. I withdrew the motion at that time. What I did do at that time, though, was I put on the record, because I spoke with Ms. Spicer, and there was some confusion. One of the issues was that there was a unapproved animal on the premises. She said it wasn't hers. But I told her that it doesn't matter who owns the dog. You can't have an animal that's not approved in the unit. But we withdrew the motion at that time. I also put on the record that any further violations of the record, however severe or trivial, was going to trigger what we're doing today. And 7 days later, the allegation is that she violated the lease. So we filed this. I spoke with Ms. Spicer last week. We couldn't come to a resolution, so I think we need to set this for a trial.
Can I speak?
Hang on one second.
No.
I'm gonna need the conditional dismissal. Do we have it down there somewhere
Judge, I
handy,
was just
Jen?
pulling up the file cabinet. I can print.
Yeah, I'm gonna need you to. I'm
Okay,
sorry.
no problem. No, not a problem. Just give me a minute.
Take your time. What is the allegation? What did she violate allegedly?
The allegation in right now is that she left garbage on the ground outside the dumpster, violating section 10B3 of the lease. And since that time, since I filed this, it's come to my attention that she has also had a unapproved resident in the unit with her, which would be brought up at the time of the trial. That wasn't in my filing on this. but we have photographic evidence of garbage outside the dumpster ripped open. With
Did somebody see her put it there?
not I don't know that. But there was mail in the garbage to her address. That's how it was determined that it was her garbage.
She put garbage outside the dumpster.
Yes, Your Honor.
I'm asking you.
Yeah. Can I explain the situation?
Yeah, I want to hear it.
Listen, so I haven't even been at my house. I've made it clear to Walnut Creek, the person in my house was my ex-boyfriend that I allowed to come over. And he never left, basically. It's a whole domestic situation. He put that trash there because he's been at my house, but that's beside the point.
Aren't you living there anymore?
I still live there, but I haven't been there in like a couple weeks.
Where you been?
I've been at my cousin's house.
Doing what?
Literally, I was told not to go home by Flat Rock police because my ex-boyfriend, he's making threats to me, saying that he's gonna kill me, he's gonna do this, he's gonna hurt my son, do all this. I have police reports that I turned into Crystal. I've been begging her for over a month to move my apartment, scared for my life, not even going back to my own house. And instead of moving my—
Who is this guy?
my safety,
Slow down.
they want
Slow down. Slow down. Why are you talking over me? When I tell you to slow down.
I'm really upset.
Who is
Picking up.
ma'am? Who is this character?
His name's Richard
Richard what?
Hollyburn, and he has a court case here in a few days for breaking my business ribs. And I've been telling you—
Slow down. Slow down. Ma'am, I'm gonna cut you off here if you don't. You're not gonna interrupt me now. I'm gonna help you, but you gotta listen, and you can't interrupt me, okay? All right? When did this guy start to come to your house?
Christmas time, and every time I call the cops would say he's been there more than 3 days, we have to evict him. So I've been trying—
How long has he been there?
Since like I said, around Christmas time.
So he's been there for December and January?
Yeah, and I've left my house. And I've came, like, every time— I haven't even been in my house like that. Every time I've come back, I had to bring the police there to escort me in to get stuff. Every single time that I call the cops. Oh, okay. You have to evict him. You can't make him leave. He's been there a couple days. Hello. And when I tell Crystal, I've been telling Crystal about the situation. The lady at the office, she's not any help. Any help at all. They just want to kick me out instead of helping. He's at my house now.
Wait a minute. Slow down. He's not there now?
No, he's finally out of my house. Finally out of my house, but I still haven't been there because Walnut Creek just a few days ago, they came to my house with an electrician and he left the door unlocked.
Let's slow down. Let's just slow down. Did he give you the key then?
No, my key's locked inside of my house. Walnut Creek locked my door because when he left it unlocked. So I haven't even been able to get in my house over the weekend or anything. I had to borrow clothes.
Ma'am, just slow down. I help you. Promise. Why'd you let this guy in the house to begin?
I didn't even know him like that.
I can't hear you.
I didn't know that, and you start, talking and
How long have you known this guy?
not even very long.
I don't know what that means. Not even very long. Some people.
Like in October.
And did you invite him to live in your house?
No.
Has he vacated the property? Does he have any of his clothes there, to your knowledge? Well, as far as I'm concerned, he's vacated, and I don't see any reason why she can't go back. If he left the property, he's got nothing there. How long's he been gone?
He just left 5 days ago.
Mr. Lechner, this seems a bit trivial to me, okay?
Your Honor, I don't, sorry.
Police reports and everything.
I mean, I'm sorry, but Trying to
Your
evict
Honor,
somebody because they left some rubbish outside the dumpster seems like about as trivial as anything. Now, I don't know what's going on there, but I believe this young lady. She looks like she's frightened to death. You got to be careful who you're inviting to stay with you.
Your Honor, if I may, I agree that it is trivial, and if it was just this, if it was just a garbage situation, we wouldn't be here. But the original situation that we were going to trial on in October was because Miss Spicer damaged someone else's property, a car, and then chased after I believe, damaged a car.
Hanging out with the wrong people.
And Your
Okay.
Honor, just furthermore, I'm looking at a police report and I realize it's not evidence. But this police report is dated from December 23rd of last year, a day after we were last in front of you. And according to the police officer, it said, according to this report, it says, upon arrival, Officer McCardle spoke with Justice Marie Spicer. Spicer stated Richard Antonio Halliburton was living with her for 2 months. So according to her statement to the police over 6 weeks ago, Mr. Halliburton had been living there for 2 months already, and he was
Is that true, ma'am?
That is true that I told the cop that, but I gave him a rough estimate because I was going through a bunch of
Slow
stuff.
down. You said you met the guy in October. When did he move in with you?
Around Christmas is when he came to my house.
Just showed up at the door one day?
And he got out and he stayed 2 days and then he started acting weird. We got into it.
You gotta be careful who you're hanging out with.
I didn't know that you guys were. I messed up.
Well, why would you invite somebody to live with you if you don't know the
I didn't
dude?
invite him to live with me. I did not invite him to live with me. I promise you that. He would not leave. He's psycho. If you've seen all the police reports, you would understand what I was dealing with. Like, not even like.
Your Honor, I have a voluntary statement written by Miss Spicer in her own handwriting dated 12/23/25 that says, me and my boyfriend were arguing and he threatened to put hands on me, so I ran out of my apartment with my son, and then he launched a water at me and hit my son in the leg. Below that says, I do not wish to press charges, I just want to be left alone. If Miss Spicer pressed charges, there would have been a no contact order, and Mr. Halliburton would have been precluded from being at the property. He shouldn't have been at the property anyways because he wasn't an approved resident.
Well, I get it. Okay, let's try to fix this for a second. I'm not evicting her for not because some yokel out there that happened to take over a property left rubbish outside the dumpster. Come on. I'm not doing that. I'm not doing that. Let's figure out how we're getting this young lady back into the unit. So let me do this. Where's the manager of Owner's Management?
I can have him zoom. No, Your Honor. I expected that we wouldn't reach a resolution today and we would set this for a hearing.
Have him zoom in. Let me go
Yes,
on and
sir.
take Ms. Collins. I will zoom him in and we'll go from there. Have a seat at the table there, Ms. Spicer. Stay seated, please.
Go to the back session.
All right, back on record on Owner's Management. Sorry, everybody. Versus Spicer. 2502433. All right, Mr. Lechner.
Yeah, David Lechner. Yes, Your Honor. David Lechner on behalf of Owner's Management.
Ms. Spicer.
Thank you.
Where's the manager?
We have
Oh, there she
Crystal
is.
Larson. Yes.
All right, ma'am, your name?
Crystal Larson.
Your name?
Justice Spicer.
I want to make sure she gets entry into the property again. The guy has vacated the property, she tells me. He has no clothes. He left the place. He doesn't have a key, right? He doesn't have a key. So can we just, to begin with, change the locks and get her back into the property?
Your Honor, I think we're glossing over the fact that she had a unapproved resident for over 2 months, where the lease calls for people that aren't on the lease, that are unapproved visitors, can only be there for 1 month over the course of a year and not for more than 14 days straight.
What I'm telling you is, I'm gonna set this for a hearing.
Okay, understood.
Want her
I'm
to be
sorry.
able to get back into the property in the interim without fear of this guy coming back. I'm not evicting somebody over rubbish. I'm telling you, let's not be silly. He's not there anymore. I don't mind telling you, you're probably gonna lose that, but young lady, listen to me. I'll give you your hearing, Mr. Lechner.
Thank you, Your
You can't fail to comply with the rules. No, I don't think you do. That you have rules. If you want to make your own rules, buy a house out in a farm where nobody's 17 miles from you. You can yell and scream, play music as loud as you want, and do whatever else you want. You can bring in 13 people to live with you if you want. You can bring dogs and cats and goats for all I care. You can't let people in there. You can't let people in there. Ms. Larson, are you going to assist her? Can you change the lock so this guy doesn't come back that seems to be maybe somebody that's not going to join the church choir anytime soon?
Yes, Your Honor, we can do that.
Well, let's do that and let's set it for hearing, but
That guy, the one illegal.
you guys are telling me, Mr. Lechner, this was over garbage is what you first said, right?
Well, this from December 29th, yes, was over garbage that was not put into the dumpster, but was left outside the dumpster in violation of the lease. But since then, I've become aware in preparing for today's hearing that Ms. Spicer has had an unapproved guest for over 2 months in the unit.
She didn't say that to me. Sounds like he was more of an uninvited guest after the initial time, but why you would invite him there, I don't know.
Well,
You invite
according
him
to the
live with
police,
you, man?
I invited him to come over his company because I thought we were allowed to have guests, and he got crazy and wouldn't leave my house. I didn't know what.
You got to be careful who you're hanging with. You know what I mean? I was just at a court to school program telling kids that are 17 and 18 and 16 the very thing I'm telling you. How old are you?
23.
You're 23. You're far past the age at which you should have figured this out. You want to hang out with the bums, they're gonna treat you like garbage. You follow me? Get her back in there. I'll set this for hearing. If you're gonna bring up something else besides garbage, you might win, but I don't think so. I'll set this up for hearing in a month. We'll see how everything's going. I'm gonna be gone. Why don't you give me the 16th of March, Jennifer?
Okay, Your Honor.
can we make that an afternoon hearing, Your Honor?
Yeah, we'll do that at 1.
Thank you.
Okay? 1 o'clock. Thank you.
Thank you, Your Honor.
Ma'am, comply with rules. You have rules. No,
Trying.
you're not trying.
Just come get me when you're ready.
If you're trying or not. But you got to comply with the rules or else you're just inviting them to bug you. You know? You just are.
But the problems are where I think I should be doing.
Well, stop inviting people over that are the type that you just described to me.
I agree.
All right, good luck. You
And
gotta
Judge, that's
grow up,
March
young-
16th, correct?
Yeah, March 16th at 1. You
Okay.
got to grow up a little, young lady. Attorney of Properties versus Terry Crosswhite, 2600352. Who's here for Attorney of Crosswhite?
Good morning, Your Honor. Sam Drabble for the plaintiff in this matter.
Is Terry Crosswhite here?
No, Your Honor, defendant had not checked in with us.
All right, you paid for a second mailing, right, Mr. Jarbo? You can go ahead and take a default.
Thank you, Your Honor. Would you like those terms on the record?
Yes, please.
Your Honor, rent to retain in this matter is $22,000. Total late fees are $750, along with
Hang on a second. Hang on. $22,000?
Yes, yeah, it's a mighty amount from.
This is a commercial property, right?
I believe, Your Honor, this is actually a residential property.
Okay, I limit late fees, I guess, to $75 a month. Are they exceeding that?
No, Your Honor, it's $75 a month. This is a arrearage since May of 2025.
I hope if I ever have money problems, I hope I rent with the attorney. You know that? How much you have in late fees, did you say?
10 months, $750, Your Honor.
What, and you have costs of what?
Court costs, Your Honor, of $178.
So you got what? $22,928, right?
That's correct, Your Honor.
And the writ date I'm gonna give you, why'd they wait so long?
Your Honor, I don't know. I'm not sure. I guess he was trying to work it out with his client, with his tenant, but that's the same question I asked him.
Default judgment writ date will be February the 19th. If you can submit that like in the next hour, that would be really helpful to me, okay?
Yeah, will do, Your Honor. Thank you.
Best of luck. Ali Saad versus Ronald Henderson and Gina Henderson. 2600256. Where's Ali Saad? Ali Saad, I need your name. You got to start your video. There you go. Your name? You have to unmute.
Ali Saad.
Mr. Henderson, your name?
Ronald Ray Henderson, Your Honor.
Mrs. Henderson, your name?
Gina Henderson, Your Honor.
All right, I adjourn this for you. What is you want to give me a breakdown, Mr. Saad, as to how much is owed?
It's termination, no lease.
Oh, it's just for termination.
Termination, no lease.
Why shouldn't you have to leave?
I'm sorry?
I'm asking the Hendersons why they shouldn't have to leave.
How you doing, Your Honor? We applied for help to move, Your Honor, and we did file that information. I was hurt during the last 2 months, Your Honor, and so we really didn't get any mail or anything. The only way I found out we had court on February the 2nd, I called in on that morning and found out we had a court date, and that's why Mrs. Henderson wasn't present that day. We haven't been served any paperwork, anything, Your Honor.
You got a notice to quit here, and he filed a complaint. I don't know what to tell you. You don't have a defense, it doesn't sound like.
Well, we do, Your Honor. Go ahead.
Well,
yes, Your Honor. So for some reason, we haven't been receiving, I go to our mailbox, our mail has been gone, taken out of it. I've filed a report with the post office. Our packages that were delivered for Christmas have been stolen. We haven't been getting paperwork from the state of Michigan. I did find a couple things on Mr. Ali's front porch.
it's not going to work with me, folks. He's posted it. He filed a complaint. You've known about it. It's the month-to-month lease.
Posted it where, sir?
We never received it.
Writ date will be February the 19th.
I'm sorry?
You have to be out by the 19th of February. 19th of February. Mr. Saad, I need your judgment today, okay? Thank you. Good luck.
Can we please speak with legal aid?
No, there's nothing to speak with. I gave you that chance last time.
She wasn't there,
folks. Mr. Henderson, I don't know what it is. I don't know what it is, sir. You're in here a lot as a litigant, and I'm not gonna. No, February 19th, you have to be out.
Sir, you never let us talk to legal aid.
Sir.
We're not allowed to speak with legal aid, Your Honor?
You lose. You were here last time. I'm not giving you any more time.
She wasn't there, Your Honor.
I was unaware.
I'm not giving you any more time. February 19th. Stop it, folks. Good luck. Thank you.
Every day in the USA, people find themselves in court.
Let's call the case of Pliska v. Latier. Mr. Engelson, good afternoon, sir.
Good afternoon, Your Honor. Thank you for permitting me to attend in this fashion.
All right, so we have up next Pliska v. Latier, file 25-9181CK. We have plaintiff, Mr. Pliska, present in the courtroom. His attorney, Mr. Engelson, is appearing by Zoom video. We have counsel for defendant. We have a defendant, Ms. Latier, present in the courtroom, as well as her attorney, Mr. Mark Connolly. Good afternoon, everybody. And this is, we're here for, we had a pretrial noticed up, but also there's a motion for summary disposition that the defendant has filed, and the plaintiff has filed a response, essentially acknowledging the deficiency of the complaint as the unrepresented plaintiff had filed it, and pleading with the court for an opportunity to amend it to come into compliance with the court rules. So given that background, Mr. Connolly, go ahead and argue your position.
Thank you, Your Honor. As noted throughout my motion, as it stands, the plaintiff's complaint comes nowhere near the requirements under the court rules that would show that it is sufficient for pleadings in the state of Michigan. I think that is clear. I don't need to go through that in its entirety in terms of looking at it on its face. For those reasons alone, the complaint should be dismissed. But as the court, I know, has read through my motion in brief, even if the plaintiff was given an opportunity to amend the complaint, the facts that were to come out in this case would still not amount to a claim of action. As noted, and I know as the court is well aware, this case comes because of a long meretricious relationship between the parties. There was never a marriage, never anything in writing to establish the claims that Mr. Pliska brings before the court. And as I noted, but what I wanted to certainly stress today in terms of what the Michigan case law says in regards to meretricious relationships, of course, its basis is because back in 1957, the state abolished common law marriages. So in order for a party to be to prevail in a complaint against their prior boyfriend, girlfriend, whatever label, they have to show independent additional consideration, whether that be expressed or implied, in order to do so. And it makes sense. The law does not allow for scorned lovers who didn't take the opportunity to get married to come and clog up the court systems with something exactly like what Mr. Pliska has filed before the court. And you can't use quantum merit arguments or unjust enrichment arguments either, which also makes sense, because you have to be able to show that at the time the alleged work that Mr. Pliska is alleging he needs to be paid for, at the time he was doing it, he expected to be paid. And at the time he was doing the work and expecting to be paid, my client, Ms. Latier, knew of this independent agreement and was expecting to pay him. And that there's no facts, this record will never develop in a way to show that that was ever the case. As we went through and noted in the affidavit that Ms. Latier signed and we attached to our brief, I mean, we're going through all of these thieves of metal roofing, windows and doors, insulation, electrical wiring, drywall, plumbing. Those are not thieves, as Mr. Pliska wrote. Those were materials that were bought solely by Ms. Latier and put into her home. And again, then he gets into what apparently would amount to contracts that were breached by Ms. Latier, but there's nothing that will show that that was ever the case. And now, since we filed my motion back in the beginning of January, and Mr. Pliska hired Mr. Engelson, and they responded. They didn't respond with any of these potential arguments or excuse me, agreements that would help their position. Because again, that just goes to show that there are none, and if this case is allowed to proceed, none will be shown later on down the road. So essentially then, Mr. Engelson's asking the court under 2.118 to amend, obviously after the 14-day by right, so asking for leave. And I know the court is well aware of what the case law says when asking for that justice must require that be allowed. And clearly this is not one of those situations. This is clearly a futile attempt. According to the case Ganya v. Motor Parts Federal Credit Union 192 Mishap 74 on page 78, an amendment is futile where ignoring the substantive merits of the claim, it is legally insufficient on its face. That's precisely what we have here. And Mr. Pliska should not be allowed to use the court system, our civil system in this manner. And he should know that going and filing a complaint that looks like this has consequences. And those consequences are that he doesn't get to come back later and try to clean it up. He doesn't get to come back later and throw more things at the wall to see what sticks. Because ultimately the only person that's literally paying is Ms. Latier. As noted, I know there's quite a lot of different arguments that I've made, different requests that I've made, but again, this case should be nipped in the bud right now. It should be dismissed with prejudice. It should be deemed frivolous by the court, and Mr. Pliska should be on the hook to pay for Ms. Latier's costs and attorney's fees.
Can I ask you, in terms of, I mean, as I understand it, Mr. Engelson is relying on the rule, not so much of leave to amend, the normal leave to amend, but the summary disposition rule that says if I agree with you, as seems everybody agrees, that the complaint as filed was inadequate and summary disposition should issue. The court rule does say that if I'm going to enter summary disposition, I should allow the party against whom that's entering an opportunity to amend the pleadings, unless doing so would be futile. And what am I to make of the fact I'm sympathetic to your arguments that the claims for an interest in the property are at best going to be a stretch and a very difficult burden for Mr. Pliska. But Mr. Engelson's response also says he wants to press claims for a return of items of personal property, almost like a claim and delivery. I mean, that wouldn't be futile, would it, to allow for that?
Your Honor, thank you. And I apologize. I meant to address that too. I've already acknowledged that with Mr. Engelson. I've talked to him about that. I don't think that there's much. I know Ms. Latier has certainly said that there's a couple of items. She doesn't want that stuff at her house. Those are certainly things that we can do outside of the litigation realm to get him his stuff back. It's not much, but certainly, again, she doesn't want it at her home, and that can be done so without this process and without Ms. Latier having to spend thousands of dollars in attorney's fees to do so. But yeah, but honestly, I was slightly confused by some of the response in that the real property, again, that's just, that ship has sailed. The law is very clear on that. Proceeds divided, that's not allowable. That's not what the law says. They were never married. But anything in regards to personal property, I just don't want the court to allow amendment just for that without some sort of severe sanction or, very precise language on it, because again, she's had to spend a lot of money and then will continue to have to spend a lot of money on what I certainly see as a frivolous claim.
All right, thank you, Mr. Connolly. Mr. Ingleson, what's your response here?
Briefly, Your Honor, the affidavit we filed it has components contrary to the affidavit filed and the pleadings filed by counsel. Whether it's a claim and
Hang on a second. Hang on a second. Hang on, you're breaking up. We're not getting a great connection here.
Sorry.
Maybe go slower.
You hear me now?
Yeah, I think we might do best if you go slowly.
I'll back up to the beginning. First of all, our response included an affidavit in opposition to the affidavit of the defendant as to the comments about personal property. There is a disagreement as to what Ms. Latier claims is being hers and what Mr. Pliska claims to be his. Now, certainly in any litigation, if a resolve can be reached, we're all for it, because by and large, that does occur statistically. That's part of it. The second part of it is the issue of whether or not a authority to either amend the complaint or a dismissal without prejudice, which would afford the plaintiff to file a cleaned up claim, as long as it's not futile, the law would support that proposition. And that's what we're seeking, Your Honor. Our affidavit includes the assertion that there's verbal and written agreement between the parties as to the long-term ownership of the real property. And since they're not married, should a finding be made of ownership, it would likely be in the under the auspices of tenants in common, which, of course, under the partition statute, for example, would afford the opportunity in one manner or another for a division of the property or a division of its worth or a sale of it and a division of the proceeds. And so I'm the first to admit, as I did in my pleadings, Mr. Pliska's effort to bring a claim was, how should I say it politely to him and to all of us, a mess. But I don't think that should foreclose his opportunity across the board and for all time to have his opportunity. And that's what we seek. However, the court would choose to have that occur, because I've offered what I believe are the options available to the court, and we seek one or the other in order to take a better, more focused approach to advancing claims on behalf of Mr. Pliska. Thank you. I'll answer any questions.
Okay, thank you. Mr. Connolly, any rebuttal argument?
Yeah, just simply, Your Honor. I mean, what I certainly want to stress to the court too, which can be gleaned, although very difficult to read through the complaint, real property is not mentioned in this at all. I mean, he didn't write in here anything about, I somehow have some stake in this real property in Wolverine and need to be paid back for that. So now we're getting into the realm of something completely different. So and then in regards to these personal property, that's what I've addressed and individually gone through, and Ms. Latier signed the affidavit about. So if the court was to dismiss this case with prejudice based on this futile complaint, this frivolous complaint, then it would still have, they would still have this opportunity if they were to want to come back to make some argument about the real property. Because, which again, you know, of course would argue would fail, but there's nothing in here about that. So now
the only one that I'm stuck on is the final page of the complaint where he says theft of tools, trailers, scaffolding, and ladders. That it seems that although that was inartfully worded, giving some kind of opportunity to amend, to press a claim for conversion or claim and delivery or something. I don't know why I would be allowed to foreclose that.
And glad you brought that up, because that's what I was alluding to with what I've already, those are the only items that we believe are still on the property that, here you go.
Right, I know, but
understand.
if you don't do that and I've entered summary disposition without an opportunity to amend to it, then he's without remedy.
I understand that. I completely get that from the court's perspective. So if it is very narrow to that, that's what we would certainly ask.
All right, well, here's what I'm going to do. There's a motion to dismiss this case under the court rules for summary disposition under MCR 2.116 C8 and C10 for failing to state a claim on which relief can be granted, and that there's no genuine issue of material fact, and that the plaintiff the defendant, I'm sorry, is entitled to judgment as a matter of law. The complaint that the plaintiff filed representing himself is in gross violation of the court rules. It in form and in substance, even leaving aside any of the grammatical challenges in it and putting the best light in it, it is still grossly violative of the court rules, facts, and law. And it seems, you know, the way that it's just paints with such a broad brush, ignoring legal doctrines that many of these things are just simply not recoverable because these parties weren't married and they didn't have contractual agreements with each other for these services. It does seem designed to harass the defendant. So therefore, summary disposition is entirely proper, and I would grant the motion for summary disposition under MCR 2.116 C8 for failing to state a claim on which relief could be granted. And the defendant, I'm sorry, the plaintiff, now represented by counsel, wants an opportunity to amend the complaint, which I'm required to do unless doing so would be futile. I find that an amendment regarding these failing to pay for services would indeed be futile. These parties were in a relationship together and residing with each other, and Mr. Plisko was doing work at the house, and now he complains, we have lost Mr. Ingelson's connection is bad.
I'm here now again, Your Honor.
Okay, very good. All right, so I'm granting motion for summary under C8. I find that, I furthermore find, before I get into amendment, it's of course unusual that a court would make the finding that a complaint was frivolous, although in this case, my ruling on the C8 motion makes clear that this was an entirely frivolous complaint, grossly violative of the court rules and of law, and I believe it was designed with an intent to harass. I find that it is clearly frivolous under MCL 600.2519, and I would award attorney fees payable by Mr. Pliska to the defendant. Mr. Connolly, you will have 21 days Well, I'm sorry, 14 days to file a bill of costs.
Okay.
14 days after entry of the order, I suppose, because we're going to have a couple orders here. 14 days after the order of dismissal to file a bill of costs. Mr. Pliska, the plaintiff would have 7 days after you file that bill of costs to object to it. If there's no objection, then the award will enter. If there is an objection, I believe under the case law, I have to schedule it for an evidentiary hearing.
Yep.
As to amendment, I do find that an amendment regarding the property or the failing to pay for services provided would be futile and frivolous, so I'm not going to allow that. I would allow an amendment on a very limited purpose, and that would be that it would not be futile. I can't find that it would be futile to allow an amendment to pose a claim for conversion, what was called theft in the original complaint as to the personal property. So the plaintiff will be allowed 21 days after the order granting summary disposition to file an amended complaint that would be limited to claims pertaining to the alleged theft of the personal property. If the plaintiff elects not to do so within that 21 days, then the summary disposition will just be a final order. So Mr. Connolly, is that ruling clear enough for you to prepare an order to that effect?
I do think so, Your Honor, but to be more specific, because there aren't numbers, as the court noted before its ruling, would it just be
theft of tools, trailers, scaffolding, and ladders? That is the only claim that an amendment is allowed. And so maybe if you guys sort that out, maybe the plaintiff won't want to amend. I have no idea, but he's got 21 days from the entry of the order of summary disposition to do that.
Yeah, may I be allowed to say anything?
Well, you have an attorney to speak for you, sir.
Well, she's perjured herself many times. She says she paid the homage for metal, and they do not take credit cards.
Attorney to speak with you. Say another word, and I will hold you in contempt to spend some time in the jail. All right, we're done here today.
Thank you, Your Honor.
All right, that's contempt of court, 24 hours in the Sheboygan County Jail right now. Direct contempt of court for swearing as he's leaving the court proceeding. I'll enter a judgment of contempt. It'll go with the bailiff. You'll be released at 2:30 in the afternoon tomorrow, sir. All right, Mr. Engelson, you have a great day.
All right, thank you. Sorry, Your Honor.
No worries. That wasn't you.
Understood.
Let's go off the record for a second.
Every day in the USA, people find themselves in court.
All right, Mr. and Mrs. Smith, would you come over here and have a seat? We're going to hear from them again before we're done. Title of this case is Scott Michael Maurer versus Jeff Smith and Jenna Smith. Are you Scott Maurer? You need to unmute your mic.
Okay, there we go. Sorry, Your Honor. Yes, I.
And you're Jeff
Michael.
Smith?
Yes.
And you're Jenna Smith?
Jane Smith.
Jane, all right. First of all, I know everybody here, and you know I know everybody here. Mr. and Mrs. Smith are my neighbors. They live around the corner. Mr. Maurer I've known since he was born. I know both of his parents. I know him. He may have even done some work for me at one time. I can't remember, but Anyway, I know everybody involved here, and I don't feel I need to recuse myself. That means remove myself. But if either party wants me to be recused and have another judge appointed to hear this, I could ask Judge Pattison to hear it. Mr. Mauer, do you have any objection to me hearing this matter?
No, Your Honor.
Mr. and Mrs. Smith?
No, Your Honor.
All right, I see them more than I see you because I go past their house a lot, but I see you around. And so as I said, I'm willing to do it. That's my part of what my job is. But let's talk about this. Excuse me. Just what nobody wants to watch somebody blow their nose, but this is a claim for the statutory limit of $7,000. We're in small claims court. You had ability to see a little bit of it. It's pretty informal. We don't strictly follow the rules of evidence or procedure. I will allow hearsay like letters and contracts and other documents without a lot of foundational requirement. But everybody is under oath. There's no appeal from small claims. Any decision made here is final. Either party is allowed to ask to remove the matter to the general division of the court, where you could have a lawyer, have a formal record, have the right to appeal, but you have to tell me that before we start. Once we begin here, any claim is final and there is no appeal. Mr. Mauer, you understand that?
Yes, sir.
Mr. Smith, you understand? Yes, and Ms. Smith? Yes. All right, you guys retain Mr. Mauer. Mr. Mauer, you have a contracting construction business, is that correct?
Yes, sir.
And what's the name of it?
Scott Mauer Construction.
All right, and the Smiths hired you to do some work to their home on Thompson Lane?
Yes, sir.
And according to your claim, you performed work, quite a bit of it, and they didn't pay. What's the story there?
I guess start from the beginning. Back in June.
How much do you believe is actually owed?
$7,201.89.
All right, well, let's find out. Mr. and Mrs. Smith, you agree with that or disagree?
Disagree.
All right, then start at the beginning. Tell me why you believe they owe you this amount of money.
Well, in the middle of June, Gina Smith had made a post about some water damage. I contacted them, met with them, oversaw the amount of damage and what needed to be done. We talked about us doing the work. We started on August 7th. Prior to August 7th, I had dropped a dump trailer towards the end of June. Dumped it 4 times before we started, which I have receipts for. On August 7th, we started in the house.
All right, now stop. How much was each of those dump charges?
Prior to starting, I have a receipt for $179.98, $179.91, $251.68, $179.75.
All right, that's before you even started the project.
Yes, sir. And I didn't charge them any time or labor or anything, just the receipts for those.
What were you dumping?
The debris from some of their tear out that they did, along with many household items. Right down to the couch. I mean, the house was pretty well completely gutted as far as furniture and things like that. Kitchen cabinets were in there. Numerous things. Things from the basement.
Just a minute. Come on back in, Mr. Burr.
I need to let her know real quick.
No, I'll bring her in. You come up to have a seat right there. Close out the Zoom. All right, let's go back to this. We've cleared the decks of everything else. so we can pay attention to just this. Did you give them a quote?
Just a verbal quote. We were working with their insurance company at the time. At the time of us originally talking, they was through their adjuster, and the insurance company had a quote of $24,660.61 to do the repairs needed. Throughout the course of speaking with their claims representative after the adjuster was done, 4 different times, I believe, I have all the printouts of the changes in the claim. It went from in late June at
Well, just a minute,
24,000.
you didn't file any of that stuff. I don't have a contract, I don't have a quote, I don't have anything, any receipts.
I filed the receipts. The file that I have here that.
Oh, wait a minute.
Of what I filed, I have some notes of our time.
All right, here's
the
the invoice from 9/29/25. Sorry, so we're proceeding from that.
That was the final invoice after we left the job.
So you're claiming material total with dump receipts, 3,540, labor total, 9,660. Down payment on 8/8 of 4,000. Apparently there was a swap of a jet ski for 2,000. Leaving 7,200. All right, let me add that up. 3,540 plus 9,660 equals 13,200 minus 6,000 gives us 7,200 that you claim you owed. All right. Now, and you've got some of this sideways. I have to turn sideways to see it, but we've got a State Farm quote, and you're right, their claim from the adjuster was worth 24,660. All right, you give them an invoice in September. Their answer to your complaint states he did not finish the job. He stated we want a counterclaim for $4,915.34 because he stated I can't read that word, and I'm not in any position to criticize anybody else's handwriting. What is that in your counterclaim?
In minor, yes.
I believe plaintiff owes me money because he stated, what does that
He would
say?
fix the gutter and soffit, put a front door in.
He stated roof soffit.
Yeah, the jet ski had nothing to do with the house repairs from the insurance. That's a completely separate thing.
All right, and six pump was.
Yeah, sump pump.
The sump pump
Sump
was
pump.
installed incorrectly. It had to be redone. We paid him separately for that as well.
All right.
So the jet ski.
All right, well, we'll get back to that. I'll hear your response, but obviously there's a disagreement here. And we don't have a quote or a written contract to operate from. So we're kind of wandering in the weeds here. So you posted something on Facebook and said you had water damage.
I had water damage and was looking for a contractor.
What was the damage?
The damage was our upstairs bathroom. The toilet leaked. We were at a wrestling event all day. It leaked down into the hallway, into our bedroom, down into the kitchen and into our basement. And so we came home to a nightmare, cleaned as much as we could, then decided that we were gonna make an insurance claim and called Serve Pro.
All right, then you put it out on the Fisher Lake site or somewhere else?
Find another contractor.
Boco Brothers was booked out, and we're friends with a couple other contractors, and they were booked. And so I put it on Facebook,
All right, and he
Scott-
responded to the Facebook.
Correct.
Okay. All right. So he agrees to do the work. All right, so we'll get your side in a minute. We're still
Okay.
trying to get clear on his side. All right, so Mr. Mauer, go ahead.
Well, on August 7th, we started work on the house, completing the rest of the tear out that was left from drywall, some doors, miscellaneous flooring, subflooring, I should say. And proceeded to put the house back together, redoing some repairs beyond even the scope of the insurance work, just to make it, complete. And on September
All right,
17th,
well, let me stop you. So you say you put the house back together. This
Yes.
isn't like a Lego set. You got new plumbing to do, you got new drywall, you got taping, seaming,
Yep.
flooring. What did you do?
I do have a file of 101 pictures. I originally thought that we would be in a courtroom. I would be in a courtroom as well. Is there some way I can share this file of pictures with you that show the state of the house from the time we got there to look at the work to the day that we started work, all the way to September 17th, the last day of work?
All right, well, so in your,
We did.
I said it twice. In your second complaint, you state work completed between 8/7 and 9/17, including miscellaneous tear out, minor electrical, plumbing, framing, drywall hanging, finishing, cleaning, painting, and soffit and fascia work. Included an invoice is a copy of all receipts and written breakdown of man hours, materials with dump fees. So you got material totals, which this all seems cheap for the amount of work you're describing. So the materials with the dump fees are $3,540, $3,540, is that correct?
Yes, sir.
And what is that?
It was for drywall, for the kitchen walls and ceiling, upstairs bathroom walls and ceiling, some framing materials for a door that we framed in between the upstairs master bathroom and their bedroom that they no longer wanted. So we framed it in, drywall both sides. Miscellaneous primer. We primed all the floors in the house due to stains, soiled areas from animals. Plumbing was the new toilet flange for the toilet upstairs that had been removed prior to us getting there.
Did you tape and seam and sand this drywall or just
Oh, yeah.
put it up?
Yep, and we primed and painted the lower level kitchen. Had primer on the bathroom upstairs. Started the bedroom upstairs after all the mud work, including the stairway wall going upstairs, which we found during the course of the work the drywall hadn't been screwed properly to the wall. So as you can see in one of Gina's pictures, that there's a bunch of screw holes, marks where we screwed the wall and then mudded it beyond the scope of the insurance work. And then as far as electrical goes, we replaced a damaged, burned out receptacle in the kitchen with a GFI that would control the other receps in that line, and also found in the ceiling a live wire coming from a light fixture, a can light that was over the sink. There was another wire coming off of that light, just laying up in the rafters on a board and live every time you turn the light on. So we eliminated that wire, put in a new can light there. We found that all the ceiling boxes for the electrical. The rough end boxes were all metal boxes. They had no grommets for the wires coming through the hole. You're supposed to have a wire clamp or a plastic grommet so that that wire is not rubbing on the metal box. We installed those in all the open boxes in the kitchen.
All
prior
right, so
to
you've
the
got
flow.
your material and labor.
Yes,
And you
sir.
got 9,660 in labor. What you're describing me would sustain that. So they paid $4,000 on 8/8.
Yes, sir.
All right, so they claim that the jet ski isn't part of this deal. What's your story regarding that?
When we met originally, I had had interest in Jeff's jet ski for years. I like that style. I'd already bought one. I had one prior to doing the work. His then needed a lot of work. But I agreed to barter essentially the jet ski for a new front door. And they had mentioned, Jeff had pointed out the state of the soffit and fascia on the house, which there was a bunch missing, some falling out. And I agreed to help them there with the soffit and fascia and the door. And after the blow up on September 17th, I was already in possession of the jet ski. So I put that of pretty decent value of $2,000 towards what they owed.
So you no longer have the jet ski that they've got?
Oh, I still have it.
All right, who has the title?
I do.
All right.
I haven't transferred anything yet. Could easily give that back.
All right, talk about the blow up on the 17th.
On the 17th, I was leaving the job site. It was about 7 o'clock at night, and Gina had showed up. There was appliances coming, and she was asking about the appliances, waiting to have them installed, or us installing them, having them delivered, and then us installing them, because the delivery place where they bought them, Lowe's, was gonna deliver and install. We didn't have the kitchen cabinets up, which had just arrived a few days prior. So I told her that we would hook them up. I mean, it was a dishwasher, oven, fridge, microwave. And I made the comment that we had done other extras beyond the scope of the work that we had agreed upon, and I wasn't worried about it. It wasn't that big of a deal. And I said, as long as I got my $17,000 at the end, which is what we had agreed upon. She said we agreed upon $14,000 and completely lost it and called me everything but a white man, a crook, a liar, a thief, at the top of her lungs in the front yard. And I told her I was leaving. I wasn't going to do this, and I proceeded to leave. And the next day, after talking with Jeff and going back to get all of our stuff out of there until we had something in writing, and talking to Jeff, I decided I couldn't go back. I just, too much had been said, and I couldn't give him 110% on that job at that point. I couldn't even go back to that job at that point. And then I was told if I came back on the property, it would be trespassing and so forth.
Yeah, we don't say I was called anything but a white man.
Oh,
This is 1956. So I don't even know where that started, but
I don't know.
it's 2026. So
I
my
apologize.
apologies. All right, so this is news to me that you were gonna do the whole job for 17,000 was the quote.
Yes, and some supplementals, which the insurance company had agreed to pay at the end, which would have amounted to $4,000 to $5,000 at the time.
All right, was that written down anywhere?
That was just my speaking with their claims representative at State Farm, or auto owners. I don't even remember.
You've been in business long enough. I can't even believe you would do this. So you did an amount of work and then after the blow up, you said you couldn't go back. So they're in the middle of this job and you left the job undone.
Yes,
How
sir.
much was left to do?
The kitchen cabinets needed installed, the flooring was there, needed installed, and the bathroom needed finished, and then trim miscellaneous paint.
All right. Did you ever get any check from the insurance company?
Myself, no.
Yes.
Everything went to Gina and Jeff.
All right. So he did an amount of work. Claims he didn't get paid. Apparently he didn't get paid other than $4,000. You got a different perspective in that you're claiming he left you high and the dry in the middle of the project. What's your take of the, we'll call it blow up on September 17th?
I take of the, Your Honor, my take
So
of the,
first thing, one thing I didn't do with anybody, all right, please raise your right hand. Everyone here swear any testimony you gave or are about to give in this matter will be true to the best of your knowledge and belief.
Yes.
Yes, sir.
All right. All right. Tell me what your perspective of that is.
the blow up in September, mid-September, was coming to a head the entire time. I asked over, and I have it, and I printed off all the texts individually, where I asked about 16 different times in different ways for something in writing, whether it be an invoice, a contract, an estimate that he can provide, that we can show our mortgage company and our insurance company, so we know what we're paying, and so what we know what we're paying him and what his fees are. He never gave that to us.
Now, this thing, it's dated 9/29 invoice. So was that the first document you got of what it was he claimed was owed?
Yes. The first document we got was Your Honor, was the $4,000 down payment, which I was unhappy with because it said the rest of the fees will be agreed upon, da, 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 da. So, and before that, I'd already asked him several times for a contract or an invoice of what I would be paying him. I also have in text that he told us that he would be conceding some of the labor costs or some of the cost to us for his labor. So $50 an hour, I wouldn't think would be conceding any of the costs. We never agreed upon any hourly rate, and I would never, ever do that. It was a job that I had through my insurance company. They created that estimate.
All right, what did you think the job cost was? He said 17,000. He says you said 14,000.
During one of the drives, or where we were dealing with the kitchen cabinets, he made a comment saying, as long as I got about 14 grand for the job, when it's all said and done, we should be good to go. We never agreed on any number. And I have that, where I've asked them down to the last day on, in September, where I said, I need something in writing to provide for my mortgage company. I also have a letter from Scott with JD Construction saying everything he did needed to be redone because it wasn't done properly.
JD Construction is Jeff Drain
and Scott Ertman.
And they have a construction company that does stuff. They've done work for me. Let's go to that. I was looking for something else.
You didn't submit that, or
The letter, he just sent me the letter February 7th. But I did provide the estimate that they did when they took over. And it does state some of things on the estimate that needed to be redone, but he did provide an overall letter.
All right, that is the JD Construction 9/20/25 estimate.
Mm-hmm.
You have that.
Mm-hmm.
But then there's a subsequent letter
He also provided for the counterclaim, the gutter and soffit costs.
I'm trying to get past everything to get to that letter.
She just got it, so.
Oh, it's not.
I
in
just
yet.
got this
Oh,
letter.
well, let me see it. I'm looking for it in the electronic files. I didn't
January
remember.
28th, he's.
All right, go ahead. Well, I'll just read it.
Oh, I'm sorry.
At the property of 1991 Thompson Lane, Three Rivers, we had to install a header between the dining room and the living room because the drywall is even and could not be married together without noticing it. The drywall in the kitchen had to be skim coated because of uneven gouges. The walls were primed and had bad roller marks that had to be sanded down and reprimed. Flooring had to be sanded and floor leveler had to be installed because of uneven in spots. Drywall had to be doubled in the bathroom because the framing for the tub shower was wrong and the tub was set. The plumbing in the basement had to be taken apart and cleaned and re-glued because it was leaking. Signed, Scott Erdman, JD Construction. All right, and you also mentioned something about a sump pump.
Yeah, that's the plumbing in the basement.
All
You
right.
put an injection pump in.
I paid him separately for that, so we did that as part of the counterclaim.
So that's not, the sump pump is not part of this deal?
It wasn't part of the insurance claim, so I paid him separately for that. I paid him cash and I provided the receipts that he gave to me. Totaled up for that.
Mr. Mauer, what's the name of your business?
Scott Mauer Construction.
Does it have a license?
I just have a DBA. And can I respond to the sump pump issue there in the picture, number one?
Let me stop you. I thought you were licensed. Under the law, you have to have a license to sue somebody. I should have done this first. I saved a lot of time. You're a residential builder, a residential maintenance and alteration contractor. You are running naked. You don't have a license. And if you don't have a license, you can't sue anybody. So you don't have the right to sue them unless you're a licensed residential building and alteration contractor. I thought you were. You get zero. You're running naked. Every time you do a job and if you sue somebody for money, you don't have the right to sue somebody unless you have a license. You need a license to do all of these jobs. In fact, it's a misdemeanor to operate as a residential builder or residential maintenance and alteration contractor. You need to be licensed by the state of Michigan. We get lots of these. And you've been doing this for so long, I just assumed you had a license.
Since 2020.
Well, a DBA is not a license.
No.
From the state of Michigan. So you don't have the lawful right to sue them. I should have done that first.
Yeah.
Claim is zero.
All right.
I could have saved us about the last 45 minutes. For this comes up periodically. It's not just this, but a number of things. You need a residential maintenance alteration contractor license to do things like swimming pools and patios and driveways, some roofing, siding. And you need a residential builder license to do things like you're doing plumbing, you're doing electrical, you're not a licensed plumber, you're not a licensed electrician, and you're not a licensed residential maintenance and alteration contractor. So you don't have the right to sue. So I don't have to decide who was right or wrong or who owes anybody how much money. Kim, would you prepare a clean one of these for me? I find for the defendant, dismiss the case
Your Honor, what about the counterclaim?
Oh, good point. You don't have a right to defend a counterclaim. You're really running naked. Not only do you lose, you get a counterclaim judgment against you in the amount of $4,915.34.
When this, and how again, am I in the hole here after I'm already in the hole 7,200?
Yes, you are. That's what you get for doing this without a license. Not only do you not get paid because you don't have standing to sue them, you don't have standing to defend a counterclaim. So you need a license to do this. You can't even file a lawsuit, and they sued you and you don't have the right to defend it. So I don't even have to think about this. Yeah, this is seems unfair, but you're doing this without a license, which is a crime.
Nothing we did required a building permit or anything of the such. It was essentially handyman work.
Yes, it did. At least if not a full-blown building permit, a residential alteration and maintenance contractor license. Did you get permits for any of this?
The insurance company took care of all that.
And JD Construction, when they took over, they took care of everything. And Your Honor, he did take some of our siding off and some of our soffit off and left it like that. And it's been like that throughout the winter. So you made the comment that it seems unfair, but he did damage to our home. And then we had to redo.
Well, it seems unfair to him.
Yeah.
But I guess that's in the eye of the beholder.
Mm-hmm.
You need a license to do this. Your opinion that you don't is, I disagree with it. In fact, you need a license to do everything you're doing at Scott Mauer Construction. A DBA is not a license from the state of Michigan to perform this type of work. So my regret, you owe them $4,915.34, and you get zero on your claim. And that's just how it went. All right. I'll have her prepare a judgment. This happens periodically, and it was on me. I should have asked that question right from the start. I'll make a copy of this letter, or is this my copy?
You can have it as your copy.
All right, we will be in recess.
Every day in the USA, people find themselves in court.
They're on the wrong side. They're on the wrong side. Come on, counsel. Don't you know? You know, I know it's your fault, but I'm going to blame them.
By the box. Oh,
That's right.
I correct myself.
All right. And on the plaintiff side, who do I have?
I'm sorry,
Your names?
Asim Yassin.
Iris Yassin.
All right. Morning. Oh boy, here we go.
Good morning, Your Honor. I'm Justin Yu. This is my partner, Lazar Georgiev. We asked this court permission to appear on behalf of our clients, Mr. Bill and Mr. Jackson, under MCR 8.120 and under the supervision of David Santacroce.
I don't know. Where are you from?
From Seattle.
Seattle. Did I already ask that of you? I may have. You've been before me before, right?
First time.
Yeah. Today's the first time?
Yes, sir.
Yeah. You're from Seattle?
Yes, Your Honor.
It's really damp there.
Yes.
Congratulations on your Seahawks.
I'm actually a Patriots fan, Your Honor.
You are? I hate you. Because I am not. The only reason I was rooting for the Seahawks, it was ABTP, anybody but the Patriots. I don't like the what?
That was a terrible answer.
It was horrible. Horrible. Why are you a Patriots fan?
I was born in Boston, Your Honor.
Oh, well, that's a problem. Okay. So where'd you go to undergrad?
Tufts University in Boston, Your Honor.
In Boston, and then your family's in Seattle.
Yep.
So you came back to Boston and now you're at Michigan.
Yes, sir.
You just can't figure out where you want to be.
Right.
Okay. And what about you?
Yes, Your Honor. I'm from Chicago.
Yay, Midwestern.
Yes, sir.
I love it. Born and bred? Or
I was born in Bulgaria. I moved to Chicago when I was very young with my family.
Bulgaria. Where'd you go to undergrad?
I went to Northwestern in Evanston.
Okay. I have a niece out in Chicago at Loyola, so I'll take it easy on you. So when it gets tough, turn it over to him because I like him better than you being a Patriots fan. All right. All right. Thank you, gentlemen. Permission to practice is granted.
Thank you, Your Honor.
All right. And where are we on this case?
Your Honor, I was served yesterday after I saw the email at 8 o'clock at night where they have a counterclaim, so I would like to motion to get a continuance in order for me to be able
to answer the counterclaims?
Yes.
All right.
According to the statutes, whatever the court deems
All
appropriate.
right. How much time is it going to take for you to answer the counterclaims?
Well, to answer the counter, between 21 and 28 days is what I would like in order to be able to get out the.
No, I probably won't give you quite all that time, but okay.
I'm sorry.
I probably won't give you that long
Okay,
to
well,
file an
the-
answer.
The court deems appropriate, but you know, I will try to do my best.
All right. All right.
Your Honor, we'd agree to a month because we have some additional discovery to conduct. We just received this case last week and we don't have all the
Students
documents.
are so cute. We'll agree to a month because we don't care about the court schedule. We just got to go to class. No, go ahead. I'm sorry. Don't mean
We
to
just
interrupt.
got this case last week, Your Honor, so we don't have all the documents yet, and we discussed with plaintiffs that we would ask for maybe a ledger or any communications or documents relating to any repairs that will be an issue in this case. And this will also give us time to file any FOIA requests to get inspection reports from the city, Your Honor.
So do you have a problem with the month adjournment?
No, Your Honor. That's cool.
Nobody cares about my docket. Nobody cares. No, I know. You're saying whatever. They don't do that. They come in just like demanding a month, but they get that from Santa Croce. Just demanding time. All right, let's do it this way. Do you have a ledger that you can provide them and repair records?
I will provide them with whatever I have, I will provide it to them. Yes, I do have a ledger.
Okay.
I have payment ledgers, I have, you know.
Okay, but what about documents regarding repairs to the
I will
premise?
have to look them up because there has never been any repairs except for one time, 2-3 years ago, when there was a little water problem. I had to pay a plumbing company to come and clean up the
line.
line. They did that, and after that, everything has been good. And besides that, repairs, changing of smoke detectors. It's been basically because it's
Okay.
construction and it doesn't need a lot of repairs. Oh, we did change the roof 2 years ago. That was but that was preempted.
So you're going to be able to provide that ledger to them, say, within the next week?
I will provide them with everything that they asked me for.
Okay.
And I will also be asking them to provide for a lot of proof because they have a lot of allegations that are out of the air. I'm sorry if I'm talking too much wrong.
All right, no, that's okay. So, well, here's what this is the way the court works without necessarily issuing a formal order for discovery. I expect the parties to cooperate with each other regarding the information. So if you ask them for something, to the extent that it can provide it, if it's there, the obligation is there for you to provide that. Same applies to you. All right, everybody's understood regarding that. All right. So what I will do then is I will indicate that you're to answer the counterclaims. In this case, you're to do that by February 24th. I'm going to give you 2 weeks to get an answer in on that. Okay.
Question, please.
Yes, sir.
I need them to provide their address because I heard that the address that they gave is not their address, but it's
You need to provide who?
the
Tenants?
the defendants to provide their correct address so that notifications can be made correct.
In terms of the
Whatever address they want to provide to be notified to.
You mean in terms of your answer?
Yes.
Your answer should be sent to their attorneys. You shouldn't be sending things directly to the defendants.
So we do not need to have their address or anything on record?
Well, why do you need their address at this point?
Okay, the first thing that I was going to do was to send them, which I already probably provided them. They need to provide the address when they move 5 days after they move in order for us to be able to provide them with whatever.
Oh, 4 days, but yeah, go ahead.
And we haven't had that yet from them. So that would, I would, in case anything like that needs to happen. And, but otherwise I would just.
Well, hold on a second. At this point, you're seeking to provide them something.
No, I already did the last time.
Okay, hold it. I'm trying to figure out, why do you need their address right now?
Simply because the law says that I need to have.
They were supposed to supply to you a forwarding address within 4 days of the date of vacating the premises. And their failure to do so has its ramifications if that becomes something involved in this case.
Okay.
So you don't need it. Any communication that you're going to have or make to the defendants in this case, you need to go through their attorneys.
No problem.
All right. So you're to answer by February 24th.
I will.
All right. And then I will adjourn this matter to March 10th, 2026, 9 a.m.
We have one more issue to raise.
Of course you do. Why? Because they're from Michigan. There's always going to be an issue. Go ahead.
Right before this hearing that the property in question is owned by a corporation that plaintiffs own. They own the corporation, which then leases the property to plaintiffs, which plaintiffs then lease to our clients. And under law, they can't represent a corporation. So we're just unclear on the law specifically here. But we just want to raise that to the court.
Well, who is the lease with?
The lease is with plaintiffs. They're just leased from their corporation.
So you're. Well, why would they have to have an attorney and couldn't represent things? Because
they can't represent a corporation if they're not a licensed attorney.
But are they representing the corporation? You're indicating that the corporation leased to them. And
right.
So.
But the corporation owns the property. So the prior order giving them possession of the property would be to the corporation.
Why wouldn't I treat them the same as I would that this really is a sublease? So
you're right.
If I treat it as a sublease, why would they have to get an attorney?
We don't have a clear answer on the law at this moment. We just wanted to raise because it does add some complications or possible complications to this case, Your Honor.
Your Honor, if I may.
Yes, sir.
It seems like a perpetual, it's a wholly owned LLC. And in order to avoid having to retain counsel, to represent that LLC, it's some sort of perpetual sublease to themselves individually. And then they lease it. Just, it seems clever at the very least. But I don't know, I mean, it obviates the rule that if you own a piece of property in a corporation and you benefit from owning a corporation, you have to hire an attorney.
Well, except that, I mean, you're right in terms of what you just stated about an LLC and the benefits that an LLC gets. The difficulty is in doing it this way, and the danger for them, while it may be clever in doing it this way, is that any liability is going to attach to them personally. And so that may be a problem.
For tax purposes, LLC doesn't have its own tax return. It's part of the individual return. So the legal identity seems the same. I mean, like they've been great, but we always prefer to have counsel on the other side. But we just wanted, I've never seen that before, so I just wanted.
I haven't either, and it's probably because the liability issues are probably potentially going to be substantial, and you're probably doing it this way. Frankly, they're going to lose the protection that the LLC has, but that may be their business. Yes, sir.
It's not an LLC, it's an incorporation. It's a C corporation. I live in the apartment where the lady lived. Where she.
Yeah, but sir, here's what the. Okay, you talk over me.
I'm sorry.
Go for it.
I'm sorry.
Here's what the issue is, and I don't know that I'm going to necessarily address it today. They've raised it as a potential. Is that it doesn't matter what type of corporate entity owns the premises. That corporation has leased to you.
Yes.
Okay. I think you need to understand that should they prevail on some issues, the liability for some of this goes directly to you. The corporation is not a protection from it. There may also be issues, and maybe this is what they're getting at. There may also be issues of if it is a circumstance where the corporation isn't really there, that it's just there in name, but you guys are operating, then they're going to go behind that corporation if they needed to get at the property. So
I understand that.
Okay.
Corporation is legal, everything is up to date. And
yeah, but so let me put it this way, and I'm not saying that it is, but if it were a situation that the corporate entity is really nothing more than a sham, that can create other problems for you.
I understand, Your Honor.
Well, I hope you do. I don't know if we'll get there. Pardon?
It's an interpreting corporation which owns the premises, and it works with the courts. I provide interpretation for the court. I'm a qualified interpreter, so the corporation is good, Your Honor. So I have no qualms.
Well, it may be for some purposes and maybe not for others. Yeah, I'm going to suggest to you, sir, this having been raised, because I don't think you understand what I'm saying. I'm being very careful in what I say, that you may want to get some legal advice, because I can see where it may potentially cause some problems. Anything else?
That's it, Your Honor.
You sure?
Yeah.
You sure, Seattle?
Yes, sir, Your Honor.
He's a Patriot fan. You know what? I should take him. I should have you take him in. You think? No. He didn't know what to do. He's like, oh my God.
One more question, Your Honor.
Yes,
You gave me 14 days, but if you give me 21, since they are asking for a month, that way I can have a little more time to provide them with whatever they are asking me to get.
I need an answer by then. I'm not saying that I need all of the documents.
Oh, okay, an answer.
I mean,
Legal purpose to, if anything comes up, I can add it to the answer. Is that correct, Your Honor?
I'm not going to say it that way. You need to answer their counterclaims by that point. The providing of documents and other information between the parties is something that is going to continue throughout. So you get the 2 weeks. You can provide an answer to this in 2 weeks. I'll see you guys in 30 days.
Okay, Your Honor.
Thank you, Your Honor.
Thank you.
Thank you.
Have him write it in Bulgarian. Just what? Just see if he can, because I don't know if he's telling me the truth. I just don't know. Just saying.
I'm impressed. I didn't realize you read Bulgarian.
I do. I'm fluent. Yeah. That's peace. Thank you, guys. Take care. What is this last?
Requires a Mandarin interpreter.
Requires a what?
Mandarin.
No, it doesn't. That.
Is present, but I don't believe tenants are.
Wait, what is this on for?
They are not paying.
Okay, he's gonna. Sanford versus Normal.
Norman's in Zoom, you're on.
Oh, there she is.
Good morning.
Gil Stanford.
All right. Miss Norman, can you state your name?
Susie Norman.
Okay. And that's a wrong screen. No, it's okay. I'm good. I'm good. I'm good. All right. Where are we on this case, folks?
At the last hearing, we were reading on the evidences I sent. One was a flash drive.
Yes.
Due to the weather and the courts being closed, it hadn't been logged yet.
Correct. I think also, we have it now.
Yes. And I believe that your coordinator helped Mr. Stanford to play his flash drive.
Right. Did you get all the stuff off of the flash drive?
I did see the video of the previous hearing on that, yes.
Okay. And so with reference to that previous hearing, you have something you're holding up. What are you trying to get?
I submitted to the court an answer to that, and I sent a copy to her. I don't know if she's received it or not yet.
Is that the response to defendant's objections and evidence submitted about January 15th, 2024 hearing? That's what you, okay.
That's right.
All right. Have you received that?
I have not.
Okay, folks. All right. All right. Somewhere along the line, we've got to make sure, because it becomes impossible for me to conduct a hearing where one party has submitted something and the other party doesn't have it. And I'm not saying, I'm not blaming either party. I'm just saying that's the cold-hearted reality of where I end up.
Your Honor, may I say
how did you send this to Miss Norman?
US mail.
Okay, well,
You know, and
that's
I
gonna be,
thought our hearing was a little later in the month. I thought she was gonna get it. And I just got the notice about our hearing date yesterday. So I was thinking maybe I should.
well, that maybe should tell you something about the mail. All right, here's what I'm gonna do. I think we have Miss Norman's email, right?
Yes, sir.
Okay, so
Just
folks
say
are
something.
not sure that, yes,
Can I
ma'am.
say something, please?
Yes, go ahead.
That video from the hearing from 10/22 of 2024 has on there where Mr. Stanford waived his right to monetary damage and rent because of the case, and my case being I dismissed my case in order to come to that end. So I don't know. I just feel like at this point it's we're just on the court's time and we're wasting it with
Well,
all of these things.
Ms.
It's just
Norman, I understand what your position may be. My position is that if somebody submits something to the court, I have to at least look at it and consider it. The very fact, I don't think, if you think about the last hearing, you submitted something and I didn't get it because of whatever the circumstances were. I didn't have it. I don't think you would want me to proceed without having that. Mr. Stanford has submitted something. I'm not going to have a problem going through it. You just have to have it so that you can respond to it if necessary, because you're entitled to have it. Here's what I'm going to do. At this point, there'll be no additional filings. All right, because I don't want to end up in this circumstance. We have Ms. Norman's email.
Yes, sir.
All right. So what I'm going to do to expedite the process, Ms. Norman, because normally I'd put it out however long it may take the mail to get there. I'm going to have my staff copy what Mr. Stanford has submitted, email it to you so that you have it. Okay? And then
so what happens then? He's got an answer to the video, and then I see something on his answer, but yet I can't answer.
Then you guys can argue that before me. Miss Norman, I can't force this to go any different.
I don't want to
argue.
I want it to end. I want it to end. And this is just how we were in October of 2024. Frustrating you.
So I am not frustrated. I'm frustrated by your failure to
I'm not a failure.
Permit the court to proceed with how it has to proceed. I just explained to you why I can't do it the way you want me to do it.
Because he submitted an answer. Is that correct?
What did I just tell you, Ms. Norman? What did I just tell you?
Sir, I've been in this courtroom almost probably 13 times now. It's very frustrating for me. I'm not a failure. I'm doing everything that I can to end this court case.
Norman, I'm going to tell you this, and then I'm not hearing anything else from you. I'm going to do what I got to do.
That's fine.
I'm just going to, no, do not talk. Stop.
I said I won't say anything else.
Just stop.
That's how you treated me in October of 2024 as well.
I'm done. Then here's what we're going to do. We're not sending it. She'll wait for the mail. I'll just adjourn this case out. Where are we adjourning it? Yep, we'll just put it out so she can get the mail. I'm going to do it that way. I was trying to expedite it for her, but she's going to treat me rudely. It's not going to happen that way. Rudely. Give me a date. Respectful. I'm done. Mute her because I'm done with you.
March 10th.
March 10th. I'm adjourning this to March 10th, 2026, 9 a.m. Thank you. You can kick her out.
See you then.
Yep.
Every day in the USA, people find themselves in court.
Leslie Bolzager versus Cynthia Hernandez, 2504922.
Right here, man. Yeah, the problem.
Boy, you didn't do a very good job on this, ma'am. You can't be doing this. Your name?
Leslie Bolsager.
Your name?
Cynthia Hernandez.
Why don't you come up here? I want you guys to resolve this. Did you buy a car from her?
Yes.
Did you
It's
stop
paid
making?
for. I
Hang
have the
on,
title.
hang on. Did you stop making the payments?
No, the car is paid for in full.
Is that true? Did she pay for it in full?
No, Your Honor. In the contract, it states.
Do you have a security agreement? I didn't sign did I sign I was concerned about this. You didn't have a security agreement, did you?
No, my name was supposed to be on the title.
You guys, you try to be your own lawyers. It'd be like me. I don't care if she was your friend, not your friend. You guys you can't do things like this. This was a recipe for a disaster. Your name's supposed to be on the title of somebody else. When they're driving, you don't know if it's insured. They get in an accident, you get sued. You probably aren't going to have insurance on it. They're going to be coming after you. Ms. Hernandez,
Yes.
did she pay the payments?
No.
Good. Then
The last payment to be made on March 1st.
Well, what if she paid in advance? Did she pay in advance?
Two $500 payments.
Did you pay more than two $500 payments, Ms. Hernandez? Don't lie to me, because I'm going to get to the bottom of this. Listen to
Yes,
me very
I
quickly.
paid two on the day at the Secretary of
I
State.
didn't ask you that. Hang on a second. I want to be clear.
Okay.
I don't want anybody lying to me. And I'm going to find out who's lying. If she's saying it's not paid and you're saying it is paid, one of you are lying to me. So if you want to come up here with all your documentation and I'll try to resolve this for you guys right now, that would be fantastic.
On September 12th.
Hang on. I didn't say that. I didn't say anything here. Why don't you get dressed and come on up here? You live on Riverside, right?
Yes.
It's only a 6-8 minute drive at best. Bring all your documentation that tells me that you've paid for the car. How much do you think is owed?
$2,000
How did she pay on the first two payments?
cash.
Nice.
Right.
Really good.
We were
Really,
together. She was living in my house.
really, really, really good. Did you give her a receipt?
Well, I wrote
Did you give her a receipt?
I wrote it in this book.
Did you give her a receipt?
No, Your
You
Honor.
guys, you know what? I mean, bring all your documentation up here right now, Ms. Hernandez. So you guys, she was supposed to put your name, keep your name on the title, huh? Did you sign did you sign the title over?
I did.
Why did you sign the title over before you? It'd be like you tell me you're gonna buy my house and I sign, hang on, blah. Well, then you should have talked to a lawyer. That's what they do.
Right.
That's what they do. I never sold it before. Come on up here, Ms. Hernandez. We're resolving this morning. Get yourself dressed. She's gonna wait, and you come on up here. How long will it take you?
Say, I don't know, 40 minutes.
I'll see you about 10 o'clock. Don't hurry, don't rush. I don't want you getting in an accident.
Right.
Take your time.
Okay.
I hope you're never gonna do something like this again.
Absolutely not. It's unfortunate.
This pains me to see this. It really does. I know it's only $2,000, but $2,000 is a lot of money. Bring all your documentation that shows me she paid you. You paid her. If you took cash out, you can go to the bank.
I had
Wait.
cash. I don't,
Wait,
I,
ma'am, Ms. Hernandez, I'm gonna find out who's lying to me. It doesn't matter to me who's lying. I'm gonna, ma'am, I'm gonna find out who's lying. You guys just make this hard when you do this, like with the handshake.
My mistake.
You didn't make a mistake. You don't have to apologize to me. You might be out when it's your burden of proof here. But I can tell somebody's lying, and I'm gonna tell you who it is when we get here. Bring all your documentation, Ms. Hernandez, okay? That tells me
Okay.
that you paid this. Guys. I mean. You say you have a security, you filed a pleading saying you have a security agreement. Do you know what a security agreement is?
I was going by what
the bank
told me to write down the,
Don't tell me what the lawyer told you. That's between you two. If I went to a bank or I went to a dealership and bought a car, that's when I will execute a security agreement. I doubt that you had her execute a security agreement.
No.
Why'd you allege it in the complaint? Shh. Give me all your documentation. Did you ever sign a note at least?
We had this agreement that I gave you a copy. You should have a copy of our, contract.
Okay.
And she resigned for the 2 payments that she did give me.
She signed?
She signed, yeah. The 2 payments, one on,
Oh, that's kind of telling, Ms. Hernandez.
and it says in the
You
contract.
guys come up here. Come on, get dressed. Come on up here. But I'm telling you, I'm going to have you guys under oath and I'm going to resolve this today. And you guys are going to, you're going to be honest with me because I'm going to find out who's lying to me. Okay? I'll see you whenever you get here, Ms. Hernandez. Unless it's really, unless you guys want me to adjourn this for a week or so, I'll be happy to do that.
well, I'm volunteering today where I live.
Where do you live on Riverside? What do you mean you're
Yeah.
volunteering?
At the towers where I live.
Ms. Hernandez,
Yes.
why don't I do this? What do I have tomorrow, Jennifer?
Tomorrow is the 11th. You have Brownstown and Groseal reps. So let me see.
It's easy. All right, 8:30 in the morning. Can you be here tomorrow, Ms. Hernandez?
Yes.
Can you be here tomorrow at 8:30?
Yes.
We're starting at 8:30. Do I have sentencings on that docket tomorrow?
No, I don't see any sentencings
Good.
at 8:30.
Perfect. 8:30. You guys be here. Don't make me wait. All right? I'm gonna
Okay.
adjourn, we'll set for February 11th at 8:30. Everybody's to bring any and all documentation. I'm gonna figure this out tomorrow. Have a good day.
Thank you, Your
Thank
Honor.
you. Thank you. Michael Wathi versus Carlos Medina Cardenas.
Right to the podium.
Your name?
Michael Malati.
Your name?
Carlos Medina.
You were gonna get a contract.
Yes.
Is he here?
Zoom.
Good.
He was
Good.
on Zoom, but he's no longer on Zoom.
You're gonna go call him or something, okay? Go call him and I'll go from there. All right, why don't you have a seat? Rick, you can have a seat right at the table there if you'd like, sir. Do I have, what's the next one? Stone versus Chavez. Anthony Stone versus Rena Chavez. 2504928.
Right to the podium.
Is Rena Chavez here?
Yes.
I've not had her check in with us, Your Honor.
All right, your name?
Anthony Stone.
Good morning. This was scheduled for 10 o'clock, so we've got plenty of 15 minutes, so to speak. Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got. You say failure to pay, repay personal loan and property damage. You can put your hand down. How much did you
Your
loan
Honor,
her?
if I may, she just walked in and just checked in at the civil window. She's on her way down.
Your Honor, I have some evidence here for her. I was told to give her.
Just wait a second. Let me.
Yeah.
I don't want anybody to rush.
Yeah.
She's 40 minutes late. It's bad enough I have to wait for lawyers. Come on up here, Miss Chavez. You're late. Where's Rena Chavez at? Is she down? Is she on her way, or did she walk around the block first?
I don't know, Your Honor. She was at the window. We told her to come to courtroom
Rena
3.
Chavez, I need her in the courtroom. She's apparently out there.
Sir,
She's
in there.
Is Rena Chavez here?
She's not in her court.
Rena Chavez here?
Yeah.
What are you doing in there?
Oh, I thought I was waiting for someone or talk to someone.
Come to the podium, man.
Okay.
Be careful. Why are you late?
I've had some emergency, I've had a, brakes, there's something wrong with my brakes right now with my car, so that's why I'm late today.
Tell me your name.
My name is Rena Chavez.
Do you two want to talk? Try to talk this out? Do you two know each other? Of course, if you gave it. Nice. Do you two want to try to talk this out, or is that impossible at this point?
Very impossible.
Okay. All right. He claims that you failed to repay a personal loan and property damage. I'm going to go ahead and I'm going to ask you both. If you proceed in the small claims division, you have to give up certain rights. You don't have to give up those rights. But if you proceed in small claims, you're giving up rights. If you want to have the case removed to the general civil division, you can hire a lawyer if you want to. You can have a jury trial if you want to. You can appeal my decision if you don't like it. To the extent that you are entitled to a plaintiff, you can seek in excess of $7,000. If you waive those rights, we're going to stay here, in which case you can't hire a lawyer, can't have a jury trial, can't appeal my decision. Do you understand that, Mr. Stone? Yes?
Yes.
You have to keep your voice up.
Yes.
Do you understand what I just said, Ms. Chavez?
Yes.
Do you wish to give up those rights and proceed here or have the case removed? Mr. Stone,
I'd like to proceed here.
you waive those rights?
Yes, sir.
Ms. Chavez,
Yes.
you waive those rights? Do you have any other witnesses, Mr. Stone?
Oh, my parents can vouch for it, but
Wait a minute, are they here?
No witnesses.
Okay, do you have any other witnesses?
Oh, I don't even hear.
Pardon?
I don't have any witnesses.
Raise your right hands. Raise your right hands. You gotta raise your right hand again. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got. Mr. Stone?
Yes, sir.
Ms. Chavez?
Correct.
Okay, you can put your hand down. How does she owe you this money?
Oh, I lent it to her.
All right, you gotta be more specific. How long did you two go out?
For a year.
Tell me the dates.
This was summer of 2024 up until summer of 2025.
Is that true, sir?
Yes.
All right, when did you loan her the money?
January through
January of what?
January 2nd, 2025.
Do you have let me see the note you had her sign.
It was a verbal agreement.
Verbal agreement.
Yeah.
How'd you loan her the money?
Just Venmo, you know what I mean?
You Venmo'd her?
Yeah.
Do you have your Venmo records?
For particular loans I do, but other, it was just the verbal agreement and I was paying utilities, her 1/4 of the utilities in the household that we lived in. And I have bills I printed out and gave to the court, month by month.
I need those, Jen. Wait a minute. So all the money you loaned her was by Venmo?
No, I just paid on her behalf with the understanding that she would pay her share.
Hang on. Wait a minute.
Your Honor.
Who was living in the, not yet, who was living in the house?
My father, my mother, myself, and me.
So is that true?
That's correct.
So was it your responsibility to pay 1/4 of the utility bills?
I never assigned a contract.
I didn't ask you that.
Yeah.
Did
but
you agree to pay
yes.
1/4 of the utility bills? And did you pay
just
one?
Some payment,
It's fine. Did you pay 1/4 of the utility bills?
some months, yes.
Do you acknowledge it? You did not pay your fair share of 1/4 of the bills?
I would say, but because I'm not working full-time and I'm a full-time grad student, so that's why.
Okay, how much do you owe him?
He made, so he wrote me a letter.
Let's slow down. Let's slow down.
Over $2,000.
Slow down. Slow down. Did you tell her the amount?
There was a demand letter sent in September, and I haven't received any payment.
I know. Did you tell her the amount that she owed you?
In the demand letter, it showed that, Your Honor.
Yeah, do you have the demand letter or did you file?
Yeah, it should be in the file.
So we do everything by M filing now. That's why I asked.
Yeah.
Do you know the amount?
It's $2,228.58.
Did you dispute that amount when you got the email?
What do you mean dispute?
Well, did you write them back and say, I don't owe you that much, I owe less than that, or I owe half of that?
Tried to call him, but there was never,
Do you owe him 2,228.57?
he claims that I did.
I didn't ask you what he claims. I want to know what you think. Do you owe him 2,228.57?
I don't believe so.
How much do you owe him?
I think maybe close to
Well,
the two.
now wait, I wanna just, I say this often, it's so true that the greatest thing about math is there's only one right answer and it's right to the pen. There's no room for discussion. So if you're gonna tell me about $2,000, I would really like you to sit down. And I would like you to figure out to the penny, as he did, he said you owed 2,228.57. How much you owe him? Is that fair?
It doesn't sound like it's fair to me since he did add.
No. Wait a minute. What I was trying to say to you, is it fair for me to ask you to sit down and figure out exactly how much you owe him?
Yeah, it's fair. I can sit down and track down how much I owe him.
Now, you also said property damage.
Yeah.
What kind of property damage?
It was to a TV I had. She had returned it. She took it originally when she moved out of the house, thinking it was hers. After some discussion, we discovered it was my television. She was in the midst of moving in her vehicle. The TV was up against the headboard and it was cracked upon receiving it back. So I said, hey.
When did you buy that TV?
It was given to me from a family member, handed down.
Any idea what the value of the TV was?
I looked on Marketplace, Your Honor, Facebook Marketplace. I said $50. I think that was fair. It's used. It might be a smart TV, but I think with the controller missing and the.
Is $50, is that what happened with that TV?
Yeah, that's correct, sir.
All right, so do you think $50 is fair?
That's fair.
All right, so you guys are only $258 apart, it sounds like. You said about 2,000. And he said 2,258.57 plus the 50.
Yeah.
Oh, the 50's included in that, Your Honor.
I see.
Yeah, it's all, it should be on the first page.
So if you thought 2,000 just for the loan and $50 for the TV's fair, you guys are only about $178 apart.
Yeah, because on the letter, it said that he made payments to the court to get this hearing, so he wants me to pay for that.
Well, he does get to recover that.
Your Honor, I should say for the record, the demand letter was off a little. I rushed it a little. I wanted this off my back. That's the truth. I went back to make sure, the utility bills were right. Well, I looked at the service dates, and for DTE, for example, it's the middle of the month to the middle of the month. It's not just January, for example. So I did all kinds of prorating, I did all kinds of math, and then I came up with some months they're actually less than were discussed.
Did you still come out to the total of 22857?
Yep, and then there were two other loans I remembered that added to that original 2,000 and some change that was in the original demand letter. That's why it's a little bit higher today. There was she went to Minnesota. She needed it was for her clinical placement in Minnesota for her physical therapy school. I loaned her some money for room and board for the few days. And that should be all in there. I got the Venmo picture of that, and then also.
Okay, let's slow down.
Yeah.
Let's slow down. What exact amount do you think she owes you now, including the TV?
2,002.
2857?
58. It's on there.
222857.
5758. It's 58 on the paper.
Okay.
Yep.
2,228.58.
Yes.
And you said he owed you you owed him about 2,000. You want to go back and you want to look, and right now I can give you some time. You can go sit down and say, I think this is too high. It sounds like he did his homework though.
Okay.
If you want to agree to that, I'll be glad to enter a judgment. We'll set up a payment plan and you guys can be on with your lives. If you don't, tell me, I'll give you some time. You go in the back room there and you can do your figures.
I mean, I like to think that he's saying this is correct with the amount, so and I see it on here too. I mean, yeah, I'm fine with making like I said, I'm a grad student.
Okay, I get it, but let's take one thing at a time. Ma'am, I get it. But ma'am, we'll cover that. Nobody wants you to not be able to eat, I promise you. But so you agree, you don't want to go back and refigure anything, right? So you got 2228.58 plus you got a filing fee here of 70 and a certified copy of 1888 more dollars. True? Do you have any other out of pocket?
No, nothing. I printed out a lot of papers. I don't even care about that. Nope. Made some copies, but.
So my math, it comes out to 2316.58. Is that true?
Yes.
All right. Now, ma'am, you're still under oath. Are you working at all?
I am working, yes.
How much do you make?
I make $20 an hour.
How many hours do you work?
I work 20 hours a week, but that's for school. I could be working less a week because full time.
Tell me how much you think you can afford to pay weekly, bi-weekly, or a month?
Honestly, sir, I am in a transition phase of my life. I could only afford him to pay him $100 bi-weekly. That's with my
Okay.
my check.
You're good with that?
I don't want that much, Your Honor. I know she's in a tough spot. I still care for her as a person. I'll be $50 a
That's
month.
great.
But she's saying bi-weekly.
Okay, so yeah, 50 a week, sure. Yeah.
Wait a minute. Bi-weekly meaning every other week.
Right, that would still be.
She said she could pay 100 bi-weekly. You're saying you don't want that much. What are you gonna ask me to have
Is
her?
that a stretch for you?
I mean, what works, I could do 50 bi-weekly, I can do.
50 bi-weekly.
When would you like to start?
I would like to start in the last week of February, once I have my first.
Okay, so that would be like February 27th. Does that work for you?
That works great.
Is that good with you?
Yes. Sir.
How easy this was. All right, where are you going? What are you studying?
Become a physical therapist.
Good for you. Good luck to you. What do you do?
I'm a behavior technician. I work with autism.
Good for you. Good luck to both of you. I'm filling out the judgment and you're all set. Thank you very much. You can go down the hall and get a copy of it. Thanks. Good luck to you both.
Thank you. What's my next steps, Your Honor?
She's gonna pay you that.
Okay.
You
Before it handles it?
Well, no. She's gonna pay you directly.
Okay.
And now if she doesn't pay, you can move to set aside the installment payment order. You could still, I'm just telling you, you could still garnish not bank accounts and tax returns, but doesn't sound like you're gonna do that. So as long as she stays with the payment plan, there's nothing left. She's gonna pay you direct. You're gonna pay him direct, right?
Yes.
Have a paper trip, no cash, checks. Okay? Thank you.
Appreciate it.
Thank you. Good luck. Go down the hall, both of you, get a copy of this. Michael Mawafi versus Carlos Medina Cartagena, 2504545. All right. I know I covered this with you before, Mr. McQuithy. I'm going to ask you to take your hat off. Your name again, sir.
Michael Mawafi.
Your name again, sir. So you both understand. I don't think I covered this with you. I might have before. Can you turn that podium toward me a little bit better? It swivels. There you go. A little bit more. Thank you. If you proceed in the small claims division, you're giving up certain rights. You're giving up the right to appeal my decision, to hire a lawyer, to demand a trial by jury, to collect in excess of $7,000 to the extent that you're entitled to it. If you waive those rights, you're going to stay here. If you want to exercise any one of those rights, just tell me. I'll remove the case to the general civil division, in which case you can hire a lawyer, demand a trial by jury, collect in excess of $7,000 if you're entitled to it, and appeal my decision if you don't like it. You understand everything I just said, Mr. Mawafi?
Yes.
You understand everything I just said, Mr. Medina Cartagena?
Yes.
Do you wish to give up those rights and proceed here, or do you wish to have the case removed, Mr. Mawafi?
Proceed.
Mr. Medina Cartagena?
Proceed.
You waive those rights?
Yes.
You waive those rights? Yes. Mr. McQuithy, your name?
Kurt McQuithy.
Is he your witness? That's what I mean. I'm going to ask all of you to raise your right hands. Mr. McQuithy, I need to see your right hand, please. You solemnly swear or affirm the testimony you'll give in these proceedings will be the whole truth. So help you God. Mr. Mawafi?
Yes.
Mr. Medina Cartagena?
Yes.
Mr. McQuithy?
I do.
All right. Have a seat. You guys can stay there. Just tell me what happened now. You brought the contractor. It says defendant was hired contracted to renovate 2 bathrooms, raise an existing vanity, and paint it white for both bathrooms. He was paid through Zelle, $8,000, has since abandoned the project. I sent a demand letter wanting to resolve this matter out of court. However, defendants continued to ignore my attempts to resolve the issue. Did he pay you $8,000?
Yes.
What kind of work did you agree to perform for $8,000?
It's 2 bathrooms, the guest bathroom, and the guest bathroom and the master bathroom shower.
So you were doing 3 bathrooms?
No, we first agreed with 3 bathrooms, but then it changed because they didn't want to do the basement.
Wait a minute, you did 2 guest bathrooms?
No. One guest, I didn't do the guest bathroom yet, but we agreed to do 1 guest bathroom and the master bathroom.
1 guest bathroom and the master, or just the master shower? Did you guys have any contract?
We had a estimate that I sent them an invoice.
Let me see the estimate.
I think we gave it to you.
Okay. Okay.
And through the invoice.
So it looks like all right. Did he do the guest bathroom?
He did not.
Did you do the guest bathroom?
I didn't get to start it, no.
Did you do the master bathroom?
The master shower, yes.
And
Your Honor,
yes,
he did, but he did not complete. He started, did not complete. I agree. I sent pictures to the court there.
do we have the pictures, Jen? I'm so sorry.
Who sent the pictures in?
Mr. Defendant.
Where did he send them?
To the court, email, Jen.
When did you send those, sir?
I sent them today, this morning, once I got here.
I haven't checked my email, Your Honor, because we've been on the bench, so. Oh, he sent them at 9:58, so I've not even opened it. I'll get them printed.
So I just want to make sure I understand. The only work you did was on the master bathroom.
Yes.
Did you complete it?
Completed the shower. Yeah.
Was that all the work you were supposed to do in the master
The
bathroom?
only thing left was the shower door that was ordered after. And when he ordered it, it took about like a week, so
So the shower door was not installed.
not his fault.
You completed the master bath shower,
Yes, sir.
and you did not do,
And I bought all.
wait a minute, slow down. You did nothing in the guest room.
No, didn't start.
All right, good enough. How much did you pay for materials?
I sent the receipts to her, about roughly 1,700 plus the $300 of.
Did you just send those this morning too?
Yeah, send it all to me. But it was the first 2,000 that he sent me was for the materials because he said he didn't have a chance to buy it. So I made him a favor. It's not part of the contract or the invoice. He said he couldn't buy the material, so I did the favor to buy it for him. The first 2,000 was to purchase the materials which he has in his garage right now.
All right.
All of that.
So you spent $2,000 in materials, you did the master bath shower, you didn't do the guest room, and you didn't install the shower door, correct?
Yeah.
And do you dispute his statement that he spent $2,000 in materials? At least did he provide you with invoices to that effect?
He did not.
And you just said you sent him this morning?
Send him all the receipt from Home Depot, everything I spent from the shop, to the bathrooms, to both bathrooms.
So after you did the master bath, and I'm sorry, Mr. McQuithy, I am gonna have some questions for you. After
Yes, sir.
you did the master bath shower,
Mhm.
why did you leave the project?
It only took like about 2 to 3 days, a week. The first couple of days that I didn't show up, I texted him. I've been texting him all the time, and I texted him I wasn't feeling good for the first couple of days. And then I told him order the shower door, and then he called me. He said it's gonna take like about a week. So during that week, I started working in another project, and then I was gonna get back to him. I never told him I was not gonna come back. And then he sent me a letter demanding after 2 weeks. It wasn't even a month passed by. So he sent me letters after 2 weeks and just kind of harassing me.
All right, let's slow down here.
Gonna take me to court. So that kind of took my energy down.
When did you start working on the project?
It was end of September.
September 26th.
9.
September 26th, September 29th. Okay, do you agree with that?
26th.
All right, one says the 26th, one says the 29th. And what days did you work on the project to complete the work that you described that you completed?
That full week.
So you're saying you worked there until, I don't know, maybe till about October 5th or 6th?
Probably a little bit more than that.
How many days was he there?
In total, he was in my house probably about 3 days.
No. You put I'm sorry. He made an oath. You can't lie. You can't.
How many days do you think you were there?
I was there the full week. I was there the whole week between me and my workers. We was there for the whole week. I had a plumber because we had to remove a plumbing. We had to remove a vent that was in the middle of the wall, which I didn't charge them extra for that either, for removing an extra vent.
Can I ask you a question? They gave me some invoices here. One says bathrooms, state ordered September 16, order total 1252.77. Another one says purchase September 17, $75, 375 item quantity 20. Another says $300. That looks like a payment.
That's the trash pickup that that I paid for. That's part of it.
Then you got another one here for $167.52.
Those are extra materials that I had to buy.
And all the materials are in his house?
Yes, well, the second bathroom as well was in the house.
When did you inform him you didn't want him back there?
Your Honor, I did that. What happened was he started the project well. He came, he guided the house, the bathroom, started the work. And I remember he sent his guy, I can't remember, it was a Friday. They came and worked until 10 p.m. And I was okay with that. After that, I had to buy the shower door. I did order the shower door. I told him, they told me it might take a week. And he said, let him know when the dog came. So the dog came, I texted him, he said he was gonna come. Then he told me he was sick. And I said, man, just let me know when you feel better.
Well, from the time that you got the door.
Right.
That it arrived at your residence.
Yeah.
You notified him, he said he was sick.
Yeah.
Did he ever come back to the property?
Never came back.
What day did you tell him, I have the door, I've received the door?
I have to check on my text, but it was probably a week, September 26th, probably before the 10th of October.
Okay. And when did you make up your mind? So after you called him, he never came back?
He never came back.
Did you call him again?
Yep, I was calling and he kept telling me he's gonna come, he's gonna come. So what I did, I sent him a demand letter, giving him 10 days.
When was that? And do you have a copy of that letter with you?
Yes,
What is the date?
10/15/25.
Did he send you that letter?
Yeah.
Did you go back there within 10 days?
No, I called him.
And what'd you say?
I spoke to him and kind of scheduled to go back.
No.
But he was threatening me to take me to court, so my energy just kind of, if he's not taking me to court, just take me to court. Because it was not feeling good going back after all the threats of taking me to court, so. I'm here, I'm not here because I don't want to pay him, you know, I'm here because he wrote in the letter that he gave me 8,000 and I never, you know, like I suddenly disappeared. That's what he wrote. I'm not here because I don't want to pay him. We can make an agreement of payment, that's fine with me. I even text him, I could reimburse you for the other bathroom. He knows that, and he said, that's absurd, you don't have to do that. I text him to reimburse him. I'm here because in this letter says, I paid him $8,000 and I haven't seen him ever since. So in other words, he paid me and I left. I did work there. So, you know, I feel bad because he's saying that he paid me, in other words, and I never showed up. The letter that he sent me, he's accusing me of scam by the law of Michigan. That's what so it doesn't feel right.
Okay.
Yeah.
Let me ask you a question. Mr. McQuithy, you're under oath.
Yes, sir.
Is the shower door installed yet in that bathroom?
As of Saturday, Your Honor, no.
Did you go and look at the property? You did, didn't you?
I did, Your Honor.
Well, how much would it cost if the plaintiff, Mr. Mawarthy, was going to hire you? And just in labor, how much would it cost for you to do the guest room as described in this estimate from the defendant, from Mr. Medina, Mr. Medina Cartagena, and to install the shower door in the master bathroom? How much would it cost you just in labor? How much would you charge?
Your Honor, I'm looking at probably about 2,500 to finish up what he's got there, just in that bathroom, labor wise. I have it listed down and itemized.
Slow down.
Yes, sir.
All that's left to do is install the shower door in the master bathroom. Do you agree with that?
No, Your Honor.
Did you not agree with that?
I
I did not.
What do you think needed to be done in the master bathroom?
So the master bathroom, the walls, they're not, it did not smoothen the walls. It did not, at the end of the shower, there's a shelving that needed to be done. He did not do that part. And also he did not raise the vanity and paint it white. And also he took the back wall. You know how you have the vanity that goes, that piece that goes to the wall? He took that off. His guys, when they came, they took that off and they never came to finish. So there's several things that have not been done. And also on the shower.
I want you to say that again. He didn't smooth the walls. You're saying he didn't sand the walls properly before he painted them?
So the walls are not sanded.
Okay,
The shower door is not there.
not installed.
The closet.
Well, you got it. You got the shower door though, right?
Correct.
Okay, shower door not installed. He didn't smooth the walls, so he didn't sand the walls and paint properly is what
Corner
you.
wall, not all the walls, just the corner wall where the metal ends of the shower. It's not all the wall.
Your Honor, it is the ceiling. It is the ceiling.
Okay,
And the wall, where the, and I don't know how to describe it, there's one wall there. And also the closet has not been done, the floor, the shelves, and the framing of the closet. And also the raising of the vanity and painting that white.
all right. And how much do you figure that would cost for you in labor alone, Mr. McQuiffy?
Upwards about $2,500.
Well,
Your
did you
Honor.
give him an invoice? Did you give Mr.
I did
Mawarthy,
not. I did not.
Did you tell him how much it was gonna charge him? You were gonna
I
do
did.
charge him?
Yes, Your Honor, I did. I did kind of itemize it at home and write down. I took pictures.
All these things you just heard Mr. Mawarthy mention.
Yes, sir.
Mawarthy, I'm sorry. All these things you just heard Mr. Mawarthy mention, were they all included in your labor cost?
Yes, Your Honor.
And you're saying it was about $2,500 just for labor?
Yes, Your Honor.
And how much for the labor for the guest room?
The guest room, I know nobody had touched it. I did look at it. He told me they had an agreement on it, and he said that he had figured the guest room work to be about 1,800. Just to do the tile work there and install
Hang
the
on,
door.
slow down.
I would
Hang
consider that
on
to
one
be
second.
about correct.
You agree that the price to do the guest room would be about 1,800 just for labor?
That's what.
Yes, Your Honor.
Okay, hang on. And do you agree with him that it would still take $2,500 in labor to complete the work on the master bathroom?
No, sir.
Yes, Your
How much
Honor.
do you? You gotta look at who I'm talking to. Right now, I'm talking to Mr. Medina Cartagena, okay? Just bear with me.
Oh, I apologize.
You said 2,500. You said 1,800 that you think, but that's just what Mr. Mawarthy mentioned to do the guest room. I'm asking you, how much do you think it would take in labor to complete the master bath?
So for the shower door, what I charge is $350 to install, just to make the mat. Whatever's left, the little paint around that shower that's left, because I left it already mudded and ready to sand and paint, which is a little bit of thin, it's nothing. And just to trim around the closet, that's it. There's nothing about shower vanity or nothing like that. So we're talking about.
Well, you were gonna put up the vanity and paint it. Wait. Were you not gonna put the vanity?
No, it's not in that invoice. It's not in there. I gave him an estimate when I was gonna get the basement. When I was gonna get the basement, the 3 bathrooms, and then I told him I'm gonna adjust something because you're only gonna give me 2 bathrooms.
All right, hang on a second. Let me double check something, please.
Can I say something, Your Honor?
Not yet, just let me, wait. I want everybody to wait. I want to find something I just had in front of me here. Okay, just give me 1 second. This is what he said on the master bath. Demo existing shower and extending 60-inch. Did you do that?
That's what I did.
Add new shower valve, add shampoo box. Did you do that?
It's in there, yeah,
Install shower door. You didn't do that?
that's where it needs to be.
Install one light in the shower. Did you do that?
So,
Where's anything in here about doing these other things, the painting and smoothing walls and painting the vanity white and
yeah, we're
install?
talking about the shower, we're not talking about the full bathroom. This is a shower renovation, not a bathroom renovation.
Right.
It's two different.
Well,
things.
wait, I want you to answer this question.
Yes.
Where does it say it on this invoice that he's gonna do any of these things you just mentioned, other than install the shower door?
On the invoice that you have, I do not have that. There was one that I had submitted to court when I was here and it had my writing on the things that we had talked about that he was gonna do.
He sent you this invoice. It says on September 22nd.
No, he did not send me anything.
You should have, or everybody has,
But
And it said due October 22nd.
he did not send me anything.
You didn't receive this?
I did not receive all the documents
All-
that he has.
all-
Wait a minute, let me look at this other thing. Hang on. When I go back to the estimate he gave you on August 20, let's do that on the master bath. Demo existing shower and extending 60-inch. He did that, right?
Yes.
He added a new shower valve and shampoo box, right? Did you install two lights or one light in the shower?
one light.
Did you add two water supply?
No, it's just one.
Wait, did you change the exhaust fan and mirror update?
That's not, because the thing is that the first estimate was something I gave him with everything, with the basement and everything. When he decided not to do the basement and the bathroom, I made some adjustment just to get the job, and I told him, okay, so let me fix something for you and give you a good deal on the guest bathroom as well for 1,800. I never charge 1,800 for a full renovation, shower, demoing tiles and anything like that. I try to work with him to get those, at least those two bathrooms. And then I made some adjustment. Every invoice, every result.
So wait a minute. Do you have a copy of these estimates in front of you? Do me a favor, if you ever come to court here again, send your documents long before 9:30 on the morning of the hearing. There's a discrepancy in the estimate of August the 20th and what you invoiced him for, according to this document. I know you said you didn't receive it on September 22nd. Why?
He should have it because all the receipts that I send him electronically goes through that invoice. So he should receive it.
When the world's a shampoo box.
It's in the picture. It's a niche. We call it a niche.
Your Honor, if I may say, the backwash of the vanity, backwash, they took, if it was not in the agreement, then why did they touch it? All the way from the beginning where the mirror goes, they took all that piece.
Did you?
I didn't touch
Yes.
nothing. The only thing I did was send a countertop guy because he said he wanted to change the countertop. And I sent you a countertop guy. And you say he was charging you too expensive. I sent him a countertop guy because I don't do countertops. And he was gonna give him an estimate for the granite and everything. I don't do countertops. So that's the only thing I've sent him for that.
And in the agreement,
Guys, something changed because in the initial estimate, it had things like install new vanity double sink. Are you
Yeah.
telling me that was in the estimate, but then you
No,
pulled
that was
out?
the estimate, what he wanted before.
You
He
adjusted.
wanted to change, but then
Why didn't you send him a new estimate?
he wanted to save
Why don't
money.
you guys, you're gonna have to, this could have been so simple. And I'm sorry, this might not be your forte, but you better make it such because you should have done another You should have done another
I
estimate. You
did,
didn't
I
do
sent
it,
it to him. That's the last one.
but he didn't invoice you for it. His invoice does not include that.
Now, did he open his estimate, his emails? That's another thing, because I send it to his email, I don't send it by paper, I will send it to him, once it creates from estimate.
You agree that you owe him at least $1,800 because you didn't do the other bathroom,
I
right?
know that, yep.
And you agree that you have all of the materials, right?
I have the material.
So he doesn't owe you.
For the material, he does not owe me.
And how much do you figure you gave him for the materials?
I gave him $2,000.
So we agree at least now that he owes you $1,800 at least, and that you keep the materials, right?
$1,500 I paid, yes. I agree with that.
But you keep the materials, so you got your money for those, right?
Yes, and he said he spent $1,700 with materials.
I'm sorry?
He said at the beginning, he only spent $1,700 with the material.
Yeah.
17 plus the trash removal.
Wait a minute. You got the materials. He owes you $1,800 for the guest room, and now we're gonna figure out what he owes you for the master bed.
Correct.
Why is there, I want you both to come up here and I want you to tell me why there is this discrepancy between the estimate and the invoice. Would you stick? And this one. This is hers. Yes, you can just say those. This is the documents they just showed me. Small claims cases, always fun.
To their page.
Two below it. I don't mind them. I'm just.
This one?
Yes. So why do we have a discrepancy between an estimate that was sent on August 20th and an invoice that was sent on the second stickered page there? I believe that was September, what, 20th? Why do we have this discrepancy between the original estimate and the invoice? Because the invoice doesn't mention anything about a vanity. Mentions nothing about a vanity. You guys can back up to the podium. I need you buy a microphone. Why is there that discrepancy?
Your Honor, like I said before, this is an estimate that he wanted at the beginning, and then it changed. It's like 2 water supplies, it was gonna be 2 showers. And then he changed, he wanted just 1, so a lot of things changed. So I sent him the new invoice, which was the other.
Well, that's different than an estimate.
Exactly, well, estimates what you want, what are you planning to do for all the work, including the basement, the floor basement.
Why did you touch the walls and do anything along those lines? If there was nothing in that invoice that you indicated you were performing work for? Does that make sense?
How's that? Sorry.
You said the only thing you did, only had to do. Is there a phone going off in here?
It's like it's a horn down the hall.
Okay, thank you. Sounds like, just wait.
Fire alarm.
Oh. Thank you. I forgot my train of thought. I'm sorry. Give me 1 second. Something changed in between the estimate and the invoice. He says only, you say he didn't do all these other things.
So also, the 2 water supply, he was raising the vanity, and right now there's only 1 sink. He was gonna make sure I have 2 sinks. So the 2 water supply, that's where that came from.
But I'm just telling you that he changed on the invoice. The language changed. The language on the invoice says nothing about work on a double vanity. It only has 1 light in the shower.
I personally, when I send the invoice, I'll make sure that's the reason why I like him to sign it. When it's an invoice that we're about to start the job, he doesn't sign, he didn't sign.
Yeah, but why didn't you ask him?
This is an estimate. This is signed by a pen, not by him, by the invoice.
Yeah, but why didn't you, just future advice.
Yeah, no, absolutely.
Make sure your documentation is in order and you get a signed copy that you keep, a hard copy that you keep. For your. What was that? Jennifer, was that?
I apologize, Your Honor. That was my work phone.
Oh, okay, no problem. How much do you think you owe him? Yeah.
1,800 for the guest bathroom. The shower door 350, and I'll say roughly finishing that work, about $800 with the shower.
800, including the shower door or in addition?
Not the shower door, I mean, the rest of the details that he's saying he's not included there. It's very minor detail, so I'll say like a day work. Now, if he wants to add.
Wait a minute, wait, I just want to make sure I'm understanding you though.
Oh, yeah, 350 for the shower door, and let's say 500 for the rest of the details to finish. To complete what I was supposed to do. Now, if he wants to add the vanity and all that, that's something he's adding.
No, I'm not adding anything, and also.
Even if he wants to,
Can I-
it's not gonna go to $2,500.
Your Honor.
As a contractor, to be honest.
You're on the top where he put all the tiles on the top. And the whole thing I need.
It's called
So that will have to be done.
caulking.
So that will have to be
It
done.
doesn't cost $2,500 for the caulking going around. So
Can you hand me that paperwork back up, gentlemen? Is it just me or do you feel like in retrospect, maybe you jumped the gun a little bit? I've dealt with contractors. Contractors, no disrespect intended, they start other jobs. They start other jobs. We know that they're going to start other jobs. I mean, I knew that 35 years ago, 45 years ago. I'm not saying it's right. But you kind of maybe jumped the gun a little bit and didn't let them finish. By the same token, I'm not sure that you shouldn't have gone back earlier. We told you had the door installed. Where do you take a shower? In that room, not the guest room, right?
Take it in the guest room. I've never had the shower in this work.
Well, I mean, he's got a master bathroom. That's where you'd like to take the shower, isn't it? So he's waiting. He doesn't have a shower door. Yeah, but
he says it don't work, but it works.
The shower door.
the shower.
I'm saying it works. He's saying it don't work, but it does work.
I'm saying the apparatus do not work. I'm not gonna take a shower when he's no door. What I'm saying.
Do you have anything else to add, Mr. McQuiffy?
Your Honor, the $2,500 included raising the vanity. But I do not have anything else to add. No, Your Honor. And the top of the tile there at the shower, there is about an inch gap. It's a little more than caulking, I believe. A little bit of drywall work on the ceiling there. He did a good job on a lot of the stuff he did. It just looked like he just wasn't able to finish.
Don't you think you kind of kicked him off the project a little early?
Oh, I gave him time.
Well, you didn't really, because you were at September 26th, and I think, based on what I've heard, he said the 29th. I think you spent a week. You said 3 days. I'm comfortable with saying 5 or 6 days. So he didn't finish that work until the 5th or 6th. Wait a minute, just let me finish. And then you ordered the shower door, and you got it a week later. So let's say that you called him on the 11th or 12th, and he's not out there by the 15th, and you're writing him that letter. What date was the date of that letter?
15.
I mean, I don't know.
Because I figured all he would have done at that point, we say, hey, Mike, guess what? I'm not able to do.
Yeah, but nobody likes to be threatened, right? So I can understand. I mean, I'm not going to assign fault on that. He could have been a little more diligent. You could have been more patient. That's my feeling on it. if the shower door was ready to go on the 5th and you hadn't heard anything and you called him several times and he didn't respond to you, I still think the 15th to start sending out threatening letters is a little bit too quick for me. Mr. McQuithy here says it's going to take $2,500. I got to tell you, I truly believe, Mr. Malafi, that you think that you're right. I find you to be credible. I find him to be credible too. He's saying an extra $850 on top of the $1,800, $2,650. I don't see where the invoice, it's clear to me you guys had other discussions after the estimate was done, but before he agreed to perform the work, it was just horribly documented. Everything being told, the $850 plus the, I'm sorry, $1,800 plus $850 is $2,650. I'm rounding it off to $3,000. That's what you're going to pay him, and I'm going to hope you're going to pay him today. I hope.
I don't have the full amount.
Well, okay.
But I can do it in 2 payments.
Okay, and you have a $70 filing fee, right, sir?
Yeah, but also for serving.
Yeah, I know. I want to ask you about that. How much did you pay for process service?
I think it was.
Well, let me double check. Maybe they have it in here. Sometimes on the proof of service. What else, other costs would he have here? Oh, he's got $69.25.
Yes.
Is that right? Were there any other out of pocket?
No.
For the letter.
21 for the letter? Jennifer?
I'm showing he paid the 70 and then the process server.
Okay. Does that sound right to you or not?
It will work. It will work.
So you're gonna get $3,139.25. Now tell me when you can pay him this.
To pay him between this week and next week.
So
Give me like 2 weeks at least. I don't know.
how about if I say installments of $1,500 by February the 24th, balance by March.
If I could pay it in full before.
I understand. You strike me as an honest guy too. Both of you do, to tell you the truth. Balance by March 3rd. Can you do that?
Absolutely.
I've signed the judgment. I really wish you both well. Good luck to you, sir. Good luck to you.
It's directly to him or?
Yes, you pay directly to him.
Okay.
Does anybody need any of these documents? I don't think you do you? I do want you both to go down the hall and get a copy of the order though. Thank you.
Appreciate it.
Have a good day. Good luck.
For your time.
Thank you. You're welcome.
Thank you.
Nice to see people leaving a small claims hearing that don't want to throw something at me, right, John? All right.
Every day in the USA, people find themselves in court.
It turns out when they weren't there.
Good morning. Good morning, Ms.
Hi,
Lovell-Lucky.
I'm so sorry. Hi. Yes, Miss Lovell-Lucky here.
All right, thank you. You are appearing for arraignment purposes this morning, and you're appearing with Miss Mistily. It does appear that you have 2 cases this morning, so we're going to take them one at a time. Okay.
Thank you.
So the first case is to.
I'm so sorry. Can I interrupt before we start? It's pretty important that I do. I apologize profusely. I had trouble with this getting onto the Wi-Fi for being late, but I'll need even for arraignment. Janet Misley, I've already had her. I had her last time. And she made a lot of
She's
promises to me. I know. And she made a lot of promises. Can you hear me? She made a lot of promises to me that instantly did not happen. And also joked around with the judge about me and found me cute and mentally unstable. Also, she chose the pills she takes to give me. So I can't use her in any way, shape, or form for arraignment. Can you please take that into notes right now? I don't even want her hearing my voice and getting any of my personal information. I saw her at Walmart twice with the same judge. They must be married.
Oh my gosh. I am not married to a judge, ma'am, or an attorney.
Her speaking right now shows for itself. That's very illegal that she's actually speaking to me. Just for the record, that's code 9432. It starts with, oh, you looked at it, huh? Online. It starts with 000-94000-444-555. Sorry, Magistrate Rogers, I apologize. Janet, okay, thank you. All of a sudden, she was all I could see on my screen, and she was making faces at me.
All right, so I'm hearing you. So what we're gonna do today, is we are gonna set your bond, okay? And then we can schedule your arraignment, okay? But we do need to set bond this morning, okay?
Yes, I thought I already had one. So sorry.
Pull up your case.
I apologize.
We're gonna pull up your
Janet,
case. We're gonna see where you're at.
I'm sorry, Miss
So-
Rogers, Magistrate Rogers. Janet Misley is making faces at me and being very demeaning and rude.
So
I
right
do
now,
not want Janet
we're gonna-
Misley in this conversation. Now, by my legal laws, I have the right to not have her present. And I do not want Janet Misley, the woman who dates the other judge and sees me at Walmart and says that my hair
So,
looks
ma'am?
bad. And her,
Ma'am,
listening.
I hear your concerns, and we're doing our best to accommodate your situation right now, but we have to get the bond set, like I said, and then we can reschedule and make sure that those needs are being met, okay? So just one moment.
I apologize. I didn't know if you could see her on the screen or not. It could be just on my end. Is it going to be the same PR bond, or is it going to be raised since I'm in the same place that I was trespassed or arrested for being trespassed?
We're pulling your case up right now, so just one
Thank you.
moment.
Alrighty. Yes, the address that I'm trespassed for is the address I live at. And that is what they call it. It's called missing your variance here. And it's just a legality term, a federal term, because this is a federal institution that I've argued with them for. I'm so sorry. That is partially owned in part by someone, but the rest of it's the federal institution.
Sorry, ma'am, so
So-
if you could, just, ma'am, could you stop?
What
for
I
just one
wanted to
moment?
say
So I
is it's
apologize.
the
I'm gonna-
now see
I'm gonna
that's
have to
Janet
mute you if
Misley.
you don't stop. All right, so just one moment. We are going to set your bond, okay?
Like I said,
So,
the
right, so ma'am, I muted you. We need to get through this, okay? On case 266386 SM1, we are going to set a $1,000 PR bond. Okay? Ask her to unmute. Right, so I've asked you to unmute.
Miss Lovell Lecky, would you please
trying to
just
use it
focus
like
on me?
I'm trying
Thank
to
you.
use it like
Hold
a
on.
touch screen. Now,
Okay,
please
thank
quit
you.
speaking to me that way, ma'am. I don't know your name.
I'm Magistrate Rogers.
Hi,
So,
ma'am. Hi.
ma'am,
I thought the
Hi.
person right there was speaking to me. Oh,
we're
hard to
training a
communicate
new
that way.
magistrate,
I should
So,
use my
I'm
phone. I
sorry.
apologize. I'm on my new
No
laptop.
worries.
So.
That's okay. You said that your address that you're at right now is at the Goodwill Inn, is that right? We just need
Yes,
to
ma'am.
verify that.
Yes, ma'am.
Okay, so you are currently residing there, and is that where you can get your mail?
Yes, it is. 2943 Keystone.
North
Key.
Keystone. Yeah.
Oh, yes, it is. I believe it is North Keystone.
Yeah.
You would know
Yeah,
better.
we got that.
Keystone Road.
So no worries. We are going to mail you a notice of a
you so
pretrial
much.
conference in the misdemeanor case. And in the felony case, it will be scheduled for a couple of other processes. But first of all, we want to get you an attorney,
ma'am, may
and
I
we want to
speak?
do that right away. Yeah,
Okay.
go ahead.
Two things. Being that
Okay.
you are the magistrate, I wanted to say thank you so much for speaking with me separately like this. Since we've gotten
No
this far, and I can see that there is a judge there, unless that's just,
Yes.
is that the administrator or is that the judge?
She's also a magistrate. That's Magistrate
Okay, I
Cantella.
apologize. Okay, so what I'm saying is
No
that's two witnesses and the stenographer witnessing that
Right.
I'm in the Goodwill Inn on my own
Yeah.
laptop in the same address that you're going to set a court date for, that I'm not
Correct.
trespassing.
That's exactly right.
Mhm.
But we want to make sure
Can
that
we
you
s-
have an attorney.
I was wondering if we
So
could
have
have
you-
a sidebar extenuating circumstances, if that could just be read.
Okay, well, for right
Please.
now, I just want to make sure that you get an attorney, and we are going to mail those notices to 2943 North Keystone Road in Traverse City.
I would like William Burdett.
Okay. We can't guarantee that Mr.
Thank
Burdett
you.
will be assigned, but we'll do our best to get that
All right,
information
then.
to the clerk that assigns the attorneys. And Mr. Burdett will be in touch with you within the next week.
There is another man that I can't work with as well. Oh my, I don't know if I remember his name. I'll have to look it up. I
Okay.
apologize.
If we'll look and
It's in
see who
record.
if you've had.
Yes,
Right.
thank you so much. It's on record, and now
Well-
Judge Peters should be on that list as well.
Okay.
Can you please
So
make
for right now,
a separate note about that? And Janet
Yes.
Misley's back.
it's okay. We're
Yeah.
all set with you.
The
Ms.
attorney that is
Lovell
not
Lecky.
mine, that is snapping her head up and down at me.
No worries. She's not doing that. She is working on another case right
How
now.
would you know? I'm
So-
staring at her. Miss Rogers,
can-
I find you.
Yes,
I find that you're being extremely rude. It's
I'm
actually a
sorry.
violation of my rights for you to talk to me that way.
Okay.
And no, it is my right for her not to be there staring at me, considering she's dating the judge that's on my paperwork, and it was on my last
For
paperwork.
right now, Ms. Lovell Lecky, we don't want to say anything more. We're on the record. So
No,
we
I'm
don't
saying
want you
that
to say
out
anything
loud
more.
the same way I'm saying that you're not giving me my civil rights and my human rights right now. And
Okay.
also you're treating me in an unapproachable manner, and also allowing
I'm sorry that you feel that
Janet
way,
Misley,
ma'am.
who I've asked not to
We're all
have.
set for this morning. So you need to just
I'm sorry.
wait so you can speak with your attorney, and we'll see if Mr. Burdett is available, okay? Thank you. You are all set for today.
I hope you heard what I said. Other magistrate, judge, I remember you, ma'am, and Miss Misley. I tried to put it on record, but it looks like the courthouse is somewhere that she works. Also, the arresting officer is her niece for the last 5 arrests.
We've
Thank you
referred
for
your case
listening.
over to an attorney. You're very welcome. All right. So at this point, we are all set. You should be hearing from your attorney within the next week, okay?
One more thing, ma'am. Is this about both cases? One, a trespass case on the place I'm living at, and then two, the second, whatever, where your Miss Lee's niece came to punch me and attack me?
It is for both your cases, yes.
And what is the date and time?
You should be hearing from your attorney within the next week, okay?
I don't have a phone. I need more information than that. And I need to make sure you have the correct email address.
Okay, what is the email?
It'll be, I wonder if you have it on file. I don't know. It's one of two ways. It's probably starting with a L. Am I right? LOVELL. Janet Misley. Code violation 4144, 4144, 4144, 93222. Army Code violation, ma'am. I chose to work with the public and not go to the other attorneys who are Chamberlain. Thank you. Thank you,
Ms.
ladies.
Lavalleja, we are all set this morning. Thank you. So I'm going to,
Yes,
you're more
ma'am.
than welcome to leave the meeting, okay? Thank you.
Every day in the USA, people find themselves in court.
.042A, and that is people of the city of Southfield versus Purvis Brothers. And then we have case number 22S00177SM, people of the state of Michigan versus Purvis Brothers.
On behalf of people.
Good morning, Judge Johnson, Jacob Schwartzberg, P 3769 on behalf of Mr. Brothers, who's on video. Mr. Brothers, would you please tell the judge your first and last name?
Purvis Brothers.
All right, so Mr. Brothers, you're here for a show cause hearing for failure to pay fines and costs on the city case. And in that matter, it was an allowing an unlicensed driver to drive. And it was alleged that you failed to pay the fine of, looks like it's now $506 pursuant to the court's order to pay. And so you're here today to show cause why you should not be found in contempt of court for failure to pay. And we had adjourned that particular matter for you to pay in full. So I don't see any receipts showing that you paid. So okay, so what do you mean you know?
Oh, I'm sorry. Your Honor, if I could get put on a payment plan or not get out of this recovery, I can put like 300 on it. March 9th, as soon as I get out of here. I just gotta get a hold to my belongings.
So that brings us to the other matter before I deal with that, which is the state case, which I believe Mr. Schwartzberg, were you on the city case? I don't think you're on that one. You're on the state, which is a violation of probation.
Violation of.
Yeah, that's for domestic violence. And so when we were here last time, that got adjourned because the defendant was in Christian Guidance Center in Detroit. And we had adjourned it for the probation officer to call and create some type of report, which we do have. And the allegations here were, let's see when they date back to. So the allegations for violation date back to October 31st, 2023, when it was alleged that you had failed to report to probation, failed to attend the HEAL program as directed, failed to complete your alcohol and drug screens, failed to pay fines and costs as directed. And then let's see, and then it looks like April 24th, okay, 2024. That might be the most recent one. It was added on also to those allegations that you failed to complete your community service, failed to verify that you were employed, failed to abide by the no contact order pursuant to a new incident report, and failed to verify that you were in anger management and failure to clear up your outstanding warrants. So those are the allegations. And of course, you have a right to have a full hearing on those, or you could plead guilty after having spoken with your lawyer. So I guess I'll ask Mr. Schwartzberg, what would he like to do on this?
Brothers would, please guilty, pleading violation, Your Honor.
Okay, and he did write the court some kind of letter that we got on the 9th, which was a couple days ago. Oh, not her, somebody, Miss Craig.
I haven't seen any letter.
Oh, yeah, it's in the file. She basically makes a full statement, which has nothing to do with this probation violation. So, sir, is it true that you wish to waive your right to a hearing and plead guilty?
Yes, plead guilty. Yes, Your Honor.
Anybody force you or threaten you to waive your right to have the hearing?
No,
Anybody promise anything?
no,
And you're waiving that right freely and voluntarily after talking to your lawyer?
yes,
All right, so it's true that you had failed to report to probation, failed to attend the HEAL program, failed to complete alcohol and drug screens as directed, failed to pay your fines and costs off, failed to turn in proof of community service, as well as picked up a new case, which would have violated the no contact order, and did not verify that you attended anger management. And then there were some outstanding warrants as well that you did not clear up. Is all that true?
yes.
Second, Your Honor. Number 6, you didn't mention, failed to
Verify employment. That's true too, sir?
Yes.
All right. And that's also a sufficient basis here for the plea. And I will accept it, finding that this plea is freely, instantly, voluntarily, accurately, and knowingly made. So, I don't really know what the excuse is here, sir. Looks like you were on a status, probably either, I'm assuming it was domestic violence diversion status, but if not, it was likely HIDA or something. Let's see what it was. Yeah, it was a spouse abuse diversion. So what happened? This just got away from you, huh? Back in 2020.
Yeah, I was just juggling with 2 probations, like the case that I got now, which I'm getting done with. That's why I'm in here. Just juggling with 2 probation, you guys, and then Wayne County. It was just hard to juggle. So just trying to get everything behind me now that I got a daughter and everything. Just time to be a man, Your Honor. That's it.
How do you have an 8-month-old daughter with this lady who was the alleged victim of this case when there was supposed to be no contact? How does that happen?
Just fell in love. I'm sorry, Your Honor. I don't know. It's just-
Okay. Well, that don't help that does not help your case. That's
know.
ridiculous. Fell in love means you didn't even get this case in the first place. So I don't even know how that's possible. This is domestic violence. And we gotta take this stuff seriously. Because these type of cases is what ultimately, as they progress, could get people hurt and killed. So we don't joke about these. What did you want to say, Mr. Whisper?
I retract that, Your Honor. I have nothing to say.
And then we get a letter from her talking about she don't have any ongoing fear.
She wrote a letter.
And she don't think he's a risk to her safety or the safety of a minor child, which isn't even supposed to be here. because they're supposed to be apart. Oh, she said he's appropriate behavior, accountability, sincere in his efforts to avoid conflict or avoid the criminal justice. Couldn't be that serious because he didn't do anything here. How serious can I believe this letter at all? Says you didn't do a thing that we asked you to do on this probation. Talking about you got confused with 2 cases. I got people with claim more than 2, and they managed to comply with all the courts.
You know what your client is?
She says, okay, at least she says, I wish to acknowledge that there was contact between Mr. Brothers and myself in April 2024. And apparently since then too, since the baby's only 8 months.
Okay.
She wasn't trying to show disregard for the court's authority. Yeah, this is all just a bunch of crap. She understands the seriousness of complying with the court order. No, she doesn't. She went and got a baby with the same guy that she wasn't supposed to be seeing. And then she writes me this, talking about she understands how serious it is. I don't believe none of this. And she acknowledges and respects the court's no contact order. Well, I'll be yeah, she acknowledged and respects it so much, she made sure she came back with a baby. And then she talked about how you're responsible as a parent. Okay, maybe you are. I don't know about that part. And then she says the conduct resulted from poor judgment and immaturity on both sides. She takes responsibility for her role. Well, she led you down a bad path if she's taking responsibility. Because you had no business doing that. Following her, going over there, seeing her, accepting calls, none of this. Then you would not be in any trouble. You should have been focused on trying to do what you needed to do. And at the right time, you might have been able to get back with her. Y'all just did this backwards.
I'm sorry, man.
What she's talking about? She believes both of you learn. She respectfully requests the court consider a disposition that emphasizes rehabilitation, continued compliance with court order. I can't do anything to emphasize continued compliance with court orders other than put you in jail. That's the only thing I could do because I emphasized that at first. And I gave you an opportunity not to have this on your record. Walked away with no conviction. All you had to do was do right. And even if you failed a little bit, show good faith and do most of the things right. Then I said he came back with an 8-month-old baby. Then she says, if deemed appropriate by the court, I also respectfully request consideration of any future modification through proper legal proceedings. Listen, y'all don't go through proper legal proceedings. Y'all been seeing each other all this time. The only thing stopping her now is I guess she just drive over to the guidance center where you already see her there. So I don't know what y'all are asking my permission for. And she could go see you at the county jail if you end up there too. You all have done it your way all this time. Now you want to ask for legal authority to do it, which she could have easily come back to the court 2 years ago and said, hey, I know there's a court order. I'd like to lift a no contact. I got people do that all the time. All the time. She didn't do that and writes me this little unbelievable letter for several years, 3 years to the fact later, asking for something to be done right. Did you want anything else, Mr. Schwarzberg? Because I'm mad. I'm not happy with him. The people wish to be heard.
Defer to your judgment. I'll just note that it's evident that the defendant has not taken anything that the court has ordered seriously. And I don't know that we're going forward.
Well, whether he improves is up to him. He could have done this right. He could have improved throughout this probation, and we'd have been proud of him and happy about it. Then he could have been back with the girl that had a baby if that's what he wanted to do, but he did none of that. He didn't make sure he was better. He didn't take any of the counseling we ordered, nothing to ensure that whatever his issues were would not pop up again in a relationship. And without addressing your demons, sir, they're still there. And they will pop up again. I don't care what she said in this letter about how you acting now. Yeah, let the one wrong thing happen. And whoever you were when this happened, it's going to pop back up because you got nothing out of anything that we ordered you to do. And most of this was rehabilitative, which is what she asked for in this letter. Now, we already did that. And you just thumbed your nose up at it. Like the court said, nothing. But if you're in that guidance center now, trying to do better, great.
Do you consider, after March the 9th, when Mr. Brothers, completes his program, to reinstate these, requirements and give them an?
I know you're kidding me, right? No, I'm not reinstating anything here. There's no way. It's been 3 years, I got nothing. I'm glad he's doing whatever he's doing, but he's got a penalty to pay. So, sentence of the court here, he's going to pay the money that he owes us, which is $1,716. We'll put him on a payment plan for that. Plus, he's got $100 in violation costs. Plus, he's going to have a $150 counsel fee for the violation. And we're going to revoke his 769 4A status. So this conviction will now enter on his record. And he's going to do some jail. He will report to the Oakland County Jail on March the 10th. Today, after I guess he's released out of the guidance center for 30 days. His probation is terminated. Now, if you don't report to the Oakland County Jail on March the 10th, look for this to be more time. Look for it, because that's what's going to be. I'm not playing. It takes a lot to get me riled up, and you've done it. That's it. Thank you, Mr. Schwartzberg. Mm-hmm. Are we ready on for water? Case number 25S01285FY, State of Michigan versus Hussein. Oh, you know what? I need to deal with Mr. Brothers' other thing too. Hold on. Go back to Brothers. I'm gonna refer him for a payment plan on this other matter, Mr. Brothers. On your allowing an unlicensed driver to drive. We'll refer it to the collections for a payment plan. And we'll make it, let's see, since you're going to jail after you get out in March, so we'll make your payment plan start sometime in May.
How long do I have to do, Your Honor, in Oakland?
You're doing 30. You'll get some credit, though. Some good time credits.
Any credit, Your Honor?
I don't know how much, but they'll give you some good time credit. How much is it on 30? Like,
35.
so 5, 10, 15, 20, 20. So you'll probably get 6 days credit. So we'll start your payment plan when defendant gets out of OCJ. And they will send the payment plan to your street on Yale Street in Westland. Hopefully you're still there. Oh, did I say refer to collection on that one too? Okay, now back to Fawaz.
Ready.
All
Thank
right,
you,
you're
Linda.
all set, sir. Good luck to you.
Me too.
Okay, this is case number 26S000820M, City of Southfield versus Tremaine Hodge. Good afternoon, Mr. Rivers. Ms. Hodge, yes, there she is. All right, come on up, tell us your name. And Ms. Hodge, you are here for a pretrial on misrepresentation of identity with intent to obstruct the police, which is a 90-day misdemeanor. There's up to $500 fine. You certainly have a full right to have a trial on this charge, could be by judge or by jury, with a lawyer to represent you. And if you couldn't afford a lawyer, you'd like to have a lawyer, then we'd make sure someone was appointed for you to represent you if you're eligible. So you understand that? Okay, so Mr. Rivers, you had a chance to speak with her today?
Yes, I did speak to Ms. Todd. We did work out a resolution agreement where she would plead guilty as charged to the misrepresentation to the police. And at the appropriate time, I would recommend that she be sentenced to time served.
Okay, Ms. Hodge, so although there is no plea bargain, prosecutor wants to recommend time served. Of course, I don't have to follow that, but I will take that into consideration. So is that what you'd like to do?
Yes.
All right, let's go over all of the constitutional rights that you do have at trial that you're getting ready to waive because you're pleading today. So if you understand these rights, all you need to do is say yes as we go over these together. So, okay, we're going to start with the fact that, again, you have a right to have a trial by judge or by jury with a lawyer. And if you couldn't afford one, we'd make sure someone was appointed to represent you. So you understand you're waiving that. And at that trial, though, you would also have the right to subpoena witnesses. That means you have the right to ask the court to order witnesses to appear to testify for you. You understand you're waiving that. You have a right to question through a lawyer any of the witnesses that are brought against you by the prosecution. You understand you're waiving that. You have a right to testify on your own behalf at trial. But if you choose not to testify, no one can hold that against you. You understand you're waiving that. Also, understand that you have a right to be presumed innocent unless you're proven guilty beyond a reasonable doubt by the prosecution at a trial. And you're going to waive that. You understand? And if you're on probation or parole status now, and you plead guilty today, this plea might be considered a probation or parole violation. So you understand that. And you have read and signed the advice rights form. Any questions about your rights? Understand if I do accept the plea today, that you won't have a trial and you'll give up all the rights we're talking about, the rights that are on the form. Yes. You also understand the potential penalties that are involved here with this charge of 90 days, $500 fine. And you still wish to plead guilty to misrepresentation of identity to the police with the intent to obstruct. Anybody force or threaten you? You've been promised anything other than what we stated, and you're pleading freely and voluntarily. Is it true this occurred January 27, 2026, 12:12 a.m. at 22305 Telegraph Road, City of Southfield? Let's see. Well, let's see. Well, were you there, first of all? Okay. Now, were Southfield police officers also present in uniform or in cars such that you could tell they were Southfield police officers? And so were they there in the performance of their legal duties, investigating a stolen vehicle or a larceny investigation? And did they ask you to identify yourself? And did you tell them your name was Alani Hodge? Okay. Okay. So when you did that, did you tell them your date of birth was April 28th of 2001? Okay. So when you put those two together, you knew it was not true. And you did that with intent to obstruct their investigation into your identity. Okay. All right. You satisfied?
You are satisfied, Your Honor.
And I'm satisfied as well. Factual basis for the plea, court rules been complied with, and I find the plea is freely, understandably, voluntarily, accurately, and knowingly made. Who is Alani Hodge? Just somebody you made up? It's not a relative. Okay. Why'd you make that up? Well, don't you know the truth? Never heard the truth shall set you free. If you had told them the truth, you wouldn't even be here on this charge.
I was really trying not to do so good off bro, and I was like,
Well,
I think that I like good, and I was like,
see, now that's your problem. What dude did you meet? And you in the car with the dude? Were you in the car with him? He was driving?
and he had a buddy as well, but I didn't know. But
You in the car with men you don't know?
be home. Like,
Are you serious?
Like literally, my car had broke down, and
Ma'am, no, ma'am. We don't get in the car with people that we don't know. Do you know what's going on out here? Girls are just disappearing. Women, girls, people. Now, what if they were bad guys? You don't know who they were, and you're in the car with them? What if they'd stolen you and did what they wanted to do to you and then killed you? A ride, was that pressing for you that you would get in the car with a stranger like that? And who knew you was in the car with them? Okay, and you don't see nothing wrong with this picture. So why not you thinking better than this?
I'm ready to I'm telling me back to him.
Okay, no, but the chances of you getting back to her was maybe 50-50, if that. It might be good the police did stop the car, because maybe they would have got you there and maybe not. You got to be more careful with yourself. You only got one life. And if you had told them who you were, you wouldn't have this case. Maybe this case saved you, because if you had told them, maybe you would have kept going in the car with them and maybe you might not have got there. I don't know. But that's something for you to think about, isn't it? Because I don't think they were going to charge you with the car. Obviously, they didn't. They just charged you because you didn't tell them who you were. And so you could have gotten out of any problem with your parole because you would have had no problem. No charge about the car. No charge about a name. Now you got to explain the name problem. Then you know what parole officer wants to hear that their parole assigned person is trying to pull one over on them by giving a fake name so they won't find out. No, they don't want to hear that. They want to see you thrive. That's what their job is, to get you back on track, get you employed, make sure you're following the rules, get you back where you're supposed to be. What you on parole for anyway? A guy or a girl?
Oh, yeah. And I do agree. I do.
Okay. Because, yeah, young, yeah. You're going to have 2, 3 more great loves. It don't matter. Let the first one go. Everybody had one. First one that broke their heart. Everybody's still moving. Very few people marry the first one. Some do. Very few. So you got to start making better choices. Because when you think about even that can't make the guy like you. It don't fix nothing. He gets you in jail and he's gone on with whoever he want to go on with. Might not even be the other person that he broke up with you for. It could be anybody else. You got to hold yourself a little bit higher esteem than that. You have value. Your life is worth more than arguing with some man to make him like you. If he don't see the prize, that's his problem. Don't mean you not the prize. I mean, he's blind. And that's okay too. He might have regretted. Now, he can't regret it now because he's thinking, well, she crazy now. Yeah, you know he's thinking that. He cannot regret that now. But that's okay. You know, you just got, what are you trying to do for yourself?
push myself through school. I want to be a lawyer in real estate and just trying to start my own clothing line business. I'm just trying to make them, not make it hard for my neighbor.
Well, that's good. Well, I'm not saying you can't be a lawyer because, you know, when you pass the bar, they got a character and fitness portion. Well, you got to explain away convictions. Some people can do it and they get past that. So you just got to stop getting in trouble because this is one you didn't have to have. You're running your chances of getting your dream done. Every time you do something like this, you got to start. And lawyers are paid to think, and you're not thinking. Not saying you're not smart. I'm just saying you're not thinking. It's two different things. So if you concentrate on your goals, I think you can accomplish them. But you getting sidetracked on all kind of dumb stuff.
And I'm like, I'm very frustrated, but I'm like, I feel like, my second chance, my last chance, I really got to get it right.
Yeah. Well, ask him for some discernment and for some guidance. And to make and to order your steps. That's what he can do. But you gotta ask him for it. Say, look, order my steps. I can't do this on my own. I done made too many missteps. Yeah, who is? That's what I'm saying. Everybody's imperfect. We're perfectly imperfect. And we've all made mistakes and done things that no matter what it was that we regret somehow, but it's okay too, because all you got to do is ask for forgiveness, pray on it, and then that's what he does. He forgives. Then you ask, you give your thanks, and then you ask for your direction. Because this right here is just nuts. You didn't have to have this. And you've been in there since the date of the incident, since the 27th. So how many days is that? 1, 2, 3, 4, 5. That's 16 days. So you're gonna promise me that when you get out of this one, you're gonna report to your parole officer. You're not gonna get any cards with people you don't know. You're just gonna stick to trying to get your job, stay in school, stay close to home with mom. You can get a man anytime, but you get yourself together first. That way you don't need him. He's just a great asset to you. Because that's what he should be, an asset. No, you should promise. You should promise.
Well, like I said, I wasn't gonna promise, but I will honor that.
Okay, well, okay, honors. I'll take that. Take that. Because I really don't want to see you back here on anything like this again. So 16 days in jail, credit for 16. I'm not even fining you. Okay, good luck. Okay.
Every day in the USA, people find themselves in court.
Shoshana, Rochelle, Curtis, 26T6475048 and B. Could I have Zuko seated at the table here, my right, your left? And you can come up here, Ms. Curtis. Your name? Nice and loud for me. You're charged with driving on a suspended and defective equipment. You have the right to an attorney. If you want one, I will give you one. Would you like a lawyer?
No.
I'll arraign you and then I'll send you to the prosecutor. I'm gonna need that one sentencing with Mr. Gamber. You're charged with
Miss Curtis up here, Tashada Curtis.
What's
Is
that?
Is this Tashada Curtis? I'm sorry that you have at the podium.
Yeah.
She has 2 warrants that we're working on right now also.
All right.
And I believe it does look like though they are Judge Hessen, so I'm not sure if you just want to send her over there or when we're done with them. But just to give you a heads up.
All right, thank you. Ms. Curtis, you're charged with operating a motor vehicle on January 18 of 26 in the city of Trenton on Fortner West at 1:16 in the morning. They think you had defective equipment and a suspended license. That is a misdemeanor driving on a suspended, punishable by up to $500 in fines, 90 days, 93 days jail costs, or all of those penalties. You understand that? Nice and loud.
Yeah.
Did you sign the advice of rights and read and understand the rights? If you plead guilty, you'll be giving up all those rights and we're not going to have a trial of any kind. You understand that? Yep. You still wish to waive your right to a lawyer? I'll enter a not guilty plea. You got to show up in court. Why? When was she scheduled for court that she failed to appear on?
October 12th of 2022.
Oh, geez, I don't want to rush you here. What are you doing?
Bill Court, where?
Here, this place. You were supposed to be here in October of 22. Well, don't sound so aloof about it, okay? You're not endearing yourself to any judge when you pull that kind of nonsense. You're going to be arraigned on those warrants next door. $500 personal bond. You're lucky you're getting a personal bond. Do you work? What are you acting like this for? Like I don't recall, like it's not a big deal. Like I forgot to pay my water bill that was $3.13. Young lady, don't play games. Judges don't like games. You want to play games? Go to the store, buy Scramble or Trouble or Monopoly or whatever else. Don't play games in here. You got it? Good. You'll go meet with the prosecutor. Either way, you'll come back in front of me, and then you have to go next door to Judge Hessen, and she will arraign you on those charges when they cancel the warrants. Good luck. Tina Wilson. Tina Marie Wilson, 25G, 82771A and B. You can have a seat there if you'd like, ma'am. Is that a cup of water or what is that?
Like this.
Well, I don't want you to vomit.
Me either.
Geez, oh Pete, relax. Take a deep breath and sit down.
Good morning, Your Honor. Attorney Corey Westmoreland appearing on behalf of Ms. Wilson.
Now I know why you think you might vomit. You haven't been here in 6 months. How come?
Kidney failure. I'm very sick.
Okay, I'm sorry about that. Okay, so you pre-tried this, right?
That's correct, Your Honor.
Let me just figure out what we've got. We got an abandoned vehicle charge. What is this? It was property maintenance, abandoned vehicle on street. Okay. So she owes on that and she's going to plead to the civil infraction of loitering, right?
That's correct.
All right. So she's going to plead to loitering. They're going to dismiss the original charge on file A, and then she's going to plead. She's got the default judgment on the other case, right?
Correct, Judge.
Ma'am, you want to plead the loitering? Your lawyer did a good job for you. You want to plead the loitering? It's a civil infraction. You can't go to the charge of loitering, responsible or not responsible.
Responsible.
$150. Property maintenance charge is dismissed. So you owe $150 plus you owe the $213, I believe I saw, right?
I believe that was it, Judge. I'm looking real quick to double check it on that.
I thought I saw 213.
It is 213.
So you owe $363. Can you pay all this?
She's able to pay $100 today, and she would need a payment plan due to her health. She's unable to work, so she's.
Are you on disability?
No, she needs to be. Absolutely.
I signed up for it. It's in process.
Okay, all right. All right, so on the loitering charge, let's do the abandoned vehicle. Who's this with you?
Lady.
Her next door neighbor says, "Oh,
Well, that's nice. We all need good neighbors like that.
Yes.
All right. Is there a way you can come up with a little more, like $40 more on top of the 100? You pay one, he's shaking his head, yes. Do you want to confirm that with him?
He holds my money for me.
You pay $140 today on the abandoned vehicle and I'll waive the balance on that, okay?
Thank you.
And you'll still owe $150 and I'm just going to give you on the civil infraction charge, I'll just give you until April 1st to pay that. Can you do that?
Sure.
Don't make it, don't make it.
And if you can't pay by then, you call the court, we'll go on Zoom, I'll give you an extension. Just don't ignore me. I wish you well. You're fine. See, it wasn't so bad. You didn't throw up or anything. Good luck.
Thanks.
Good luck.
Have a nice morning.
Thanks, you too.
Couldn't move fast enough to get to the bathroom, so I brought a cup.
All right, you're fine. Relax. All right. Tashana Rochelle Curtis, 26T 647 504 A and B. Your name, ma'am?
Sean Paris.
All right, nice and loud. You're going to plead to no operator's license on person, right? They're going to dismiss the driving on a suspended, true? If you do that, the possible penalties are up to 100 fines, 90 days jail, costs, or all those. Do you understand that? And again, did you sign, read, and understand the advice of rights? If you plead guilty, you'll be giving up all those rights, and we're not going to have a trial or a hearing. Do you understand that? You have the right to a lawyer. Do you still wish to waive your right to a lawyer? Just keep your voice up for me, okay? To the charge, no valid operator's license on person. How do you plead?
Guilty.
Were you operating a motor vehicle January 18 of 26 in the city of Trenton, county of Wayne on Fortin or West at 1:16 in the morning? Did you have a valid license on your person? Are you on probation or parole?
No.
Anybody forced you to plead guilty?
No.
Please accept that the no ops, the suspends, dismissed. I'm ready to sentence you. You ready? Anything you'd like to say? You got to stop doing it. And then you don't show up and you go out and got another one apparently. 100 fines, 70 costs, 75 victims' rights, $50 justice assessment, $295 or 60 days. You can go down the hall and pay that, okay? And you have that to pay, correct?
Yes.
All right. And by the way, did he address the defective equipment? Oh, and I'm also dismissing the defective equipment too. So you can go down the hall, pay your $295, and then go in front of Judge Hessen, okay? Good luck. Susowitz, Brian Susowitz.
Yeah.
This is 25F243700. Does he really want to do this under is this under 779?
I don't believe so.
He just put it under that.
If he did, it's fine with me.
I mean, the guy just was in jail for 93 days. I mean, it's a noise violation. I mean, if you think you want, I will just give him fines and costs. He's got a heck of a record. If he was going to go to become a priest or something, I would, you know what I mean?
Yes.
He just wrote it in this line that he usually checks a box for statute. He didn't do that. Noise violation.
That's what he proposed to me, that he had to plead guilty as charged. And,
But recommend fines and costs.
recommend fines and costs.
I'm fine with that.
Sir?
But we're not gonna fool around with 771, right?
No, I wasn't even aware of that.
Okay, good enough. So do you understand? State your name. Do you understand what your lawyer just said? So first of all, I guess I gotta have him, he's gonna stay mute, wait formal reading for arraignment purposes.
He will, Your Honor.
And then he's going to plead guilty to a noise violation with the prosecutor recommending fines and costs only, right?
Yes.
Is that what you want to do? That is punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that? And did you sign, read, and understand the advice of rights? If you plead guilty, you'll be giving up all those rights. There will be no hearing or trial. Do you understand that? To the charge of noise violation, how do you plead? Were you at Walnut Creek Drive, 28227 Walnut Creek Drive, Flat Rock, April 4, 25 at 3:54 in the morning? Were you yelling? Were you yelling racial slurs?
I might have, I was John.
Why would you be yelling racial slurs? I'm sorry?
Not sure.
I hate that. I always think when somebody, is making slurs about anybody, they must be emperor of the planet or something. You know what I mean? Like, who are they? I hate that.
Unfortunately, alcohol can fuel a lot.
Yeah, I know,
Discussed that
but we don't usually say things unless we feel like them, whether we're drunk or not. That's my issue with it. All right, I'll accept the plea. I'll go along with this fines and costs, but you're gonna pay some fines and costs. Anything?
Yes, Your Honor, the gig is working, but he does have some obligation, Your Honor. He has a family that he supports and some other bills as well. So this is not a violent offense, fortunately.
I know.
So I'm asking for a minimal amount of fine.
I just don't like these. I just don't understand it. Anything you want to say?
I was in a bad state of mind. Wasn't living how I was supposed to live. There's not an excuse. I understand that. But
Your record is horrible.
I know I'm trying to turn it around. I got a daughter now. I got another way.
I just don't, there's no place for racism in our society. Some people think it's cute. I find it disgusting. 200 fines, 225 costs, 75 victims' rights, $50 justice assessment, 550 or 90 days. I'll let you pay this at the rate of 50 per week. And you can start to pay this beginning on February the 27th. If you need more time, you come talk to me. Don't be doing that. Good luck. Thank you.
Judge, he does need to go over to Judge Hesson's now. He has a
Need
case
to go
over
to
there.
Judge
too.
Hesson's too. Come on back. Let me do your bond violation and then we'll get prosecutor in there. Summer Lori Greathouse, 25F 245 336.
Judge.
Your name?
Elizabeth Ross, probation, Your Honor.
Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got.
I do, Your Honor. I just passed up to you because there are numerous violations, numerous positive blows on the sober link. So I just, that way you have that in writing.
This is the one with the fourth offense.
That is correct, Your Honor.
And are you adopting this? You've got a document that says, and I can read them real quick. She was positive for alcohol in the sober link on February 8 at 7:27 p.m. She was positive and with these numbers corresponding on this document. February 9th at 11 a.m., 11:17, 11:34, 11:53 a.m., 3:26, 3:44, 7:22, 7:40, 7:57, 11:22, 11:39 p.m. Also on February 10 at 11:27 and 11:44 a.m. Also on February 10 at 3:27, 3:44, 4:02, 4:19, 4:37, 7:29, and 11:18 p.m. And then again on February 11 at 11:25, 11:43, 12:02, 7:11, and 11 p.m. She failed the blow, right?
That is correct, Your Honor.
This is the document you prepared?
That is correct.
Sign it, will you, for me, please? I'm gonna find that there's been a violation of defendant's, defendant has violated bond conditions. I want you to go into Mr. Longton's office. I want you to tell him I'd like him and his client to appear here if he's available this ASAP this morning.
Yes, Your Honor, in person?
In person. I'm issuing a bench warrant, revoking the release, forfeiting her bond, and issuing a bench warrant pending a hearing. The bench warrant will be in the amount of 10,000, 10%. Boy, this is not good. Thank you. All right, so we're gonna go on record on this. Summer, Lori, Greathouse, 25F 245 336. So if we haven't put the warrant in the lien yet, Heather, don't. Good morning, Mr. Longton, or afternoon. Your appearance?
I'll call out Your Honor, so
Your name, ma'am?
Summer Great House.
There's a multitude of probation violations or bond condition violations that are alleged. February 8th, all day on the 9th. I'll be happy to give these to you. The 10th, all day from 11:27, the 11th. So I'm going to hand you this, Mr. Longton. You can look at it. I'm going to conduct a hearing. She can either plead guilty or we can have a hearing as to whether or not she violated the bond conditions. So we'll go off the record. I'll let you two talk and.
Not necessary.
Okay.
I already discussed this with her and gonna plead not guilty and I explained to the court why.
No, that's okay. We'll have a hearing right now.
Right.
But I'm gonna, Ms. Wild, your name?
Elizabeth West, Your Honor.
Okay, so Mr. Longton's advised that she is going to plead not guilty. So are you ready to proceed with the hearing?
I am, Your Honor, as well as the Sober Link expert with House Arrest Services. I told him that if he was needed, I would be able to email or call him and he would be happy to be here present as well.
She still wants us to do that? If she does, that's fine.
She does.
Okay, call and get them ready. And then we'll start the hearing. Why don't you make an extra copy of that?
I did, just to be on the safe
So
side.
I'll take the one, the original there that I gave to Mr. Longton. And we'll go off the record while you called him. Are we all set?
He said he'll be joining momentarily. He already has your Zoom information. It was just a matter of him, I think, polishing up with what he had in front of him and.
Let's go back on record here.
Right answer.
All right, so I'm recalling Summer Grade House. Mr. Longton's here, Ms. Wiles is here, and Ms. Greathouse is here. So they're pleading not, she's pleading not guilty. You can start your testimony. I understand house arrest is going to be zooming in any second, but I'll go ahead and we can start. And then Mr. Longton will have an opportunity to question you. Raise your right hand, please. Do you solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God?
I do.
Okay.
Sure. On February 5th, Ms. Greathouse was referred to House Arrest Services to obtain her SoberLink device, which she did do in a timely fashion. I was notified on February 8th that Ms. Greathouse was positive for alcohol at 7:27 p.m.
Yeah.
with a 0.019%.
Wait 1 second. He just told me house arrest is out there. We'll bring him on. All right. House Arrest Services. You can start your video, unmute, and state your name, please. There you go. Thank you. Your name?
Yes. Hi, my name is James Hunt.
Okay. The probation director is just beginning her testimony, so we're going to let her conclude and then we'll go from there. Thank you. Go ahead.
Yes, Your Honor. So again, just briefly, February 5th, Ms. Greathouse was ordered to obtain the SoberLink, which she did. I received an email February 8th indicating that Ms. Greathouse was positive for alcohol, 7:27 p.m. at 0.019%. For counsel and for yourself, Judge, anything below a 0.020% does not require a reblow, and therefore no reblow was required at that time. On the 9th, as listed on the sheet that counsel has been provided, as well as yourself, Your Honor, Mr. Hunt does have this information as well. Beginning at 11 a.m., Ms. Greathouse was positive at a 0.029%. She called House Arrest Services claiming this was due to brushing her teeth. House Arrest Services did inform her to continue to blow as required. So at 11:17, she was this is a typo on my part, that was 0.023% at 11:17 a.m., Your Honor, again, my typo. At 11:34 a.m., she was 0.23, 11:53 a.m., 0.017, again, under that cutoff, no more reblows were required, but resumed to be positive at 3:26 p.m. at 0.020, 3:44 at 0.013, under that cutoff, no further blows required, continued to be positive that day, 7:22 p.m. at 0.023%, 7:40 at 0.022, 7:57 at 0.019 under the cutoff. Continued to be positive that day at 11:22 p.m. at 0.025% and 11:39 p.m. at 0.018% under that cutoff. Then on the next day, February 10th, she was negative for her morning blow. However, resumed being positive at 11:27 a.m. at 0.023, 11:44, 0.017% under that cutoff. Continued to be positive that day, 3:27 p.m. at 0.040%, at 3:44, 0.033%, at 4:02 p.m. 0.027%, 4:19 p.m. 0.021%, at 4:37 p.m. 0.016 under that cutoff. She did continue to be positive for alcohol, however, again, under the cutoff at 7:29 p.m. and 11:18 p.m. The following day, February 11th, she was negative for her morning blow. Positive again, 11:25 a.m. at 0.025%, 11:43 a.m. at 0.021, and at 12:02 p.m. under that cutoff at 0.016. She continued to be positive under that cutoff at 7:11 p.m. at 0.019%, and at 11 p.m. she did fail to blow. An hour and 55 minutes later, at 12:55 a.m., she did blow, and she was all zeros on her late blow from 11 p.m. Last night. In the meantime, she did call house arrest services, and she claimed that her device was malfunctioning because it was requiring her to continue to blow. House arrest services did inform her that as long as it told her to re-blow, that she needed to. This is what happens when we're positive for alcohol. It's going to have you blow until you are under that cutoff to ensure that it isn't environmentals like toothpaste and all the other excuses that sometimes we hear. But the one excuse that Miss Greathouse used while brushing her teeth back on February 9th. I did ask them to send over her contract as well that she signs with them that indicates that she agrees to wait at least 20 minutes after using any mouthwash or any product containing alcohol, such as, but not limited to, hand sanitizer or any other topical substances that may include alcohol like cologne, perfume, bug spray, before she submits a test, as well as she agreed to submit to required tests if requested by the device after a sample had been submitted. There is no issue with Miss Greathouse continuing to blow, but again, it's not a malfunction of the device. Mr. Hunt here is to do his testimony. It's because of the detected use of alcohol that she had to continue to blow, Your Honor.
Okay, do you have any questions of Ms. Wiles?
Do I?
No, you're a lawyer.
Ma'am, you're not technically prepared to testify reliable this device is, correct?
I would leave that up to Mr. Hunt, sir.
The answer is no. You're not totally qualified.
Correct.
My questions are Mr. Hunt.
Okay. Mr. Hunt, I'm going to ask you to raise your right hand, please. You solemnly swear or affirm the testimony you'll give in these proceedings will be the whole truth, so help you God.
Yes, Your Honor.
Do you want to ask him some questions?
I'm gonna ask him just a brief question in relation to an email, and then I'm happy with Mr. Longton, of course, to ask Mr. Hunt any questions. Mr. Hunt, you and I had talked on the phone. I asked you to review those blows from Mrs. Greathouse in reference to the possibility of that device being defective. And you indicated to me that as a knee-jerk reaction, you did feel that it could be a malfunction of the device, but that you wanted time to look at those blows and make, of course, a more professional decision. And you indicated to me in the email, I'm going to ask you if this is correct, that in looking at each single event, these are consistent with drinking. Is that correct?
That is correct, yes.
Thank you. No other questions, Your Honor.
All right. Do you have any questions of him?
Mr. Hunt. When my client calls Silverland to complain about the device, does she talk to you or to someone else?
She would have spoke to somebody in the monitoring center.
Who would she have spoken?
I would have to pull some calls to get names. I do have a note in here from Miss Hall, one of our monitoring room employees.
And that note says what?
That she called and stated the device keeps telling her to take to test multiple times. We advise her to just keep testing when the device says to. She stated that it may be because she smokes cigarettes. We advised her to reach out to her officer if she has any questions about the report.
What else do you have in your notes?
I have another note in here from a Miss May that says that the client called and stated she brushed her teeth and then left the house and tested on her device.
Do you have any other?
Those are the two notes on her account.
Do you have any notes from your staff indicating that they spoke to her about having the device recalibrated?
I do not know.
How often do these devices need to be recalibrated?
The devices are recalibrated after 1,500 tests have been taken. This device, I'm still waiting to hear back from the manufacturer because this was kind of short notice. But this device has, as of right now, 1,448 tests remaining until calibration, which indicates to me that the device was recently calibrated before given to Ms. Greathouse.
Isn't it true that these devices sometimes fail before reading 1,500 tests?
It's technology, so yes, that's certainly possible.
Isn't it true that it has happened and you have a record of these devices failing?
Yes.
So you don't know whether these test results are accurate or not.
But I mean,
you don't.
No, I do not. No.
Nothing further does he call.
Do you have any other questions?
Nothing further, Your Honor. Mr. Hunt, is it possible to send a device into the manufacturer to determine in this circumstance if this is a device failure or not? Would there be a definitive answer?
Yes, absolutely.
Thank you.
Well, Mr. Hunt, the question is, if you send it back to the manufacturer, can they tell definitively whether or not it has been failed? Are you technically an expert that you could tell us if that's true or false? That the manufacturer can tell us definitively whether or not it's been failing?
I would be able to recite the report that was given, but no, I'm not an expert in device calibration. No.
So we don't know whether or not the manufacturer's report would be definitive or not, do we?
We don't even have that report yet to determine if it's definitive.
I'm sorry, guys, this is just appropriate process, yeah.
Wait a minute. I want to interject.
I wasn't done.
Yeah, let her finish first. Go ahead. You want to ask a question?
Yeah, I had a follow-up question to that, but
go ahead.
Mr. Longton chimed in. Mr. Hunt, and it actually alluded to actually what Mr. Longton was. So if we send that device in and the manufacturer reviews the device and we get that report back, that then, piggybacking off Mr. Longton's question, then being the expert, because that is their device, would we know if it malfunctioned or not?
Yes, correct.
Thank you. And I am done now.
And read the conclusion that he drew in the email again. Will you do that for me, please?
I can actually read that in whole. It says, good morning, Ms. Wilds. As we discussed on the phone, I went ahead and did some math to figure elimination rates. And these events are consistent with consumption. I have a consolidated report attached, and I also have a detailed report covering her positive dates from 2/9 to today. Knee-jerk reaction, seeing the mix of positive and compliant, was device failure, but looking at each as a single event, these are consistent with drinking. If you have any questions, please let me know. And it is signed by Mr. Hunt.
All right. Do you have other questions?
I have none. I had my comment.
Okay. Raise your right hand, ma'am. Solemnly swear affirm under penalties of perjury the testimony you give in these proceedings will be the whole true self you got. Okay, go ahead.
So what happened during the earliest possible?
I'm sorry, I didn't hear the question.
What happened with sober, starting with these early possible days, like February? What happened?
On the night, so I had taken a couple of days off since the last time I was in court and I stayed home. And then I went back to work that Tuesday, I believe, and I'm in my car a lot. So when I left this morning,
Wait a minute, which morning are you talking about?
the 9th, I believe that was Tuesday.
Well, the first one said she was positive for alcohol at 7:27 PM on February 8th.
Talk about February.
8th. What day of the week was that?
February 8th would have been a Sunday.
Honestly, Sunday I was at home with my kids. We played some games, had the football game on. I got them to bed because they had school the next day. And then, so it must have been Monday then.
February 8th, it's like.
Okay, so then starting that Monday, I had gone back to work, back into the office, driving around throughout
So
the
the
day.
question is, what happened on February 8th at 7:27 PM?
No idea. You know, I didn't ask, I don't remember that it asked me to retest. Honestly, that was on Sunday. I don't remember.
Go ahead. On the 9th, you went to work. What time did you go to work?
I left my house at about 10:45.
Okay, where do you work at?
The office is in Allen Park, but I drive clients around or meet them at different houses. I do real estate.
Okay, so
So on Monday, I had a client that, well, I went to the office first. We had an 11 o'clock Zoom. I did the Zoom and then I left. I met up with the client, so I did a bit of driving around. When I had gotten the first one, I brushed my teeth, left the house. I do smoke cigarettes, so when I called, I didn't claim that it was because of brushing my teeth. From my recollection, that was the first time it had asked me to retest. So when it happened, I called right away and asked about it. I called house arrest. And I said, this is asking me to retest. And so I had asked questions the day when I signed the paperwork, when I got the device, and like Ms. Wilds had explained, like they did kind of go over everything. That was the day that I was in court. Did I necessarily remember the 15 minutes before and all of that stuff? No, yes, I did sign it. There was a lot going on. It was high stress, high anxiety. She went over it.
Let's keep.
Okay, so this day, all day I was driving around clients and I picked my kids up at this 3:26 time. I was with my kids. We went home, we had dinner. That was on Monday. They didn't have any sports that evening.
When is the last time you consumed heavy? Is it before February 8th, 26?
It was. Yes, it was in December.
Last time you consumed alcohol?
Yes, sir.
Did you consume alcohol on February 9th any time?
No, sir.
So on your device, when you blew at 3:26 and 3:44, did you see these readings on your device?
No, sir.
You don't see these readings?
No, sir.
They don't. And okay, so you just
So I
said
did a
it.
retest. No, sir.
And when you're asked to reblow,
Yes, sir.
when were you asked to reblow?
Tells you to wait 15 minutes.
Right, so on February 9th, how many times were you asked to reblow?
The 9th. Felt like every time I did it, that's why I called. And then I wasn't asked to reblow on the 10th in the morning. and I
let's
think
stick with the 9th.
Okay, so every time, and I had called that day, and I called house arrest, and I said, it keeps asking me to reblow. What could the reason be? She said I could bring it in and have it recalibrated, and then I had.
Okay, go ahead. I'm sorry.
So then the next test, I believe, did not ask me to reblow. And then the one in the evening, I think did ask me to reblow, and then the next day, it didn't in the morning, and then it did a couple of times throughout the day. I think that one was the day that it asked me multiple times, or maybe not.
Let me ask you a question.
Yes, sir.
I ordered you to go and get the sober link the day you were in court. That's February 5th, right?
Yes, sir.
Did you go on the 5th?
Yes, sir.
Did you have any problems when you blew into the machine on the 5th after you acquired?
The first machine they gave me was not working, so she gave me a second one and then no.
Before you left.
No,
Wait a minute, slow down. Let's slow down. You went over to house arrest on the 5th
yes, sir.
in Livonia.
Warren.
Warren, I'm sorry. Warren,
Yes, sir.
you said she replaced the machine?
The first one she gave me was not working.
And did she replace the machine before you left house arrest?
Yes, sir.
Okay, so you went back from house arrest on the 5th, right? With a workable machine, at least in your mind.
Yes, sir.
Did you have any problem when you blew in that machine on the 5th?
No.
Did you have any problem when you blew in that machine on the 6th?
On this, I don't remember if it was.
Well, let's wait. Well, let's not guess. The 8th was Sunday.
Yes, sir.
The 5th would have been Thursday.
Yes, sir.
You got the machine on the 3rd, on Thursday, the 5th. You didn't have any positive blows with it on the 6th, right? You didn't have any positive blows with it on the 7th. Wait, let me finish. You didn't have any positive blows on that machine on the 7th, did you?
No, sir.
And when you woke up in the morning, when is the first time you tested on the 8th?
Would have been between 6:45 and 7.
Did you have any positive blow on that time, on that occasion? Well, any problem with the machine testing inappropriately until at least 11 o'clock on or about the 9th of February?
There was the 8th.
Okay, you're right.
The only issue.
Wait a minute, slow down, my mistake. On the 8th, you blew positive at 7:27 PM, right?
Yes.
How many times did you test it on the 8th prior to the 7:27 positive blow?
I tested 3 times.
Any problems with those results when you blew on the 8th prior to the 7:27
No, sir.
blow? Any problem with the machine when you blew on the 7th?
Not with a retest. The only issue I had with the machine that Saturday was that it wasn't turning on. And when it finally did power on, it had battery. So it wasn't that the battery was dead. That was kind of when it's. I didn't think much of it.
Any positive blow on the 7th? I'm asking you.
Oh, no.
Any positive blow on the 6th? Okay. Anybody have any other questions on that? Go ahead.
Your testimony been completely candid?
You got to keep your voice up for me, though.
Up?
Yes.
When you heard, has your testimony been completely candid?
Yes, sir.
Last time you had a drink was in December.
Yes, sir.
You willing to take the polygraph?
Yeah, we did.
They're much more reliable than they were when you and I started practice law. And Taylor Police Department has a polygraph, and they're more than happy to pay for the polygraph. Because otherwise, you're going to make a decision based on a device that could well be defective.
It could be, and if I am not satisfied by a preponderance of the evidence that she consumed alcohol, I'm going to find her not guilty. No, wait, just wait. Let's not, I don't want to talk about polygraphs. You ask your next question. Mr. Hunt, I want to ask you one while he's thinking.
Yes, Your Honor.
I want to make sure I understand. You said maybe every 1,500 blows, it has to be recalibrated. Right?
After 1,500 blows, yes, it's due for recalibration.
You said this particular machine, based on your inspection, still had roughly, I think you said, I want to double check, 1,444 blows left.
1448.
1,448 blows until the machine needed to be recalibrated.
Correct, yes.
Go ahead.
Mr. Hunt.
Yes.
Last year, in 2025, were there machines that turned out to be defective before there were 1,500 blows?
I'm sorry, can you say that again?
Last year, January through December of 2025. Were there devices that turned out to be defective that needed calibration before 1500 volts?
Yeah, it's technology. Things can fail. That's absolutely true.
And you had devices that did fit, correct?
Yes.
DNA open today?
But on-site is, yeah.
Good.
Yeah.
What else?
Your Honor, I have the greatest confidence in my client that she's telling me the absolute truth. I think it would be a horrendous miscarriage of justice to have her guilt based on what you've heard today from both her and Mr. Hunt. And I know you don't want to hear anything about polygraphs. I understand why the District Court of Appeals is clear about that. But in all honesty, when you and I practiced law, they were only 60% effective. Today, they're 98% effective. I'm more than happy to have her polygraph at the Taylor PD.
How do you explain the fact that this machine was working on the 5th, was working on the 6th, was working on the 7th, and worked until 7:28 or 27 properly on the 8th, and then all of a sudden she starts blowing positive, and now there's a problem with the machine?
And we don't have the testimony from the factory to answer that question as to whether it could work properly today, fail tomorrow, and work properly 2 days later. We don't have that kind of technical testimony. Mr. Hunt's already testified he relies on the factory for that kind of. When I told my car this afternoon to come here, my brand new Jeep would not start. I had to go back in, call the dealer, come back out. Eventually, it started. Who knows why? They don't know why. Who knows why, whether or not this thing fails every other day or failed all these times. We don't have the technical testimony from the factory. I don't have it.
I don't, this is not, we deal with these machines all the time, Mr. Longton. SoberLink devices are accurate. Once out of every 500 defendants will somehow, some way, when they get in there, get results like this, want to try to try to insist that there's something wrong with the machine. There's nothing wrong with this machine. They don't need to prove beyond a shadow of any doubt that the machine is working accurately. It's pretty evident here. He told you what it needs to have to recalibrate, or how often it needs to be recalibrated. He said it still had 14. Yes, listen. I don't think there's any question in my mind but that she was drinking. Okay? I get this all the time. And there's no question in my mind that she was drinking. And I'm not going to order a polygraph. I'm not sure I don't want to send her for a test. But I'll tell you what, I'll send her for a test.
If she flunks, put her in jail. Because I'm confident she's not drinking.
If she flunks on this test, I will put her in jail, and she will remain in jail. I will set a bond she won't be able to set, because I've just done, in my view, as I believe now, I've had somebody commit perjury in this courthouse, and I don't think very kindly of that. So yes, let's have her go to on-site today.
Yes.
Now, I am not going to be here tomorrow, but I will be more than willing to Zoom tomorrow. And we can Zoom on this case at 9:30 in the morning or 10 o'clock in the morning. You available, Mr. Longton?
I will change my schedule.
We'll Zoom on this case at 10 o'clock.
What I could do is I can have them send it straight to the lab. It won't be a screen, which would probably be more preferable. I assume Mr. Longton would prefer that as well, since he wants the actual results. So she can submit to her test today at 4 p.m. on site, and they can actually send it to the lab. Now, those results won't be back tomorrow. Should be back Monday or Tuesday. Court's closed
What
Monday.
does trouble me, though, is Yeah, let's do that. I'll do that. We'll continue the hearing at 10 o'clock. Now, I'm gonna give you one last opportunity.
Yes.
I'm gonna let you go test. If that test comes back positive, as opposed to me finding you guilty right now, I'm gonna set a bond you will not be able to make. Do we understand? Maybe you need to go confer with your lawyer. I've been doing this a long time, young lady. I can tell who's telling me the truth or not. I don't pretend to have every answer, but I'll tell you what, I'll compare my ability to determine somebody's credibility with anybody's. And I don't believe for 1/2 a second that you're telling me the truth. And then if you go and test and I have confirmation that you've committed perjury in here, you are going to have a massive problem with me. It's going to be so big of a problem, you're not going to want to, you're not going to believe how bad it's going to be. So I think before I send you for that test at onsite, you need to go confer with your lawyer for a few minutes. And after you confer with your lawyer for a few minutes, if you two want me to still order you to go to onsite, I'll order you to go to onsite. But do this, listen, don't talk to him now in front of me. Go take a few minutes, but think very carefully about what you're about to get into, okay? Do we fully understand one another? Okay, all right, you guys go talk. We can reconvene in here in a few minutes. Thank
Are
you.
we all set with Mr. Hunt, Judge?
Mr. Hunt, unless we call you again, thank you very much for your testimony. Mr. Longton, do you need any more
Of course.
from Mr. Hunt?
Your Honor, I only had one question.
Well, I'll tell you what, you go talk to your client and he'll come back in here. Will you zoom back in at 1 o'clock and we'll reconvene at 1?
I sure can. Absolutely.
Perfect. Thank you.
Thank you,
Thank
Judge.
you, Your Honor.
Next, you seated.
Court is back in session.
All right, back on record, getting this Wilds in here. Recalling Summer Lori Greathouse, 25F245-336.
Hold on, Your Honor, what I'm saying, but Your Honor, I asked her one of the last times we had it on. She excluded the fact that she's been drinking non-alcoholic beer and thing. And my question for Mr. Hunt would be, would that create a positive test? I don't think it would, if manufacturer's representation as contains is accurate, it's almost 0% alcohol, but I don't know.
We're just gonna follow this little circle around. We're gonna follow the circle around. I just want to know, does she want to get tested?
Yeah.
If she does at 4 o'clock, I'm sending for a test, and we are going to reconvene here at 9:30 or 10 in the morning. If she doesn't, sounds like she's already changing her story. I didn't hear one thing about a non-alcoholic beer until you just mentioned it. Not one, not even close. There's no remote reference to a non-alcoholic beer. So this is what I'm trying to tell you. I don't want to sound like a know-it-all, but I've seen this movie. I've seen this movie thousands of times. And if she wants to go for a test, I don't mind sending her for a test. But I don't hear this nonsense about non-alcoholic beer. Now I'm hearing, Ms. Wilds, you're just walking in, about she's drank some non-alcoholic beer. And would it be positive? So I want Mr. Hunt. I asked Mr. Hunt to show up here at 1 o'clock. And I'm hoping he's going to log in now. Do you see anybody from house arrest out there, Heather?
I do not, Judge.
Do you have your phone, Beth?
I do not, I'm typically the one working in court.
So, I just see this perpetual denial. You know,
There is an alternative. That is that she's correct. And
there is an alternative, like there's an alternative that I could pogo stick to the moon too right now. I mean, there's a possibility that some Martian could come grab me. I mean, look, it's fine. We'll send you for the test. I'm only telling you, I have one set of bond in mind. if I don't think that you perjured yourself. And I have another set of bond in mind if I do think you perjured yourself. Okay? And if I send you for a test and it confirms this on top of what I have, I will be 1000% convinced that you perjured yourself. In which case, I'm going to set the bond that I would set if I'm convinced that you perjured yourself. I don't have any problem with you going for a test. You want to go for the test? You go for the test at 4 o'clock. We'll reconvene here at 9:30 or 10. Mr. Hunt, you know, I told him one, I didn't want to have to wait.
Your Honor, may I have another moment with my phone?
Yeah, you can have another moment, but
Your Honor, you've been very clear, so allow me.
I know. I'd like to think I'm clear. Summer, we were back on record, right? Summer Lori Greathouse, 25F 245 336. Okay, everybody's name again. Your name again.
Oh, Your Honor.
Ma'am, your name.
Summer Greathouse. Elizabeth Ospation, Your Honor.
Mr. Hunt. Your name again, Mr. Hunt?
James Hunt.
All right, what is she want to go for the test or what?
Yeah, can I ask Mr. Hunt just one question?
Sure.
Mr. Hunt,
Yes.
you acknowledge that the device can malfunction one day and function normally the next day. Is that possible?
I have not seen that in my experience, no.
So Your Honor, we're gonna change our.
I don't want her to sit here now.
I'm sorry.
So just so you know, I'm gonna make the decision because I'm gonna spare her the disgrace of just admitting to me under oath that she has committed perjury. I mean, I will do that if you want. I don't want her to plead guilty now when she just testified under oath that she hadn't consumed anything until she came back and said it was non-alcoholic beverage. So if you're telling me she's not going to go for the test, I'm simply going to make my finding right now. And there's no reason for her to change her plea because honestly, I think it's horrible if I'm going to sit here and have somebody admit that they just committed perjury in front of me. So that's what I'm suggesting to you. If you want a different route, you can do that. I get it, Mr. Longton. But I still think, even though I'm upset that somebody would do such a thing, I still have a function here and I'm going to do it to the best of my ability. And that would be my advice to your client. But that's not, she need not take advice from me. So if she wants to just say, if you want to tell me, Judge, we don't see a necessity to go for the test at 4, then I will simply make the findings based on what I've heard here, testimony from your client, from Mr. Hunt, and from Ms. Wiles.
That would be correct, Your
Okay.
Honor. She will not object.
Okay, so I'm gonna simply, I'll listen to argument if you want. Do you want to argue or you want me to just make my findings here?
You're fine.
The court finds that the machine was properly working, that the defendant consumed alcohol, and that the document, which Ms. Wild signed February 12, 2026, evidences that intent, or evidences the results. And also, I'm going to find you guilty as charged. Now, you and I are going to have a conversation, young lady. You should have been charged with a felony. You should have been charged with a felony. Now, I don't know why they didn't charge you with a felony. I don't know. I don't care. It's not my business. I just do what they put here in terms of files. Now, in my view, you needed sobriety because I still think we can help you. But if you come in here and you lie to me, there is no way in hell I'm taking you in sobriety court. Excuse my language. I should not have said that word. Ma'am, don't say anything. You should not be saying anything. You are the whopping old age of 8? And this is now your 4th offense. And judges don't like this when you have 4 offenses by the time you're 38. They should have, like I said, charged you with a felony. I'm not being punitive when I do what I'm going to do here, but you're scaring the devil out of me right now. Because when you have a judge tell you not to drink, and you've had 3 offenses, and you've had a sober link device, and then you come in and you tell him under oath that you didn't drink alcohol, and he knows that you're lying, I can't help cure somebody who is not going to admit that they are drinking. I get it, that they have an alcohol problem. I get it. There's a form and an element of denial. But honestly and truly, you are going to live a short life if you don't get off of this stuff. It's your life. It's not mine. I have no choice here but to forfeit your bond. I am forfeiting the bond. That means you're losing your $500, and it also means you're going to have to post. And it's a good thing that you guys didn't go for the test just to verify what I was listen to me. What I was 100% sure of, and that is that you had consumed alcohol. I'm forfeiting that bond. I made a mistake when I only gave you a $5,000 bond. Ma'am, I'm going to explain it to you. I gave you a 5,000 10% bond. You know why? Because you told me, as I recall it, you only made about 50,000. Well, that's why I gave 5,000 10%. Because I thought, well, I got to run a sober link. She's had 3 priors. Maybe she'll understand that this judge is a little bit serious, but I still cut you a break. And now you go out and you drink again, and you come in here and tell me what I know are lies. 60,000 10% is the best I'm doing. 60,000 10%. You're going to have to post $6,000 to secure your release. I have a pretrial date. Make sure any warrant that was entered is canceled. And
If you have until tomorrow.
I'm sorry, Mr. Longton.
There's no way.
There's no way in heck I'm letting her out. She scares me.
Listen.
Ma'am,
You're on okay?
ma'am, no, I have made my decision. Listen to me. You are not taking this seriously. You are not. Ma'am, you will not hear me change my mind. I don't decide things over a bowl of Cheerios. I knew if we had a hearing today, you were going to at least have this, because I was sure you were drinking when I talked to you and saw you under oath. You're making your own bed. This is like going to Maui compared to what's going to happen if they turn around and charge you as a felon. I'm telling you, I'm not arguing with you. They'll let you make a couple of calls. I'll move the pretrial date if you want, Mr. Can we do this earlier if she can't post the bond, Miss Heather?
Let me take a look, Judge. The
I'm
Flat
sorry?
Rock case.
Yeah, it's just Flat Rock. I set it for March the 3rd.
Next that we have Flat Rock is next Thursday, the 19th.
I can do the 19th.
Every day in the USA, people find themselves in court.
Let's have the McNeils come up, please. If you'd raise your right hand for me. Swear that testimony in this case will be the truth, whole truth, and nothing but the truth.
I do.
You may have a seat. The Coxes are neighbors.
Correct.
Okay. So what started the issue here? I mean,
I have some more, I haven't updated attachments for that from things that occurred last night after we submitted our evidence.
Just tell me what happened.
So as far as which began or as far as the updated?
Okay, so the Coxes and the McNeils are neighbors.
Yes.
And sounds like shortly after you moved in or after they moved in, I wasn't sure who was there first. There was a disagreement during the Black Lives Matters protests.
That wasn't a disagreement. That was just a situation where we were having a conversation and he was explaining to me his viewpoint on using violence or weapons or firearms to defend himself and anyone that came up against him. So it was said to me to be interpreted so that I would know that he will do whatever means necessary to defend himself.
And why do you think it was directed at you rather than just saying?
When we moved in, there'd been tensions from the beginning. They didn't like our dog. So we chose to give our dog away so that we could be good neighbors and that we could set kind of a precedence. Shortly after, they didn't care for the sound that comes from my shop that's on the property. So they would ask and complain about it being too loud. So that kind of escalated over the years, but was manageable as long as we were willing to meet and speak, and we could usually navigate that. What kind of brought things to a head was they had said that they were going to move their fence further onto our property. And I had told them, I don't like that. It cuts off access to my building. I'd have to cut down 7 of my trees, cut down my expensive gate, metal gate, and that I would be more than happy to help pay for the fence if we keep it where it's been for the last 20 years. So we had come to an agreement where they were going to put removable sections in so that we could have access to the backside of our property. So when they put that section of fence up and did not put in removable sections of fencing, that's when I called a lawyer. So my lawyer at that point said, do not have communication with them. Let's just see how things go. There's another section of fence that we're expecting them to deal with, in which case they will have to cut down our trees and cut down our gate to have access to that, to move the fence line. And so when it came time for them to do that, I did not cut down my trees. I did not move my gate. And so they cut down the trees and cut down the gate. And that's when the harassment really started, with the signs, the cameras, those types of things. It was only over the last 2 weeks that the music has been directed towards our children, where now our children are being harassed. So I don't know what catalyst there is for the last 2 weeks that's instigated this, but I'm assuming that this has to do with us not complying with their request to cut down our trees and move our gate. They, to my knowledge, are unaware that we have a lawyer and that we are working on dealing with the boundary line. I would imagine if they did know that this harassment would only be worse. So I don't know how that's going to play out yet. The lawyer is still looking into, he's going to interview neighbors next week and some stuff like that. So, but in the meantime, we're just really up against the frustrations here. So to harken back to the Black Lives Matter protest, that was just a point in time. I don't have the exact date of when that conversation happened, but that's all that was.
Okay, I was just trying to figure out what this is about. So.
Sorry.
But the dog and...
We do have a timeline of events, Your Honor.
Yeah, I looked through that.
Okay.
Okay, so he has the cameras up and the loud music. Those are the actions they've taken that are your...
The signage as well. The signage is offensive. We don't appreciate that. The other thing that we feel is harassment are the false claims to governing agencies.
Now, both of those things are probably something the court's not going to do anything about.
And that's understandable, but that's what we're bringing to the table. Like, that's what we feel is being harassed.
And have you made loud music complaints to the county?
I called the county, I called Thurston County Sheriff, and they said that we need to file a harassment report. I gave them the details of the situation. I explained the context of what is happening and just how it's very intentional towards our children. And they said the only options that we have is to try to get some kind of an anti-harassment order.
You've lived there 20 years?
We have lived there since 2009. Our lawyer has discovered that fence has been there for roughly 20 years.
Okay. So since you've lived there, has the music been a constant, or does the music show up when things get tense between?
Well, that's only happened over the last 2 weeks.
Okay.
So the music is a brand new development, and it's only now that the weather's getting nicer when our children are outside playing. And so they wait for our children to be there to then play the songs that they're playing.
Gotcha. Having handled a case recently where something similar was going on, the county noise ordinance would, I think, apply between the hours of daylight and 10 p.m. or something. So, or between 10 p.m. and daylight. So that's when quiet is required. Loud music is much harder to regulate prior to that, while people are technically awake and that sort of thing. But your concern necessarily isn't just about the loudness, it's about the lyrics and the impact it has on your children. So yeah, I understand that.
We don't feel that exposing our young kids to that type of sexual content is appropriate.
And have you mentioned that to them? Are you still at the point where you could talk with them, or is that not something you can do now?
So in light of what happened last night, I contacted my lawyer to say, I know that I've been advised not to have communication with them. However, I've already submitted a form to the court. Can I talk to them? Can I ask them to turn off their music? And he said yes, because that harassment issue is a separate issue from the one that he's dealing with. He said, go knock on their door. I explained I couldn't knock on the door because I'm watching my kids. Can I text them? So he said, yeah, text them, see if they reply. So I texted them. They did not reply, but they did turn the music up in volume.
I think you got your answer, huh?
I'm pretty confident.
Yeah, okay.
We have made every attempt to communicate with them one-on-one and have conversation for years. And every time there's been a grievance or a complaint, it's been them coming to us asking to change our actions, which we've complied. We haven't had to, we're not obligated to. But now that we've had the first, hey, this is an offense to us, like we would like to discuss you not taking this action, they have just gone full ballistic. And there's just no ability to have conversation.
Have they made any sort of threats?
They have not made threats saying we are going to kill you, we're going to shoot you. They have not said those, which I know if they had would change things, but
they're just making it obnoxious for you to have them as neighbors.
Incredibly.
And they're your immediate neighbors.
Correct, Your Honor.
They ever come onto your property?
I feel they've come onto our property.
Is that the boundary issue?
Yeah, that's part of the boundary dispute.
Okay. And has an action been filed on that yet?
Not yet. The interviews, our lawyer is interviewing the remaining neighbors, what sounds like next week. And when that's concluded, then we may file.
Has there been a survey of the boundary line?
There has been a survey, yes.
And does it show in favor of the Coxes or in favor of the?
It shows in favor of the Coxes. So one of our approaches, from what I understand, is that he's going to be looking for adverse possession. He believes we meet the requirements of that. We planted trees in that space. We've owned it, or utilized it. Yeah.
All right.
We also rebuilt the fence previously.
All right. So my guess is this will be an ongoing issue going forward.
Yeah, this is not going to be a fun existence.
Okay.
He is a mid to high level manager for Grays Harbor County. So he's used that position to kind of threaten, for lack of a better word, or hold us under his thumb in regards to what we do on our property. So he's done that to other neighbors as well. So we just really feel like we're up against a bully. And we're just, at some point, we kind of have to stand up to a bully.
So one of your complaints is about the cameras that you believe are surveilling you. And they're going to come in and say, no, they're to cover the boundary line of their property, which is, somebody's right to have security cameras. Have they posted videos online that you've seen that show, wait, they're not serving that security purpose. They actually are.
I've been blocked. They've blocked us from their social media. So to my understanding, I don't know.
Okay. So I asked that question so you will realize how difficult that's going to be to address the camera issue.
We installed our cameras after the fact in light of this, and we've installed them at the fence line or lower so that we get full view of our property and none of theirs. And they have 20-foot tall turrets that they can rotate the cameras around to get 360 view. I think they can still observe their property without having to have access to all of us surrounding neighbors' properties.
Okay. That also be a somewhat problematic issue to try to figure out how you set limits on that. As we look at it from I'm not a neighbor, obviously. So, I just have to look at it dispassionately. I'm going to hear two arguments on that. One is it's just their security cameras protecting their property, and yours is no, they're surveilling us as a means of harassment. So I'll have to figure where that line might be. And I can't do that today without them here to hear their side of it. I am convinced that the music is being played as a direct means to harass you based on the timing of it and the nature of it. I'll try to construct something here. So I think what you've told me is it's directed at your children when they're outside.
Those are the only times it's happened, is when shortly after our kids go out to play.
It almost be kind of the reverse of what we typically do, which is say you can't play your loud music at night, but here it's almost like you can play it at night once the kids are in bed, but you can't play it during the day when they're out back.
The loud music, I don't mind if they were having a party, if they were enjoying the music, but it's done intentionally.
I hear
so
what you're saying. So there are decibel levels that I believe, are set forth in the county ordinances. You might be well advised to have somebody come out and measure decibel levels when the loud music is playing, so you have something to present the court. Besides just, you don't like their loud music, and they're going to say it's not all that loud. They listen to it for personal enjoyment, and you're going to put the court in a tough position trying to figure that out. So getting a number on the decibel level would probably be something smart to do.
We do have a video that shows a decibel reading of it at around 60 decibels, which I think we submitted to
I haven't seen the video. I'm just
okay.
And I can't remember where 60 falls on the decibel ordinance.
I think 55 or ish or whatever was the max allowed for Thurston County.
Right. Okay.
But yeah, we can continue to monitor that.
So you have a decibel meter that you use?
Correct.
Okay. Well, then you don't need somebody to come out. You have a decibel meter.
Yeah.
Okay.
When we spoke to Thurston County Sheriff, they said as far as the sound goes, there's really nothing we can do. They said if it's after 10 p.m., we could ask them to stop. But if the music continues and we keep calling Thurston County Sheriff, they're going to continue to say, like, we're just not able to do anything about it. So our only reason for being here is to try to get the intentional harassment to stop. We're not grievances about other nuisances that they've given us. We're just, these intentional things are what we're looking to have dealt with.
Okay, as I said, this is going to be problematic. The limitations I put on them, I will enter a temporary order. Those orders are not to have direct contact with you or your family members. And I've also indicated that they are to control the volume of the music to comply with county noise ordinance. So you are going to want to measure the volume and see if they're exceeding that. As to the content of the music, we have the First Amendment, and that really restricts my ability to say you can't play obscene music when kids are around. So probably nothing the court can do for you in that regard. So my apologies, and then as I'd indicated earlier, we can't, as long as signs aren't on your property, we really can't regulate their expression unless it was threatening. And we can't keep them from calling all the agencies they're calling to come, file complaints with all of them and make them come out and talk to you and find out there's no issue there. The agencies will have to decide not to respond to the Cox's complaints when they keep realizing you haven't done what they've said you've done. So unfortunately, a lot of what you're asking for, court can't step in and regulate. Now, there may be a way of suing them that if they are engaged in harassment, you make it as part of a civil lawsuit. The court can construct something much broader. We're limited here by the anti-harassment statute, so I can't regulate legal activity. Okay, so just so you know.
Okay. Thank you, Your Honor.
If you'll wait outside, I've signed the order. There will be a hearing on the 23rd of February at 9 o'clock. And the Coxes need to be served a copy of this. I think it was, you said the sheriff's office that appears out there, is that right?
Mm-hmm.
So would you like them to do the service?
I believe so, yeah.
Okay. So if you'll wait outside in just a moment, you're going to be given a copy of the service packet, and you can just walk it across the hallway to the sheriff's office.
Thank you, Your Honor.
Great.
You're
Thank
welcome. I hope it quiets down for you.
Yeah.
Thank you.
Yeah.
Every day in the USA, people find themselves in court.
And Robert Leon Weaver.
He wants to talk to you, and I'll talk to him.
I don't, that's not the way it works. Tell me
Explain
that.
it to him.
Okay. Okay, what is it he wants to, Robert?
He is claiming that he should not be revoked off probation because he was never guilty of anything, and that he doesn't understand why. And he has told me he
Oh, boy.
fired me multiple times.
Okay.
About this.
Yeah, this is Edgar Pons.
Oh, he was found competent, I think, but he's not very rational and doesn't seem to. So.
Bring Robert Weaver in, please. Yes, sir. Huh?
So we may need to reevaluate.
It just happened last month.
Oh, then I will shoot a silence to you. You can speak to me
No, this is dated December 3rd.
Yes.
No, we can't be doing monthly evaluations.
I agree, Your Honor.
Come on up. You're Robert Weaver? You're Mr. Weaver? Yeah, I recognize you. Robert Weaver. Here in 24 CR 121, Mr. West is your attorney and the state's attorney here and the probation officer is here. There is a first amended motion to revoke probation that has been filed in your case, Mr. Weaver. And it states. Of habeas corpus information? No, it's a motion to revoke probation. You certainly are, though, experiencing a habeas corpus right now because here you are. Your body is before the court, and that's what that essentially means. You are on probation for 10 years for arson as of May 6th of 2024. And there are 7 allegations of violations, which include committing the offenses of public intoxication, obstruction or retaliation. That's all in May of 2024. One of those is 3 days after you were released. You were placed on probation and released. Within 3 days, you were committing the offense of public intoxication, according to this. And then 8 days later, you were charged with the offense of obstruction. You failed to report to the probation office as directed on May of 2024, which was the day you were placed on probation. You failed to never become intoxicated by being intoxicated. Then there are 2 additional allegations which allege that you committed the offense of assault causing bodily injury on May 2nd, 2025 in Harris County, Texas. And also on that date, you committed the offense of criminal mischief. So if one or more of these allegations of violations have been proven, then by a preponderance of the evidence or greater, your probation can be revoked and you can be sentenced up to 10 years in prison. Do you understand what you're facing here, Mr. Weaver?
I do.
Okay. Mr. West is your attorney here. What are we doing today, Mr. West? Huh?
I do need Mr. West.
He's here if you need him. If you want to represent yourself, is that what you want to do? You can do that.
Of course.
That's not a wise thing to do, but he has been appointed to help you if you need it. Do you understand? He's going to be right here and he's going to be ready, willing, and able. You want to represent yourself? That is your decision. But historically, people who represent themselves fail miserably if they are not familiar with the rules of evidence, the rules of procedure, the rules of the penal code, and have experience and training in this. But you're a grown-up, you're an adult. If you want to represent yourself, you may do that. Is that what you want to do?
Yes, sir.
Then are you making that decision?
If
Don't interrupt me because we both can't speak at the same time, then she can't take it down, but you'll have a chance to be heard fully, okay? And if you want to represent yourself, are you doing that after thinking long and hard about it? And you've had a chance to see, I guess, and talk with Mr. West, haven't you? Yes,
sir.
Okay. And after those discussions, is that what you want to do as an adult, clear-headed, thinking, a competent person? Do you want to represent yourself in this matter?
Yes, sir, Your Honor.
Okay, you will be allowed to do that. Mr. West, though, will be right there if you need to refer and get any help whatsoever. He's your lifeline. He's within 10 feet of you, okay?
I understand.
All right. Do you waive a formal reading of this first amended motion to revoke probation? And can we proceed in a summary fashion?
Yes, Your Honor.
Please raise your right hand. Do you solemnly swear or affirm that any statements you might make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? If you make any statements, will they be the truth?
Yes, sir.
Okay, lower your hand. In summary, sir, this first amended motion to revoke probation alleges that on May 6th, 2024, in this court, you were sentenced by this court, me, to 10 years in prison, and that was suspended. I placed you on regular probation for 10 years for the second-degree felony of arson. Is all of that true?
May I defend myself?
Yeah. Well, is all of that true?
In my own defense, my attorney was fired preceding that trial. I spoke to him briefly in December the 18th, approximately, and I relieved him of his duty.
Maybe this helps your recollection here. I'm going to show you some items that are called written plea admonishments dated March 25th of 2024. And was that Don Dusler?
Yes, sir.
The attorney? Here, look at those. Do you recognize that? Is that your signature?
Don't have my reading glasses. I do not have my reading glasses.
You don't go without them? Here,
Probably.
borrow his. Borrow his.
Mm.
Thank you. Those are reading glasses.
These are not legally binding signatures, Your Honor, because
Do you recognize those as your signature?
Loser actually presented himself and he was dismissed.
Okay.
Is that your signature right there?
Okay, here's what we're going to do. I see where this is. I see where this is headed. We're going to have a hearing on this. Okay. And when are we picking a jury today? We're doing it in the morning. What are we doing this afternoon? Here. What do we have set for this afternoon? Settings. Can we do it this afternoon? I mean, it's set for today. Can we bring him back this afternoon? And can the state be ready to make its presentation? Because
I can do the administrative.
I'm going to
and do the new office.
I understand. I will just enter denials on each of these because I see where we're headed. The court will also note and put into the record that the defendant was evaluated on or about December 3rd of 2025 by Dr. Ed Rapond, licensed psychiatrist, as the court requested that Dr. Rapond evaluate the defendant for competency. The report was prepared and it was placed into the record at a hearing on January 5th of 2026. And the court found, based upon Dr. Rapond's evaluation, that the defendant is competent to proceed to a resolution of his legal issues. And he does have a mood disorder, which is currently being treated and he is stable while taking his medications properly. And
not on my medication.
why not?
I lost it when I was on vacation from May 3rd, 20. 23 or whatever it is.
No, this states as of December 3rd, 2025, this states that you were on medication at this time and it was not, and you were not in need of involuntary psychiatric treatment or intervention. And is aware that your next court date is early January 2026, which we had to postpone. You were able to accurately identify your court-appointed attorney's name, and in your mental state, you were able to follow legal proceedings and would be able to conduct yourself appropriately in a court of law only if you choose to do so, this states. And you do possess sufficient ability to communicate with an attorney, and you have a reasonable degree of rational understanding of the preparation of defense. You have made your decision voluntarily and knowingly, and you are competent to decide whether to represent yourself or not. It's not a wise decision to do that, but you are like competent adults, you are allowed to make your own decision, whether it's a wise one or a poor one. So we will have a hearing this afternoon on this, and just be prepared. I ask the state to be ready to make its presentment. And Mr. West, I'm going to ask you if you'd be so kind to be present, and we're going to do it at 1:30. Yes, sir. Be present. And if he needs any help from you, then he can speak with you. Yes. All right. That is all. Thank you.
That's fair. Thank you.
We'll need to pull that camera on the
Witness.
lawyer's tables.
Do you want the witness camera on?
Have a seat, sir. Thank you. With Mr. West, your attorney, right there. There you go. Thank you. Yeah, right there. Sit.
Oh, no, I'm not sure. I'm just.
That's what you're getting. This is habeas corpus, bringing the body forth. You have been brought forth in front of the court. That's it, to be live and in person.
Accidental fire cannot be malicious.
Okay, I can't hear you.
An accidental fire cannot be malicious or intentional.
I understand.
My affidavit cannot be used to.
Okay. All right. That's not. You're going to get a chance to speak. Court gets to speak though, and I'm kind of the manager of the proceedings so that we can keep it on track. Let me make some announcements here. We are calling cause number 24 CR121, the state of Texas versus Robert Leon Weaver, and you are Mr. Weaver, and you were here with Mr. West, your attorney.
Oh, no. I'm been removed as.
Oh, that's right. That's right. He's going to represent himself.
Yes, yes.
And Mr. West is sitting by. He is there for you to refer to at any time you want. But you, Mr. Weaver, are insisting to represent yourself in this, correct?
If it pleases the court.
All right. It does. I just am concerned about your abilities in handling matters of court that a person who graduated from law school and has experience like Mr. West is able to provide, because even though you are allowed to represent yourself, you still have to follow all the rules that all judges and lawyers have to follow. And that is, in this court, primarily the penal code and the code of criminal procedure and the rules of evidence. And a lot of times people who represent themselves who aren't familiar with those are at a disadvantage. I've talked to you a little bit about that. You've had a chance to think about it. Is it your insistence to continue to wish and represent yourself at this hearing? That's what you want? Correct or not?
Yes, sir.
Okay, at any time you change your mind, Mr. West is right there, on 5 feet from you. You can refer to him or ask him in questions as well if you want some guidance or clarification, because I'm not allowed to be able to help you on this. That's for your lawyers. And the DA's office is not going to help you. He represents the state of Texas, not you. But Mr. West has been appointed to represent you, and you are making this decision to self-represent or represent yourself at this hearing. You're doing this voluntarily and based upon reflection and consideration of it. Is that true? You've thought about it, and this is,
Yes, sir.
okay. Do you need any additional time to think about it?
I do not.
Okay, we'll move forward then. All right, there is a first amended motion to revoke probation, sir, that has been filed. And also, please raise your right hand. At any time you make any statements during this hearing, do you promise that whatever you state will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, lower your hand.
I,
In summary, this first amended motion to revoke probation, it was filed September 3rd of 2025. It states that on May 6th, 2024, in this criminal district court of Jefferson County, Texas, you, Robert Leon Weaver, was sentenced to 10 years in prison, and that was suspended, and you were placed on regular probation for 10 years for the second-degree felony of arson. Is that true or not true?
I disagree.
You disagree? Okay, you can do that, and the state has the obligation to prove. Number one allegation states.
Yes, well, let's take proceeding or only on count three.
Three.
Yes, sir.
Number three, allegation 3 states you failed to report to the Jefferson County Community Supervision and Corrections Department, the probation, in other words, the probation department. It says failed to report since you were placed on probation on May 6th, 2024. You never reported to probation as required by your probation order that the court placed you under and signed based upon your plea of your entry of a plea in this court earlier, and you never reported, and that was since May 6th, 2024, which is over a year and a half. Is that true or untrue?
With my affidavit being used solely to prosecute or.
No, is it true or untrue?
That is untrue.
Okay, that's entered into the record untrue. That's all you need to say. The obligation is on the state of Texas to prove these allegations. And Mr. Laird, on behalf of the District Attorney's Office for Jefferson County, Texas, you may call your witnesses.
Judge, first ask the court to take judicial notice of all the documents in this court file, in this file number.
Yes, sir, it shall.
And I would call Troy Robinson to the stand. So did I ask you to fingerprint someone today?
Yes, sir, you did.
Who did I ask you to fingerprint?
You can see the card.
Was it a Robert Weaver?
That's correct, Robert Weaver.
And you see that individual in the courtroom today?
I do.
And can you describe something he's wearing?
Yeah, a red jumpsuit.
Record reflect he's identified the defendant.
Yes, it will.
So let me show you what's marked as State's Exhibit 1. Do you recognize this?
Yes, I do.
What is that?
This is a fingerprint.
Okay, and what fingerprint card of who?
Robert Weaver.
And is that the Robert Weaver that you just identified in the courtroom today?
It is.
And is that the ink print that you took from Mr. Weaver earlier?
That is correct. It is the ink print that I took earlier today, signed by me on 1/26/26 at 1:30 p.m.
I'll tender State's Exhibit 1, says your fingerprint on it. Any objections?
Is there any objection to that fingerprint card being submitted by the state into evidence, Mr. Weaver? No objection?
Well, yes, sir.
What?
May I address witness?
Briefly?
Okay. And what is the likelihood that you'll be able to run a background check statewide, nationwide, worldwide, without my Texas Department of Transportation number, Texas license number, which is not on the card, correct?
It's not on the card, no.
It's not.
No, it is not.
Is that why you said you were going to take the fingerprint from me so that you could run a background check? True or false?
No.
Anything else?
What is a probability with today's technological advancements that a fingerprint could be impersonated by possibly plastic or an engraving? Is that possible?
Are you asking, can the fingerprint be copied into a plastic or in some type of engraving?
Yes, sir.
Yeah, that's possible.
Anything else?
Nothing else.
Okay, go ahead.
Tender State's 1. This is the same individual who took this fingerprint from yourself, is that correct?
That is correct.
Any objection to that?
May I enter my Texas Department of?
Any objection to it?
Does this have this individual right here you took? Did you ask him for a social security number?
Yes.
And his date of birth?
I did.
And did he also, did he sign this?
That is correct. There is no spot on the fingerprint card for the Texas State CDL number that he is attempting to give me.
Okay, but it does have his social security number on it.
Yes,
So
sir.
he gave you.
Any objection?
Was this?
No, yes, is there an objection or not? What is the objection, sir?
Was it not taken to run a background check?
No, that's, you can't, you can cross-examine him here in a minute, but you have to make an objection. That's why I urge you to, you've got somebody who knows what to do next to you, but you're insisting on representing yourself. When you do that, you have to follow the same rules lawyers are trained to follow. What is your objection? You can't ask him questions. It's an objection you have to make, and then I will rule on it. That's what this is right this moment. Any objection?
That with the ability to falsify these documents, I proved that maybe this should not be entered as a court document.
Okay, is that what you're saying your objection is?
That it is possible that it could be falsified information.
Okay, your objection,
It's adulterated court document.
that's what you're saying your objection is.
That's my objection.
It is overruled. Go ahead. And State's Exhibit 1 is admitted.
Thank you, Judge. Let me show you what's marked as State's Exhibit 2, which the court has already taken judicial notice of. Do you recognize that?
I do.
And did I ask you to take State's Exhibit 2 and compare it to State's Exhibit 1 to see if the State's Exhibit 1 is the same person as State's Exhibit 2?
You did.
And did you compare that?
I did. Yes, so I took the thumbprint from State's Exhibit 1 and compared it to both thumbprints on State's Exhibit 2 and all are identical.
Now, both of these are the right thumbprint, is that correct?
That is correct.
And after comparing these, did you come to the conclusion of whether or not the person in State's Exhibit 2 is the same person as in State's Exhibit 1?
They are the same person.
So the person in State's Exhibit 2, in your opinion, is the same person you identified here in the court today, Robert Leon Weaver?
That is correct.
Go ahead.
I'll pass the witness, Judge.
Okay, the witness is passed, and now you can ask questions, sir, of the witness.
Can I have that in layman's terms, investigator, please, sir, what was just said, please, sir? Will you state that in layman's terms? So that the court and everybody may understand.
We all, the court understands. The court understands.
What the cause 24, 38, 26 was.
At any time, sir, remember, you can ask Mr. West to help you if you are misunderstanding anything, but go ahead, ask him.
The number that you refer to is,
Okay,
yes,
Go.
please state it in layman's terms, so I understand, I don't know every penal code in the book. You know, what that penal code is pertaining to, is it arson?
Hey, John, you want
Am I being charged with another crime?
sir, I do not know what, other crime you'd be charged with. As far as the paperwork that was provided to me, the number represents the cause number that is filed with the court and the district clerk in reference to the case that you previously had.
You're referring to the arson?
Yes, sir.
Okay.
I believe so.
This is, just to clarify, Mr. Weaver, we are talking about the arson case only. The case of arson for which you pleaded guilty, for which you were placed on probation by this court.
Yes, sir.
That's all we're talking about.
Yes, sir.
Okay, go ahead.
Did the people at the scene of the crime wish to press charges on the defendant, Mr. Robert Weaver, for arson?
I object, Your Honor, that's,
At the scene of the crime.
it's not relevant to this hearing, so.
Sir, that
And this investigator was not a part of that investigation.
the objection is sustained. Sir, this was, once again, this
Yeah.
case was disposed of, for the record. The court's got to complete the record so that it is clear. You entered pleas of guilty to the indicted case, second-degree felony of arson. And that was all on March 25th of 2024. And the court, in those pleadings, you waived a trial and entered a plea voluntarily, knowingly, and intelligently pleading guilty to the charge, the second-degree felony of arson, as indicted in this case as of January 24th, 2024 by the Jefferson County Grand Jury.
Yes, sir.
You entered a plea of guilty to that. The court found, like in most cases disposed of in this court, they're through agreed pleas of guilty, that you had through your attorney made an agreement with the state that you would be pleading guilty, sentenced to 10 years imprisonment. That imprisonment would be suspended. You would be placed on regular probation for a period of 10 years. And restitution was to be paid as a part of the probation order. All of that was entered into on March. These were documents that were signed on March 25th, 2024. Those were entered into the record when you pleaded guilty on May 6th of 2024. The court followed the recommendation and your agreement that you entered into with the state through your attorney and found you guilty beyond a reasonable doubt, sentenced you to 10 years in prison, but suspended that sentence and placed you on regular probation for 10 years. Thereafter, a motion to revoke probation was filed in this case on February 6th of last year, and among other, and it was later amended on September 3rd of 25 to allege two additional allegations of crimes, but we are only taking up in this hearing what was presented in the original motion to revoke probation, number 3, failing to report to the probation office since being placed on probation on May 6th of 2024, in violation of condition 4 of your probation order, which required you to report regularly. That's all we are dealing with, just that issue. Okay. With that in mind, go forward. You can ask a question.
Do any of those signatures match the signature that you have, Detective, today?
Do you understand that question?
Do
What do you mean?
the signatures on any of those documents would light being shed on the subject of personation or this, if we present to the detective those documents to see if my signature, not legally binding signature, matches the ones that you have on any of those documents. Your Honor, if it pleases the court.
So I have no knowledge of anything of the case other than the scope of which I was asked is the comparative fingerprints.
Compare the fingerprint.
That is the only knowledge I have of your case.
Can you compare the signatures?
I was not asked to do that, and I did not do that.
Would you please do that for the court? If it honors, if it pleases the court, Your Honor.
I am not a handwriting expert.
But you would be able to take a legally binding signature that you have and compare it to those. If you're comparing fingerprints, obvious. There are some discrepancies in this case, which as I.
What's your question? This isn't the time to make a final argument. What's your question to it?
Your Honor, can you present those documents to see if a fingerprint expert, detective, could compare those signatures with my legally binding signature to see if they match?
You mean the signatures when you entered your pleas of guilty?
Yes, sir.
That would be irrelevant. The court made its findings based upon your representations, your attorney's representations, that you had entered your plea voluntarily, knowingly, intelligently. And the court made its findings that you were the person who was pleading guilty, who was entering his plea and accepting responsibility. That was enough to find you guilty by law beyond a reasonable doubt.
Yes, Your Honor, I understand that fully.
Okay. Then
But
you're the same person who was placed on probation. Now, the issue is, why didn't you, the person who was placed on probation in this case, report as directed to the probation office as the court ordered you, as it is alleged you never reported from the outset? That's the issue.
Okay, yes, sir. I was not on my correct medications because I was driven away at gunpoint from not only City Hall, where I may have gotten identification, or Baptist Hospital, or Genoa Spindletop on Washington 8 near the scene of the crime.
Okay. All right, just ask him some questions. If you want to take the stand and testify, you can do that here in a minute, but this is just the time to ask him any questions that you may want concerning what this witness had his involvement in. And it was just for fingerprint
comparison only, Judge.
For the matters that he's testified to. Did you have any other questions for him?
We do agree, though, that that can be an engraving and it can be impersonated and possibly applied as false document in this case. It can, correct? And
Are you able to answer that?
No, sir.
He doesn't understand.
he already answered that.
Okay. Anything else from this man?
No, Your Honor.
No, Your Honor.
All right, you are excused, sir.
Thanks, sir.
Judge, I would like to call Mr. Robert Leon, the defendant in this case.
Come on up and take a seat.
Testify on his own.
Take a seat right here, sir. Thank you. How much time does he have credited?
I can undergo cross-examination today. Other witnesses.
Have a seat, please. All right. what we're gonna need to do is pull that chair closer to the microphone because we know the microphone, unless you're speaking close to it, it doesn't pick up your voice. You don't want to be uncomfortable, but, okay, that should be good.
Okay.
All right, and you can't, obviously, it's very awkward to ask yourself questions. You may make a presentation of what you want to put into the record on your behalf relevant in this case. Go ahead.
Yes, sir. I'm from Dallas, Texas, and apparently I had lost my medication. On vacation to New Orleans, passing through on the Greyhound bus back to Dallas. I was wrong, so I did not have my medication. I went to City Hall,
Which city hall?
Beaumont,
Oh, okay.
and tried to register myself. And I was driven away at gunpoint by a police force in Beaumont. While looking for occupational job, I was looking for a job. I was asked to leave churches, restaurants. Somehow, my personal information had been made public, although my probation officer does not know that I'm over 21 or things. And she does not know that I have lost my medication. I was driven away from the hospital. I'll get my prescription filled at Walgreens. Taking a victim stance, Your Honor, I was a victim in this case. And the fire was accidental. Even though my constitutional right to life, liberty, and happiness in the pursuit thereof was infringed upon, I was in fear for my life, sir. My welfare check was stolen. My food stamps card was stolen. My health benefits were stolen. I had no right to know would not offer me any help. I could not return to Dallas. There was nothing I could do. And became bitter cold in the tropics, ranging from 109 degrees to -90 degrees Fahrenheit. And I was in fear for my life.
At what point in time? What date are we talking about?
Between the dates.
You mean when this crime was committed? When this fire occurred? Is that what you're talking about?
On May 3rd, in 2023, when I had my disability check shut off and I took vacation money to New Orleans. The Big Easy Show, called it. And I lost my medication somehow. Yeah. And I came to Beaumont, went to City Hall, went to the hospital, was admitted in the psychiatric and family was gone, I believe. I stayed there for several weeks. As far as the arson and the conviction, it would have been a tragedy in my life, a tragedy for me to die at such a young age with actually no legitimate health risk because of hypothermia that would have been a tragedy to my family. And my friend, I have 50 nieces and nephews, 5 brothers and sisters. And my dad is still alive. They're both veterans. My classmates were all saluted forward, my class president. I tried to walk away, and I walked all the way to Houston, 4510 interchange. And brought back to Jackson County.
Go ahead.
I don't believe that I would be able to survive in the jail. I've never been to prison or state jail, only county jail. And this is, the order for deputy custody and body back
You have,
from here tonight.
you have a copy of my staff report.
I didn't hear it, county jail. You gotta go.
Oh, thank you. Go ahead. I'm listening to you. I'm reviewing the the post-sentence report that was prepared by the probation office at the court's request right after you were placed on probation. Go ahead.
I was never given sobriety, field sobriety test. Most of those are misdemeanors that are your probation violations, Your Honor. Most of them, actually, to be fair, all of them actually could be concerning my criminal record. I don't have any aggravated cases, Your Honor.
Say it again.
I do not have any aggravated cases that I've been convicted of in my 50s, almost 51 years on this earth.
I'm looking at the post-sentence report. It states that you were in 2005, you were sentenced to 120 days in jail for assault on a public servant in Dallas County. Then in 2011, you were placed on 2 years deferred or unadjudicated probation in Dallas County for delivery of a controlled substance. Then in 2018, you were placed on 3 years deferred or unadjudicated probation for assault on a public servant in Dallas County, Texas. And these are all felony offenses.
Yes, sir.
Then also, let me finish. On August 27th, 2018, you were also placed on 3 years deferred or unadjudicated probation for attempting to take a weapon from a police officer in Dallas County, Texas. And in this case, so you have been placed on probation. Then you were on 2 years deferred or unadjudicated for probation for delivery of a controlled substance, 3 years deferred or unadjudicated probation for assault on a public servant, 3 years deferred or unadjudicated probation for attempting to take a weapon from a peace officer. And then this case is a final conviction where you were sentenced to 10 years in prison and that was suspended and you were placed on regular probation.
Yes, sir.
And then I'm looking at your adult, I'm not putting it into the record. In your misdemeanor, I'm looking at 11 separate misdemeanor convictions where you were sentenced to jail time since 1996 through 2018. And these were included convictions: violation of a protective order out of Dallas County, violation of a protective order in Dallas County, evading arrest or detention in Dallas County, driving while license invalid in Dallas County, criminal mischief, Dallas County, and illegal possession of marijuana, Dallas County.
obstructing or resisting an executive officer out of Sacramento County, California. And in that case, you were sentenced to 204 days jail and placed on 3 years probation. Also, on that same date in Sacramento County, in 2016, you received a similar sentence for obstruction or resisting an executive officer. Then shoplifting in Denver County, Colorado, 3 days jail, 12 months probation. Assault out of Denver County, where you received 85 days jail in 2017, and assault family violence, 150 days jail out of Dallas County in 2018. So that one's 11 misdemeanor convictions, along with 5 felony dispositions, which include this regular probation of arson. That's your criminal history. That was part of the post-sentence report that was made in this case and by the probation office, and is part of the file here.
Yes, sir.
Go ahead.
Dallas County Jail, Lewiston County Jail, and Frank County Court Building has ruled that there is a conspiracy against my life by the drug cartel and other people. Some of the times, these officers did not speak English and were not citizens of our country. Other times, like the 2 protective orders, I was not aware that my ex-girlfriend had.
Wait, hold on. On that first part, where there's threats to your life, what documentation do you have to support that?
No, the conspiracy.
Oh, okay.
It's in Texas Department of Corrections.
Okay. Is this how much?
Yeah. I don't care the phone
Yes, sir.
that the drug cartel has a conspiracy. The drug case was what? Under a gram of cocaine. I sat for 2 years because they would not hear my case in court. I sat for 2 years on a case.
Sometimes that can happen in those big counties.
Yes, sir. The violation of protective order. I did 8 days for misdemeanor offenses. Both of them in total. 8 days in county jail. As far as the attempt to remove a firearm from an officer, he pulled a gun on me when I was in a restaurant. He asked me to leave. I said, yes, sir. I hadn't eaten that day. I simply went there to eat. I was in the bathroom. He did not speak English, so I asked him to put his gun down. Well, and he tased me anyway. So when the blue and white showed up, as I was leaving, he tased me while I was leaving the store. Blue and white showed up. And the taser was under my body there, inside of the restaurant. So I did approximately 4 years on that one. Or I'm not sure. And then that was the Trump administration. I've never been convicted of theft in Denver County. You check Denver, Colorado. Or was it Pikes Peak Nuclear Facility? Once again, there are falsifications in these court documents. I'd like to just have this blown to the wind so I can go home. The Texas Department of Corrections will keep its promises, give me a safe place to stay, and clean clothes, and clean food and water that will sustain me. I lost 120 pounds in your care over the past approximately 3 years.
You've been in jail 447 days, sir. That's just a little over a year.
From approximately December the 9th of 2023 Or we'll say, when I left home from Dallas, I've been away from my home. I'm a domestic homemaker. Do a lot of walking through a walk all the way to 45, 10 interchange and have Jefferson County come get me up. It seems to look pretentious that an accidental fire could cause me to lose not only an eye, a wisdom tooth, under the care of your doctors. I've never been to prison on all those cases were self-defense cases. I do understand spoken English, and if English had been the spoken language in the United States of America or said area of what is this place called again? In Beaumont, Texas, where they had a city jail. No, in Jefferson County, Texas. Across county line.
Anything else?
I would like to grant my guilty plea. On my guilty plea, I would like to be kicked.
I think that's a little late. It's in the record. And you were under oath and you made your representations under oath. If you want to recant, then the state may consider perjury charges because I found that you were competent and that you understood the proceedings and you made statements that all of this is true, so help you God. Are you saying that they weren't true?
I was off my medication.
Are you saying they weren't true?
I'm just saying that I was off my medication.
Now, are you saying they weren't true?
I'm not saying that I didn't think they were true to the best of my knowledge at said time. Or that maybe prudent to be agreeable. I'm very sorry that there was a fire. Or that I'm here in Beaumont off the bus and I didn't make it home. I'm sorry, I am. I'm very apologetic and sorry for this whole the mess with paperwork that work through. I did live in California. Sacramento, Hawaii, Denver, and Aspen, and Seattle, and near Cleveland, near Cincinnati, near Toledo. And been here one time. Got full climate. So I was in fit for my life, and I'm still in fit for my life. I also am in fit for my life.
Anything else you would like to add, sir?
Do you have any questions? Because if we could say that, could we get in contact with Harris County and see what Judge O said about me, about my 90 days? Because I'm a 90-day order protective custody psychiatric evaluation at a local or North Texas. Okay. And I don't think me walking along the beaches in Sacramento, my disability section, I was saying, over 23 years, equals $23,000, which you're asking me to give you my life saving on accidental fire. If that's all it would be, it's the penalty something else, I'm going to.
Anything else you want to add, sir?
What can I do to please the courts?
You're not negotiating with me, sir. I make findings and the court will make rulings under law. for what the court has the authority to do, but I can't bargain, I'm not bargaining with you. That's not for me to do, sir. I will make findings and rulings of law. Is there anything else? Do you want to ask Mr. West anything more?
Well, I want to let you know that my affidavit was paraphrased and it should not be used as a sole prosecutor's device to convict me. Thank you.
Okay, anything else? You may be seated, sir. Thank you. The court, is there anything else from the defense or the state? Nothing further? Nothing further? Mr. Weaver, anything further?
Yes, sir. I was impersonated poorly.
You were what?
Impersonated poorly in some of these findings against me. Some of those criminal convictions were people impersonating me poorly, Your Honor.
Anything else?
I am a psychiatric patient who deserves to be given an opportunity to go to a psychiatric hospital, as was a doctor's order, doctor of law, and a doctor of law, Your Honor.
Anything else?
No.
No? All right, and so the court made its findings based upon what was presented at the time of the entry of the plea, that the defendant was mentally competent to enter his guilty plea. He did understand and appreciate the consequences of pleading guilty. There was sufficient evidence supporting his guilty plea to find him guilty beyond a reasonable doubt, and I found him guilty beyond a reasonable doubt of the second-degree felony of arson and sentenced him under the agreement to confinement in the institutional division of the Texas Department of Criminal Justice for a term of 10 years. That was suspended. He was placed on regular probation for 10 years. Among other conditions of probation, such as reporting regularly that he failed to do from the outset of probation, he was ordered to pay restitution, $1,675.
Yes, sir. Our paperwork is.
For the burning of a vehicle?
Yes, sir.
Okay, I guess it wasn't totally burned. I guess.
It wasn't much of a vehicle.
And it wasn't much of a vehicle, according to the state. All right. What is the state summarizing and asking here?
Judge, here's the problem with Mr. Weaver is that he's not going to comply with probation. It's apparent. I mean, he's had opportunities, had probations before, but this time he's decided not to. He's a danger. If he gets out there to himself or others, I think he could end up either hurting himself or hurting somebody else because of his priors with combative nature of police. We'd ask the court, we don't want to place him in the penitentiary for a long time, but we would ask for 3 years in prison. I think that's fair. I don't think he's going to come back and comply. And I think that will also give him an opportunity while he's there. They do have mental facilities that they can place him in, and they would have plenty of time to work with him and make sure they get him straightened out before he gets back out on the street.
Did you want to add anything to the record here, Mr. Weaver?
I'm very sorry that this accident happened, Your Honor, and any harm that I've caused. I apologize profusely and thank you, Your Honor. Thank you.
If nothing further, I'm going to find that there is sufficient evidence supporting this first amended motion to revoke probation, to grant it by a preponderance of the evidence or greater. This motion to revoke probation
first amended motion to revoke probation filed September 3rd, 2025 is granted by a preponderance of the evidence or greater. Court has revoked your probation of 10 years in this case, and you were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years, and restitution will be ordered. I have restitution in the amount of $1,675. That will be ordered, and hopefully you can somehow do something to pay that back. Do your best to fix this. The sentence of 3 years is what this court finds is fair and appropriate under the circumstances of this case. Do you understand what has happened today, sir?
Yes, sir.
And again, you will be given credit for the 447 days that you have already served in connection with this case. Anything else?
Yeah.
If not, we are in recess. Thank you.
Yes.